So we're on the record in docket 23-00380, the people of the state of Michigan versus Eugene Cornell Melvin. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Aaron Robinson, Assistant Public Defender for Mr. Melvin Cornell.
All right, and this is the time set for a jury trial today. You're scheduled for 8 o'clock. It's now 8:24. Mr. Brodowitz, your witnesses are here and everybody's been subpoenaed. Is that correct?
Yes, Your Honor.
All right. Ms. Robinson, is Mr. Cornell, to the best of your knowledge, is Mr. Cornell present today?
I have not seen him yet today.
All right. So with that understanding, I'm going to enter a bench warrant. Defendant failed to appear, and a bench warrant and bond forfeiture. I don't know. Let me see if this is an assault of crime or not.
I believe it is, Your Honor. It's an assault.
A and B. All right. So defendant for failed to appear there's a bench warrant and bond forfeiture issued in regards to 23-00380. Anything else for the record in that docket, Mr. Brodowitz?
Nothing from the people, Your Honor.
Ms. Robinson?
No, Your Honor.
And then we have Ms. Austin Morrison's. My understanding is there is a jury trial scheduled for today, and we are proceeding on that. So we're calling in a jury on that. Is that correct?
Yes, Your Honor.
All right, Ms. Robinson, that's correct also, right?
Yep.
Okay. And so I will, I think we had the jury instructions from last time already set, but I'll go through and check for pronouns, etc. Okay. So so that's all for the record on that file. Anything else ready to go in regards to, we're probably 4 minutes away from the 8:30s, Mr. Brodowitz.
Yeah, I know I have one victim here. I have not called the hallway yet for other victims.
Okay.
Let's see. As far as I know.
And they've got till 8:45. Everybody's got 15 minutes.
I believe that might be Samsung.
Yeah, Mr. Conrad's on the Samsung.
Yeah, I can speak with him as well, Your Honor.
All right.
He's still unrepresented.
So if you wanted to, let me grab those. So if you want to talk to him.
So sturdy. Yeah, that would have been.
All right, let's hold off on that.
Doyce.
So. All right, Mr. Conrad, the assistant prosecutor is going to join us, and then I'm going to put you in a breakout room with him, okay? Mr. Burnett, are you ready on your LAFQ case?
Yes, I am, Your Honor.
All right, we're on the record in docket 16-04347. That's LAFQ versus Nurani Musa. Will the parties please introduce themselves for the record?
Yes, good morning, Your Honor. My name is Joe Burnett. I'm filling in for Tim Smith on behalf of LAFQ.
And sir, you are Nurani Musa?
That is correct, sir.
All right. This is the time set for a discovery. I have it as a discovery hearing. Is that what you're covering for, Mr. Burnett?
Yes, Your Honor.
So is that would you like the opportunity to meet with Mr. Moose in a breakout room to ask any questions concerning discovery or discuss any discovery issues?
Yeah, I think that would be perfect. Yes.
All right, Mr. Musa, I'm going to place you in a breakout room with Mr. Burnett, and he's going to have some questions for you concerning discoveries issue. I'm going to swear you in first so that you're under oath as he asks those questions. All right.
Yes, sir.
Mr. Musa?
Yeah.
All right, please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Huh? Excuse me?
Mr. Musa?
Yes, I do.
Okay. All right. I'm going to have Mr. Musa and Mr. Burnett placed in a breakout room, and then we'll come back and put that on the record. Okay, sir? So you'll join room 1. You should get a prompt.
He got back on the elevator for some reason, went back downstairs to security.
Yeah, ma'am, I'm going to have you to lower your voice since we have discovery. We have a proceeding on.
Yeah, so I have had some,
Did you have the opportunity to speak with Mr. Conrad?
not yet.
Sir, on the Samsung, would you please identify yourself? Mr. Conrad, yeah, I recognize you. The other individual on the cell phone, sir, would you identify yourself?
Roderick Washington.
Okay, Mr. Washington. You're here for your 8:30?
Yes, sir.
All right, stand by. We've got some cases to call in front of you, okay?
You're right.
Okay, that's fine.
I'm gonna go out in the hallway, join, and then.
All right, we'll put you in a room with Mr. Conrad.
Okay, yeah.
All right. So Brodowitz and Conrad.
Yeah, she said.
Probably can hear him through the walls. That's-
Yeah, see.
Let's checking on that. Can attend by Zoom. He's fine. No, it's Brodowitz and Conrad, not Brodowitz and Washington.
Oh, yeah.
Put Conrad and Washington together.
I'm sure that's a lively discussion.
That's the same Roderick Washington. I'm thinking of that as
Right, that's
way.
a lively discussion. Meanwhile, Mr. Brodowitz is sitting.
Sure, I'll
Yeah.
reduce your case.
Mr. Washington, stand by and we'll call your case in a minute, okay?
Okay, I'm sorry. Was I supposed to accept the court?
No, you're good. We put you in the wrong breakout room, and so you're right where you're supposed to be.
Okay.
Thank you.
using the device audio. My goodness. So many things happening, leading to a blank screen.
All right, so we're on the record in docket 23-723, 724, 725, 726, and 727. That's people in the state of Michigan versus Douglas Conrad. Will the parties please introduce themselves for the record?
Jeff Reynolds on behalf of the people, Your Honor.
And sir, you are Douglas Conrad?
Yes, sir.
All right. This is the time set for a final pretrial in the matter. Mr. Brodowitz, how are we proceeding today?
Yes, Your Honor. At this time, I have seen proof from Mr. Conrad that he has had, I believe actually it was 4 dogs. There was a mistake with one of them, but I have seen the licenses for all 5 dogs that were listed on the ticket. So at this point, the people would move to dismiss for compliance.
All right. So the people of the state of Michigan moved to dismiss without prejudice for compliance. That means, Mr. Conrad, that they could reissue if they choose to. Realistically, they will not. And your cases are done for today's purpose. All right, sir?
Thank you.
All right. So you're all set, Mr. Conrad. Thank you for your appearance today.
Thank you, sir. Good day.
You too. All right. Let me write all that down.
All right. They're saying it's done, babe. I don't know how to get
You're
out.
all
of it.
set, Mr. Conrad. Thank you. All right, we're on the record docket 2203-220, and sir, you are Roderick Washington, sir?
Yes, I am.
All right. This is the time set for a final pretrial. Mr. Brodowitz, how are we proceeding?
Yes, Your Honor, at this, as you stated, today's the date and time set for final pretrial. The people's witness did appear at the last final pretrial, but I guess there were some discovery issues between my office and the public defenders, which I believe have now been corrected. However, I believe the court also at that last final pretrial excused the witness's absence.
They did.
However, I did have phone contact with the witness yesterday as well, just to confirm that. So at this time, the people would be ready to proceed. We have made an offer for the defendant to plead to count 2 domestic violence with 76948 if eligible, and then dismiss count 1 with restitution.
All right, Ms. Sutter, how are we proceeding today?
Thank you, Your Honor. We did receive the discovery, it looks like Friday morning, finally. So I did speak with Mr. Washington. And at this time, Mr. Washington would like to proceed to a jury trial.
All right, so we'll proceed to jury trial. The jury trial is set on May 23rd at 8 a.m. So Mr. Washington, the date for jury trial is May 23rd at 8 a.m. So you should be here before 8 a.m. on the 6th floor in the city of Lansing. And then we'll proceed to jury trial. All right, sir?
All right.
Right, that's live in person, so you'll be here on the 6th floor. Anything else for the record in docket 2203-220, Mr. Brodowitz?
Nothing from the people.
All
Your
right,
Honor.
and we will take jury instructions a week before then for both parties, for Mr. Brodowitz and Ms. Sutter, but you know that. So I'm just reiterating what you already know. Anything else for the record of Ms. Sutter?
Just to note, I did receive the discovery Friday morning. However, it is non-compliance with Ricky Jack. So I may be filing a motion to compel for an unredacted police report as the public defender's office is entitled to it.
All right. So do you plan on filing the motion, or?
I do.
Okay. All right. So we'll entertain that when we get to the motion date.
Thank you.
And then we'll do it. We should hear that sometime prior to the 2 weeks of jury trial. All right. So that's all for the record docket 2203-220. Mr. Washington, please keep in contact with your public defender, Lauren Sutter, and we will see you on that date, which is May 23rd.
Okay.
Okay, what time?
May 23rd at 8 a.m.
8 a.m. All right.
Yeah. So be here before 8 a.m. This is compelled. This might be the first.
That's the motion that's not next.
Okay.
Yeah.
All right.
So that motion is set for the 16th, and I said,
All right.
we couldn't get to the executive.
Just 1 minute.
Yeah, I think we're gonna go. Let me do the civil case, and then we'll.
Okay.
If Ms. Robinson's ready, we'll go on the AG case.
What about Ms. Kernan?
Oh. I don't know if Ms. Sutter, is Ms. Green yours or Ms. Robinson?
That's Ms. Robinson.
All right.
Oddly enough.
Am I good to leave?
Out of. Yes, Mr.
You are
Washington.
too. You're good to leave, Mr. Washington. Thank you. Ms. Robinson, who did you want to be put in a breakout room with? Okay. And then, Mr. Burnett, are you back on the civil case of 16-4347?
Yes, Your Honor, Laffey versus Mr. Musa.
All right. Did you have the opportunity to speak to Mr. Musa in a breakout room?
Yes, I did, Your Honor. We had a good discussion. Mr. Musa has agreed to a payment plan, whereas he will pay $200 a month beginning June 1st. He's also agreed to, pursuant to the subpoena, send us his last 6 months of bank statements, his last 4 pay stubs, copies of his vehicle title and vehicle registration, and then his most recent tax return. At this time, I think we would just like to request of the court a control date, perhaps 30 days out, to give Mr. Musa some time to get us those documents and to make that first payment.
All right. So I would assume the control date would be after June 1st.
Yes, Your Honor, if that's acceptable to the court.
Yeah, I think so. So set it sometime in 6 weeks. Six to 8. What's that? Just a, yeah, just a pretrial, just to discuss, like a pretrial, a discovery, a civil pretrial. We'll just set it for a civil pretrial at this point and use it as control date.
Okay,
June 26th.
So we'll set it for June 26th at 8:30.
okay, thank you, Your Honor. I told Mr. Musa that if we got the documents and the payment, we would call and cancel the court date. So he's at least aware of that part of it.
All right, all right. And Mr. Musa, do you have any questions of me concerning what happened today?
No, Your Honor.
All right, we set the control date for June 26th at 8:30, and if everything goes well, you may, Mr. Burnett will be in touch with you whether we actually need that date or not. All right, sir?
Yes, sir.
All right. Anything else for the record? Docket 1604347. Mr. Burnett?
That is all, Your Honor. Thank you.
All right, thank you. Mr. Musa, you're all set. Thank you for your appearance today.
Thank you, Your Honor. Thank you, Mr. Burnett.
Thank me. Ma'am, what's your name? Davis. Are you a witness today or are you?
No, I'm here for free trial, my third free trial. I'm assuming it's the final free trial.
It is the final pretrial today. All right, let's wait for Miss Robinson and then we have Miss Green too, right?
Just thinking about oh, visqueen or whatever you call it. What?
I do not see Mr. Green on the Zoom courtroom. There's nobody in the physical courtroom by the name of Casey Green. I would indicate that it was scheduled for 8:30. It is now 9:14. It would appear the defendant failed to appear. Mr. Brodowitz, how would you like to proceed?
Being as the defendant failed to appear, Your Honor, the people would ask that a bench warrant be issued and any bond be forfeited.
Mr. Robinson, any comment?
No, Your Honor.
All right. It is a domestic assault case, so the bench warrant is issued and bond forfeited in regards to Mr. Green at the final pretrial for failure to appear. Anything else for the record, docket 22-01134, Mr. Brodowitz?
Nothing from the people, Your Honor.
Ms. Robinson?
No, Your Honor, thank you.
Thank you. That's all for the record in that file. And then we'll take a short adjournment and talk about the Davis case. So court will take about a 5-10 minute adjournment and get back on the record.
Mr. Blakely? Mr. Blakely?
Can't hear you. Never mind.
Hello?
Mr. Sheehan, what case are you here for?
I'm not sure. I lost my paperwork. Sorry.
What judge are you supposed to be seeing?
I think Tony Flores is what I'm thinking, but I've had difficulty getting information out of the system, kind of. I'm just not too familiar. Can you hear me all right?
I can hear you just fine. I'm just trying to find what case you're here for.
Okay, I'm here. This says Mr. Blackney. I'm not Mr. Blackney.
I'm sending a message to somebody else that's also in the Zoom with you.
Oh, okay.
You are supposed to be meeting with the magistrate this morning to be arraigned.
That's what I heard.
This is not the magistrate.
Oh, what is it? Okay.
This is Judge Flores.
Okay, so I can't do what I have to do over Zoom is what you're telling me?
You can, but you need to zoom in with the magistrate. You can't zoom in with Judge Flores.
Okay, and do you have like a meeting number or something?
One second, let me try to locate that for you.
Okay, I'll be here.
Yes, because basically, his argument is basically because the government shut down and the shelter was told to stay with their dogs or as far as I can understand his argument.
Here's the thing, it's a little nutty, but unfortunately, it's probably.
Oh, yeah, I don't think he's ever gonna win on anything like that, but I'm like, okay.
Like, you're kind of right, though.
It's a unique one.
No.
One that he said, someone's got to like, attorney about that. I work with the state. I can't. Yeah, I can't sue the state. I can't sue them. So nobody, I don't think anybody, neither you guys represent Mr. Plea.
Yeah, like, I could not find an application or office for him or for Daylon Trusso. Just nothing in our system.
All right, and then what about Mr. Curtis?
That's Aaron's.
Okay. Because he's represented on one, not represented on the other.
So then will you offer an attempt?
File a petition.
I can't. That one I don't know. I highlighted both for her because it's like previously other, but I'll be honest.
I didn't really offer it. I could maybe.
Okay.
They might.
So
She doesn't want to take it today.
but they are hurt. She is better than ours. I'm gonna go to that.
Oh, sorry.
See if we can set it for a file for trial stage 4 file.
Right.
I can try to work on it.
Or we could just leave it set for trial and not do it.
Yeah.
She's.
All right, Mr. Sheehan,
Yes.
that number is 216 101 7816.
Okay, 216-101, and then what?
7816.
7816. 216-101-7816.
Yes.
Thanks. I'll get over there. Okay.
(22-00872). People of the state of Michigan versus Lisa Ann Cripe.
1 second here. Sorry.
Okay.
Or- Stuff. I asked him what he's got again, Joe.
Yeah, that's Mr. Sheehan.
He's supposed to be with the magistrate. I just gave him their information. It's wrong.
Okay, sorry, Your Honor.
All right, so we're on the record docket 22-00872. That's people of the state of Michigan versus Lisa A. Cripe. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Ms. Cripe today, who is joining us via Zoom.
And ma'am, you are Lisa Cripe.
Yes,
All right, this is the time set for a pretrial in the matter. Ms. Cripe, Mr. Brodowitz, how are we proceeding?
Yes, Your Honor. At this time, as you stated, today's date and time set for pre-trial. I have seen proof that I believe the dog in question has or is deceased. So at this time, the people would seek to dismiss for compliance.
No objection.
All right. So, Ms. Cripe, you understand that the people have received information that the dog in question, Cusco, is deceased, and therefore they're not moving forward on the case. If there is a question as to that, this case may be reissued because it's dismissed without prejudice. But for our purposes today, the case is dismissed. Do you understand that, ma'am?
yes, I do.
Mr. Brodowitz, did you have anything that you wanted to add?
Nothing, Your Honor.
All right, Ms. Sutter?
Nothing further.
All right, so case is dismissed without prejudice. That's all for the record docket 22-00872.
Thank you.
You're all set, Ms. Cripe. Thank you.
Thank you.
I'll just do a quick check-in. Mr. Eisenman is here. Have any of us received updated anything for him?
It's in the file, just they didn't email it.
Okay.
So,
Would you mind if I borrowed your file?
yes.
Thank you.
You can borrow our file. So this is,
May I approach?
yes,
Thank you.
this is the update.
Yeah. Thank you.
Okay. But I'll give you both and then you can talk to him
Thank you.
and
Appreciate
we
it.
can decide. And that was like for this morning.
Gotcha.
That last-
Yeah.
Burning midnight hours of the.
Well,
midnight hours.
that's when it came through that
Ah,
he'd been arrested while he was on probation, which changed the recommendation.
okay.
So, but
She's just gonna give you today.
he's tough day. Mr. Have you talked to Mr.
I
Blackney?
have not yet.
Did you want to talk to Mr. Blackney?
Yes, Your Honor.
Well, you can go talk to Mr. Blackney. Ms. Robinson, are you ready on Miss
Davis, yes.
Davis? All right. So Mr. Blakeney, that's the assistant prosecutor is going to join and we're going to place you in a breakout room with him. All right.
I'm sorry,
Okay.
Your Honor.
All right. And what we're going to go forward on a different case. So we're on the record in we're on the record in docket 22-01168. That is people of the state of Michigan versus Tabitha Davis. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Assistant Attorney General Philip Jack.
Karen Robinson, Assistant Public Defender for Ms. Davis, who's standing to my right.
Ma'am, you are Tabitha Davis?
Yes, sir.
All right, this is the time set for a final pretrial in the matter. I know that we've had some indication in chambers as to how the court looks at this in regards to a Cobb's hearing. I don't have a problem with indicating for the record that initially I've indicated that I was not amenable to fines and costs in this matter. That the people, it's my understanding that they were not seeking immediate jail time as upfront. And so, but I am looking for a referral to probation and some probationary time in regard to drinking in this matter. Mr. Jacques, is that your understanding of the conversation that took place?
Yes, Your Honor.
Ms. Robinson?
Yes, I believe you said 4 months with drops and no drinking.
Right.
Okay.
It was basically it was a probationary measure to make sure that I know that the Miss Davis is not drinking throughout her probation. Okay. So Ms. Robinson, how are we proceeding today?
She's going to be pleading, Your Honor.
All right. And that's a plea to the charge, Ms.
Yes,
Robinson?
it is.
And all right. And that's your understanding, Mr. Jacques?
Yes, Your Honor.
Okay. So may I inquire of your client of her advice of rights?
You may.
Ms. Robinson. All right. Ms. Davis, you understand that the maximum penalty in this case is 6 months and or $1,000. I have indicated that I'm looking for probation in this case. So at least during the cops conversation, I'm only looking for probation. I would not be sentencing you to immediate jail.
Okay.
With the understanding, yes, I've talked to the Assistant Attorney General in this matter and Ms. Robinson and right. And so if I follow that agreement, if I violate that cops agreement, like something comes out of nowhere from probation,
Okay.
I would give you the opportunity to withdraw your plea. Okay.
Okay.
Okay. It's not a Killebrew, it's a Cobb's, but I think that's fair to allow you, since I'm telling you right now that we're not looking at jail time, we're looking at probation. Okay. All right. You understand that if your plea is accepted to this misdemeanor case, you have certain rights, and I'm going to walk you through those rights. Okay. You have the right to be tried by jury. You have the right to be presumed innocent and proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have witnesses against you period trial. You have the right to question those witnesses against you. You, of course, are represented by attorney Erin Robinson in this case. She would be present to cross-examine any witnesses and contest any charges brought against you by the people of the state of Michigan at trial. You understand that, ma'am? All right. You have the right to have court order any witnesses appear in your defense. You have the right to remain silent during the trial. You have the right not to have that silence used against you. And you have the right to testify at trial if you choose to testify. If your plea is accepted, you'll give up the claim the plea was a result of any promises other than what we've discussed and the conversations pursuant to the cops agreement, or threats that it was not your choice to plead guilty. You'd also be giving up the right to any appeal from any trial issues. Since we're not having a trial, we're pleading guilty today. Is it your intention today to waive your rights to trial and plead guilty in this matter?
Yes, Your Honor.
Can I raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, nothing but the truth under penalty of perjury?
Yes, sir.
All right. I'm going to bring your attention back to May 10th of 2021 at the offense location here in the city of Lansing is where the contact was made. What did you do in regards to count one? The accusation is you maliciously used the service provided by a telecommunications service provider with the intent to terrorize, frighten, intimidate, threat, harass, molest, annoy, or disturb the peace and quiet of the governor's state of Michigan, Gretchen Whitmer. Why don't you tell me what you did in order to be guilty of this, what occurred on May 10th, 2021 in the city of Lansing?
I can't remember. I just remember calling her really drunk. To be honest, she wasn't a very special politician. I called a whole bunch of them that I didn't like at the time.
All right.
And she happened to be one of them. And I
all right. So you
said some.
So you called the governor and you made some threats or annoyed the governor.
Not threats, but annoyed. I guess
Okay.
annoyance. Yes.
All right. And you did so on May 10th, 2021, and the call was made to the city of Lansing.
Yes.
All right.
I think so.
Any questions concerning the factual basis, Mr. Jacques?
And I would just indicate that factual basis is not, I think it supports the plea, but
Right.
it's different than the facts we have in our police report.
Okay.
If she's pleading guilty to it, she's accepting responsibility.
All right. Thank you. Ms. Robinson, any question about the facts?
No, Your Honor, thank you.
All right. I do believe the factual basis in that you did make a call to the city of Lansing concerning annoying or disturbing the peace and quiet of Governor Whitmer by threatening physical harm or by disturbing the peace and making annoying comments to her by use of a telecommunication services provider. So I'll accept that as a plea to the offense And I'm going to refer this to probation as indicated in the cops conference. So the defendant pled to the charge. And I'll refer to probation. Yeah, pretty much the same as a drunk driving. So alcohol assessment.
Yeah.
And I will indicate that the Cobb's agreement is a 4-month term of probation. The Cobb's agreement was a 4-month term of probation.
And Your Honor, I believe she's already done a substance abuse assessment, so
She can make that
yeah,
available.
I just let her know to
Yeah.
provide
Yeah,
that
I
to
could, I
probation.
could send an email to it when I go back home.
To probation. So our probation department's on the 5th floor. You want to stop by them, answer all their questions, tell them about your other probation, okay, who your probation agent is. And so what they're gonna do is they're gonna prepare a report for me, as you know, and then we'll see what options are available. Really, what I'm concerned about is that the drinking that was involved that led to this.
Okay.
That's really the
I
main
actually,
aspect.
yeah, I have it.
Okay, yeah, it's probably not a good idea at this
No,
point.
yeah, I've definitely learned my lesson from
Okay.
being on probation to begin with, so.
So I'll refer you to probation on the 5th floor and we'll set for sentencing date of
I'm sorry, June 27th.
June 27th at 1 o'clock. Any questions from the Attorney General, Mr. Jacques?
No, Your Honor. Thank you.
Ms. Robinson, June 27th at 1 o'clock, you have that date?
I do, thank you.
All right, thank you. That's all for the record in that file. Ms. Davis, we'll see you on that date.
This is, okay, for probate, okay.
Yeah, for sentencing, it'll be on June 27th. And then go down to the 5th floor, tell them what you're there for, and they'll have somebody.
Right now?
Yeah, right now.
All right.
Yep.
Oh, okay, thank you.
All right, thank you.
You're all set, Ms. Davis.
And you're all set, sir.
Thank you, Your Honor. Have a good day.
You too.
You too.
This is the third of the probation. I got another one.
Right. So Miss Sutter should see this too. Most likely.
Crusoe.
I believe she's talking.
All right, there's-
Forgot about that.
We have Thurman's here. And Macon. Wait. That's Ms. Thurman, you should get a prompt to join your public defender in a breakout room. All right, so we're on the record in docket 23-01200. That's people of the state of Michigan versus Javon Smith Dobbs. Will the parties please introduce themselves for the record?
Jeff Roberts on behalf of the people, Your Honor.
Aaron Robinson, Assistant Public Defender for Mr. Smith Dobbs.
And sir, you are Javan Smith Dobbs okay. And you can hear me all right, Mr. Smith Dobbs?
Yes, sir.
All right, thank you. This is a time set for a pretrial in the matter. Mr. Brodowitz, how are we proceeding?
Yes, Your Honor, as you stated, today's the date and time set for pretrial. The people have made an offer, and that would be for the defendant to plead to count 2 as charged, dismiss count 1 with restitution on both counts.
And Ms. Robinson, how are we proceeding today?
We're gonna set the case for final pretrial and jury trial,
Okay.
please.
All right, the final pretrial date, which will be live or via Zoom for if it's still incarcerated, if Mr. Smith Dobbs still incarcerated, but the final pretrial is set for
May 23rd at 8:30.
May 23rd at 8:30. June 13th at 8 for the jury. So the Mr. Smith Dobbs I think he can appear via Zoom. I don't think we have to bring him over for that final pretrial. Mr. Brodowitz, you'll be responsible for your witnesses being subpoenaed on that date.
Your Honor, my witnesses are actually here today in the courtroom, so I was wondering if I could waive their appearance for the final pretrial.
I have no objection to that, Ms. Robinson.
That's fine.
Okay, so I'm going to indicate that the defendant may appear by Zoom. And the CV's appearance are excused. And then, so we'll see you again on May 23rd at 8:30 for the final pretrial. Your jury trial is set for June 13th at 8 o'clock. All right, Mr. Smith Dobbs, please keep in contact with your attorney, Aaron Robinson from the Public Defender's Office, if you have any questions. Anything else for the record, docket 23-01200, Mr. Brodowitz?
Nothing from the people.
Ms. Robinson?
Actually, briefly, Your Honor, I would request to convert Mr. Smith Dobbs's bond into a personal recognizance bond today. It looks like he had some bench warrant arraignments for a probation case in circuit. Those have since been cleared up. And so the only thing that is holding him in is this case. He's got a $2,000 10% bond that he would normally be able to post. However, because he wasn't sure what was going to happen with the felony cases, he did spend all of his money on making sure that his housing was secured, and so he doesn't have any money to post to get out. So we just ask for a PR bond.
Response, Mr. Brodowitz.
Yes, Your Honor, I would state that based on I understand the arraignments in circuit court, based on the nature of those cases in circuit court and the violent nature of these assaults here, I would ask that the bond remain 2,010%.
Okay, based on the 2 assaultive crimes that are indicated in the file and the initial bond that's set, I'm going to deny the motion.
Can I ask a question? So does that mean I have no bond, or my bond is still the same?
Bond is the same at 2,010%.
Thank you.
Thank you. Anything else for the record, docket 23-01200, Mr. Brodowitz?
Nothing from the people.
Ms. Robinson?
No, Your Honor,
All
thank
right,
you.
thank you. That's all for the record in that file. And then, were you able to meet with Mr. Blackney?
Me?
No, it's Mr.
Oh.
Brodowitz. I think met with him in a breakout room.
I did meet with him briefly. He indicated to me that he was going to be seeking representation from the Public Defender's Office. And once I learned that, I did not proceed.
All right, let's go ahead and put that on the record. And he's also got a fingerprint. So we're on the record in docket 23-01075. That's People of the State of Michigan versus Eric D. Blackney. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
And sir, you are Eric Blackney, is that correct?
Yes.
All right, and it's my understanding that you've indicated that you're going to seek representation in this matter from the Public Defender's Office?
Yes.
Okay. I have in the computer that you did seek representation, but it wasn't, something happened. And I do have a court-appointed attorney requested. on that date. Do you have the number to the public defender's office?
No, I don't.
All right, let me give you their number so that you can follow up on the appointments. Because right now they don't have you as a client.
Okay.
So take this email and this number down, okay?
Okay.
The number is 517-679-2979.
Mm-hmm.
And the email address is pd@ingham.org. And Mr. Smith Dobbs, you're free to leave.
Thank you. That
All
was
right,
my
thank
question.
Yep. So Mr. Blackney, what I'll do today at this pretrial is adjourn it for a second pretrial, so you can get representation from the public defender's office, okay?
Okay, thank you.
All right, so we're gonna, D is to seek representation from PD. So we'll reset it for the next date, and I'll get that date from you. In the interim, as soon as you can, you should make that call and give them the date that I'm about to give you, okay?
Okay.
All right. So we've reset this pretrial for. It's reset for May 23rd at 9 a.m.
Okay.
Make sure you give them that. Make sure you give them that date, because that's the date you should be represented at this next pretrial. Okay, sir.
Okay, thank you, sir.
All right. Anything else for the record? Docket 23-01075, Mr. Brodowitz.
Nothing from the people.
All right. Mr. Blakeney, you also have, you have to get your fingerprints taken as a part of the warrant. We're going to leave that I'll leave that in the file, and you can address that at the next pretrial, okay?
Okay.
All right. So you're all set. Do you have any questions of me, Mr. Blakeney?
No, not at all.
All right. You're free to leave the Zoom courtroom. Thank you for your appearance. We'll see you on that May 23rd date.
Okay, thank you, sir.
Thank you.
All right.
Listen.
Yeah, but they do subpoenas for the next one.
Sure. Burgess? Crusoe.
That's the one, that's.
The final three. So that one.
Yeah. Thank you. Nice meeting you. Have a blessed day.
And Mr. Crusoe's here, Mr. Brodowitz, and I don't think he's on, I think he's unrepresented.
I believe so.
So you may want to talk to, are you Mr. Crusoe, sir? All right. You may want to talk to him just in regards, it's a dog licensing case, I think.
My twins, my twins. Yeah. Hanover murder. Yeah. Come out there, give you a hug.
So. So you are
They're the victims of the.
I can't give you that advice. Okay, and so I just need to tell you that anything you say, I can't use it for it. That's like, I would just have to put it in. So, yeah, so you've been charged, you got a ticket for unlicensed dog. I believe it was the dog. Do you have a license? Okay, so what we can do then is we can send it for Yeah. Yeah, so as long as I can get proof that the dog is licensed, and we just see the license paperwork, then yeah, we'll dismiss it. That, or you can email it to me. If you want to.
This just has a PV green
Send it in, and then
and a here.
go from there. They'll probably set it for another set for the final.
She represented Sutter,
Sorry.
Sutter on the PV, and then arraignment. So Miss Sutter should talk to her.
Yeah.
Also. See,
Yeah.
that all over.
I was gonna say,
Oh, yeah. I got a feeling
I
that
can write it on a piece of paper.
if Sutter talks to her, put that all together.
J. B. R.
Not the appropriate thing to say.
It's easy. At.
First, just because I've got that name in my head right now. So, yeah, or else I'll start,
Sorry.
I'll add a Y to her name too. And she should come out of room 1, right?
Yes, she's still in there.
Oh, while we're waiting on her, we can probably just go through. Does she have to prompt out of there? All right, here she comes. All right. So we're on the record in docket 2300998999 and 230100. Will the parties please introduce themselves for the record?
Jeff Bradowitz on behalf of the people, Your Honor.
Aaron Robinson, Assistant Public Defender for Ms. Thurman.
And ma'am, you are Tammy Thurman, and you'll have to unmute yourself, ma'am.
Yes, I am, Your Honor.
All right, you can hear me all right, Ms. Thurman?
Yes, Your Honor.
All right, this is the time set for a pretrial in the matter. Mr. Brodowitz, how are we proceeding?
Yes, Your Honor. At this time, the people have made an offer that if Ms. Thurman were to provide proof of licensure of the dogs, the people would dismiss the ticket for compliance. At this time, the people have been provided proof of license for dogs Fatty and Lucy. And upon conversations with the defense, Ms. Thurman is still waiting on the license for the dog Oreo. So at this time, the people would seek to dismiss for compliance the files relating to the dogs Fatty and Lucy, but leave open and set for, I guess, final pretrial the case relating to the dog Oreo in order for compliance to be met with that.
All right. I don't know if they indicated. Let's see if they indicated what dog goes to what count.
So Oreo goes to the case in 98.
That's Oreo.
So dismiss 99 and 1,000.
And we'll dismiss 99 and 1,000.
Yeah.
Yes.
Okay. All right. So Ms. Thurman will, per compliance, will dismiss case 23000999. And per compliance, we'll dismiss, the people move to dismiss docket 230100. And then on the final case that you're waiting on, we will adjourn 2 weeks so that you can provide some compliance on that file, and we'll reset it for May 23rd at 9 a.m. And if Mr. Brodowitz, if you're able to provide that, the compliance to Mr. Brodowitz, he probably can take that off the docket, okay, ma'am?
Yes, Your Honor.
All right. Anything else for the record, docket 23000998, Mr. Brodowitz?
Nothing from the people.
Ms. Robinson?
No, Your Honor, thank you.
All right, thank you. That's all for the record on 23000998. Ms. Thurman, you're free to leave the Zoom courtroom. Thank you for your appearance today.
Thank you, Your Honor.
And we're ready on Crusoe.
Yes, Your Honor.
Mr. Crusoe. On the record, docket 22030021. You can come up here. That's People of the State of Michigan versus Delon Crusoe. Will the parties please introduce themselves to the record?
Jeff Bradowitz on behalf of the people, Your Honor.
And sir, you are Delon Crusoe?
Yes, sir.
Okay. And this is the time set for a pretrial in the matter. Mr. Brodowitz, how are we proceeding?
Yes, Your Honor. As you stated, today's the date and time set for pretrial. I have spoken with Mr. Crusoe, and I have let him know that if he provides proof of license for the dog Ollie, that the people would dismiss the ticket for compliance. He has indicated to me that he does have the license, just not with him. And so at this time, the people, I guess, would ask for a brief adjournment in order for Mr. Crusoe to provide that license to myself so that we can
All right.
Resolve this ticket.
All right. So you understand, as long as you provide a license for the dog Ollie, this case will be dismissed. All right. So it's all for compliance purposes. We'll reset it to give you some time to get that license and show Mr. Brodowitz. We'll reset for May 23rd at 9 a.m. So you have till May 23rd at 9 a.m. to provide any assurance to Mr. Brodowitz. And then Mr. Brodowitz, if you get it before then and you want to contact the court that we don't need the hearing, That's fine, okay?
Yes, Your Honor.
All right. Anything else for the record? Docket 2203-021, Mr. Brodowitz.
Nothing from the people. Your
Mr.
Honor.
Cruzo, do you have any questions for me?
No, sir.
All right, sir, you're all set. Thank you for your appearance today.
Your Honor.
Yes.
That was gonna be my question, because I know since they're tickets, we don't really do a nollie for them, but how?
I will write it in the file if they get me the file.
Okay, because I do have one for you, at this time set for next week.
If you email us and indicate
Okay.
that compliance has been provided,
Okay,
I can stick it in, I can put it on the record or I can just write it in the file. Because I don't need a nollie on that. Yeah, I don't think I need a nollie.
yeah,
on
I
that.
was wondering how to do that on
Yeah.
tickets, so.
I think that's the most, I think that's the easiest way to do it. And then I'll just write it in the file and we're all set. Do you want to go on Eisenman?
Yes.
All right. I'm gonna go on mute.
Oppose?
All right, Ms. Moyes, let's call your case of docket 23013226. And you'll have to unmute yourself. That's people of the state of Michigan versus Olivia Moyes. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter appearing for now on behalf of Ms. Moyes.
And ma'am, you are Olivia Moyes?
Yes,
And you can hear me all right, Ms. Moyes?
yes,
All right, this is the time set for a pretrial in the matter. It's been brought to my attention. This is a co-defendant file along with the following that we're going to call file 23013225, Ms. White. And therefore, it's my understanding that Ms. Sutter has been appointed to both files from the Public Defender's Office. It's obviously a conflict. And so we're going to reset this pretrial so that Ms. Sutter knows A, which of the two defendants she's appointed to, and B, what your conflict counsel will be concerning representation. All right, Ms. Moyes?
yes.
Do you understand that we're going to reset it so that you know exactly who your counsel is?
Okay,
So Mr. Brodowitz, is that your understanding of what we're doing here?
Yes, Your Honor.
Ms. Sutter?
It is, Your
Yeah,
Honor.
and you're kind of in a hard spot because it's your conflict.
Right, and I was a little cautious about calling either of them yesterday
Right.
because it's a delicate thing with conflicts. So I don't know which. Normally, there's a procedure I follow to pick one, and in this case, there's no good choice. I think
Right.
it's just a matter of point and grab.
Right. All right, we'll reset the pretrial for conflict issues for May 23rd at 9:30. And Ms. Moyes, you can attend that by Zoom just like you're doing today, okay?
okay.
All right. So anything else for the record, docket 23013226, Mr. Brodowitz?
Nothing from the people.
Ms.
Your
Sutter?
Nothing further.
All right, Ms. Moyes, the Public Defender's Office will contact you in regard to who your lawyer is on that, okay?
Okay,
All right, thank you. That's all for the record. You're free to leave the Zoom courtroom. Then we'll also call docket 23013225. That's people of the state of Michigan versus Nadine White. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter appearing for today on behalf of Ms. White.
And ma'am, you are Nadine White,
yes,
and you can hear me all right, Ms. White?
yes,
Right, so you have an understanding that the same thing as to Ms. Moyes, we're going to adjourn this pretrial because there's a natural conflict from the Public Defender's Office. And we have to find out who your lawyer is going to be. All right, ma'am?
all right,
All right, so we're going to reset this pretrial. What was that date again? May 23rd at 9:30
okay,
for conflict issues.
okay,
And so you will be contacted by the Public Defender's Office in regards to who represents you on that date. All right, ma'am?
all right,
Easiest way to say it is one of you is going to get Ms. Sutter and somebody's going to get a conflict counsel. All right?
okay,
All right. So you have that May 23rd date at 9:30?
yep,
And you can appear by Zoom on that date. All right, ma'am?
okay.
Anything else for the record in docket 23013225, Mr. Brodowitz?
Nothing from the people.
Ms. Sutter?
Nothing further.
All right, thank you. We'll see you on that May 23rd date. All right, ma'am?
All right.
All right, thank you. You're free to leave the Zoom courtroom. All right. How about Burgess?
I believe that's Ms. Robinson's.
Is
And I
she,
think-
do you know if she's talking to him right now? Or is she talking to him?
I would imagine she's talking to him.
Okay. If
And
not,
then Macon?
Macon, I'm not sure if they're represented.
Macon declined the services of the Public Defender's Office.
Oh. Right, let's go ahead and call the hallway for Macon.
Well, she's on Zoom.
She's on Zoom? Oh, okay.
I can,
Did you want to meet with her?
yeah, I can speak with her.
All right. Miss Macon,
Have one question.
Absolutely not.
Miss Macon, are you there?
Yes,
you are unrepresented today, is that correct?
Yes.
All right, would you be amenable to speaking with the assistant prosecutor on this case?
Yes.
Concerning this matter? All right. When he joins us, I'll put you in a breakout room with him, all right?
Okay.
All right, thank you. We're on the record in docket 23-01048 and 23-01047. That's people of the state of Michigan versus Desiree Macon. Will the parties please introduce themselves for the record?
Jeff Broadwitz on behalf of the people, Your Honor.
And ma'am, you are Desiree Macon.
Yes,
You can hear me all right, Miss Macon?
yes, I can.
All right, this is the time set for a pretrial in the matter. Mr. Brodowitz, how are we proceeding?
Yes, Your Honor, as you stated, today's the date and time set for pretrial. After speaking with Ms. Macon, she has provided me with proof of licensure of both dogs. So at this time, the people would seek to dismiss the ticket for compliance and both files.
All right, with that understanding, both files for compliance purposes are dismissed without prejudice. What that means is that the people could reissue if they choose to, but for our realistic purposes today, the case is dismissed. Both cases are dismissed today. Anything else on the record, docket 23-01047 or 48, Mr. Brodowitz?
Nothing from the people, Your
Ms.
Honor.
Macon, do you have any questions of me? Both files are dismissed today.
No, I don't have any questions.
All right, you're free to leave the Zoom courtroom. Thank you for your appearance today.
Thank you.
And then we have,
This was given to me today. The victim wrote.
Looks like it was written in 1920.
Right?
are you ready on Kyrgyz?
I guess, I don't think he's here, right?
All right.
Correct.
Okay.
All right, so we're on the record in docket 23-01275 and 23-01198. That is people of the state of Michigan versus Dale Kyrgyz. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Aaron Robinson, Assistant Public Defender for Mr. Kyrgyz.
All right, this is the time set for a pretrial in the matter. I do not see Mr. Kyrgyz in the Zoom courtroom. There's nobody in the waiting room or in the physical courtroom. This was scheduled for 9 o'clock. It is now 10:27. It would appear that Mr. Kyrgyz has failed to appear on these two dog cases. Mr. Brodowitz, how would you like to proceed?
At this point, Your Honor, as the defendant has failed to appear, the people would ask that a bench warrant be issued and any bond be forfeited.
Okay, Ms. Robinson, I'm assuming you want a 48-hour hold on that?
Yes, please.
So if Mr. Kyrgyz is able to, make some contact, we'll place this with a 40. So the bench warrant bond forfeiture is issued with a 48-hour hold.
Thank you.
That's all for the record in dockets 23-1275 and 23-1198. Now, on this jury trial, I just want to be certain that I'm learning as I go, and that we have to be more, these pronouns kill me on this stuff. Because it's always a he, she, so I'm making sure, but I want to make sure that I've got you both here, that your witnesses, Mr. Brodowitz, want to make sure the complaint reads with the witnesses you're going to call correctly. Let me make sure I got that. Because I think there's 3 witnesses on the complaint.
Yeah, but one of them is Officer Hackenberg. He's just the issuing, so I only have 2 witnesses.
So it's Mary Carlisle and Rachel Logston.
Yes, yeah.
And you don't intend on calling Randy Hackenberg?
No.
And then, Ms. Robinson, you don't have to call any witnesses, so we won't put any down, okay? Unless you want to.
I have witnesses. but-
Okay. Did you want to wait on that to present them, or did you want to let the jury hear who they are?
Doesn't matter.
let's go ahead and let the jury, just in case somebody knows them. So prosecutor, witnesses, and then we'll do defense. I do want them to know that you don't have to call any witnesses, but you may call.
My witness is Mary Carlisle. It's the victim's mom. They have the same name.
So are you in a, oh, they have the same name.
They have the same name.
All right. So Mary Carlisle Senior, I guess. I don't know.
I think it's like Mary, I think her middle name is L and the victim's is F.
Okay, let's put L.
Sometimes distinguish that.
We will. So we have Mary Carlisle and Mary L. Carlisle right now.
Cool.
Okay. All right. So that's the witness. Any others?
Possibly, I don't know yet.
Okay. Sounds good. All right. So we'll I think if we get started by 11 for the voir dire, bring them in here, blah, blah, blah. And then we'll see how it goes, but I guess I am looking like at a 1 o'clock lunch.
That's
Break
fine.
from
I
1
just
to
need,
2.
I need at least an hour lunch to run home. No, seriously though, because I
Right.
have to run home and let my dog out
Right.
and then come
You
back.
will get
because
one-
Last
yeah.
time I got home at 7, then that
Right.
was just too late for him.
So let's, yeah,
home to a
that's,
mess.
yeah, that's not gonna work. Yeah, we should give the jury at least an hour. And I'm banking
by
right now
minutes.
1 to 2. Okay, that'll be 1, so, but maybe a little bit more, maybe 12:45 depending,
I
okay?
mean, I live 5 minutes away.
Right,
just
but
moved.
we don't want the dog to suffer because, we're not.
My
timely.
carpet to suffer.
All right, so let me know, and I'll bring up the jury in the part 1,
Okey doke.
and then, and we should move the camera.
I'm gonna run downstairs. quick and use the restroom.
All right, okay. The jury might be ready before 11, so.
I'm gonna just run outside real quick and
Check on the jury.
stretch out my back.
All
But I'll
right.
be up in like 10, 15 minutes.
All right.
Nice.
Instructions before trial. All right,
Just a view of your stream.
that's all it
And
is?
a head,
And a head?
and a half a head.
Top of the head.
That's how I like it. All right. mute there.
There we go.
All right, thank you. All right, I'm going to read you some instructions before trial, and then we'll make appearances again. That was really for the record. And through the, I don't know how this works, but you can follow along as I read. It's all magic to me. So these are the instructions before trial, People versus Trina Austin Morrison. Ladies and gentlemen, I'm Judge Tony Flores. It is my pleasure and privilege to welcome you to the 54A District Court of Ingham County. I know that jury duty may be a new experience for some of you. Jury duty is one of the most serious duties that members of a free society are asked to perform. Our system of self-government cannot exist without it. The jury is an important part of this court. The right to a jury trial is an ancient tradition and part of our heritage. The law says that both the person who is accused of a crime and the prosecution have the right to a trial, not by one person, but by a jury of 6 impartial persons. Jurors must be as free as humanly possible from bias, prejudice, or sympathy for either side. Each side in a trial is entitled to jurors who keep open minds until the time comes to decide the case. A trial begins with jury selection. The purpose of this process is to obtain information about you that will help us choose a fair and impartial jury to hear this case. During the jury selection, the lawyers and I will ask you questions. This is called voir dire. The questions are meant to find out if you know anything about the case. Also, we need to find out if you have any opinions or personal experiences that might influence you for or against the prosecution, the defendant, or any witnesses. One or more of these things could cause you to be excused in this case, even though you may otherwise be qualified to be a juror. The questions may probe deeply into your attitudes, belief, and experiences. They are not meant to be unreasonable prying into your private life. The law requires that we get this information so that an impartial jury can be chosen. If you do not hear or understand a question, you should say so. If you do not understand it, you should answer truthfully and completely. Please do not hesitate to speak freely about anything you believe we should know. During jury selection, you may be excused for serving on the jury in one of 2 ways. First, I may excuse you for cause. That is, I may decide that there is a valid reason why you cannot or should not serve in this case. Or a lawyer from one side or the other may excuse you without giving any reason for doing so. This is called a preemptory challenge. The law gives each side the right to excuse a certain number of jurors in this way. If you are accused, if you are excused, you should not feel bad or take it personally. As I explained before, there simply may be something that causes you to be excused from this case. I will now ask you to stand and swear to answer the questions fully, honestly, and all the questions that you will be asked about your qualifications to serve as juror in the case. If you have a religious belief against taking an oath, you may affirm that you will answer all the questions truthfully, fully, and honestly. So I'm going to have you all stand. Raise your right hand or not if you have a religious affinity against taking an oath, and say, do you solemnly swear or affirm that you will truthfully and completely answer all questions about your qualifications to serve as jurors in this case? Is that an I do?
I do.
All right, thank you. Is there anybody who does not say I do? All right, you may be seated. I'd like to introduce you to members of my staff. Wendy Holden is my court recorder. Nathaniel Neves is my court officer. He will be acting as bailiff too. So he will be taking care of the jury that's selected in this case, all right? And I'll swear him in later after proofs are presented. This is a criminal case involving the accusation of a charge commonly known as assault or assault and battery, which I will explain fully later. This charge has been made against the defendant, who is Trina Austin Morrison. The defendant's lawyer is Miss Erin Robinson. Miss Robinson, please introduce yourself.
Hi, ladies and gentlemen. My name is Erin Robinson. I have the pleasure today of representing Ms. Trina Austin Morrison.
Thank you. The lawyer for the state of Michigan is Assistant Prosecuting Attorney Jeffrey Brodowitz. Please introduce yourself and list any witnesses you anticipate calling in this trial.
Hi, ladies and gentlemen. My name is Jeff Brodowitz. I'm the Assistant Prosecuting Attorney. The witnesses I plan to call today are Miss Mary Carlisle and Officer Rachel Logston.
And the defense does not have to provide any witnesses, as you'll notice through our instructions. It is anticipated that the defense may call one witness, and that's Mary L. Carlisle, who is not the same as Mary Carlisle, and we'll go through that, okay? Does anyone know the defendant or any of the lawyers or witnesses? All right, ma'am, you know, so who do you know, ma'am?
I know Mary Carlisle and Mary Carlisle.
All right, so you both know one of the defendants and one of the witnesses. All right. Council approach. So juror, I'm going to call you juror number 1, 2, 3, 4, 5, 6, 7, juror number 7. Thank you for that. This probably is not the case for you to sit on, right? Obviously, if you
The judge.
you know two of the 3 witnesses involved. So, ma'am, you're excused for this trial, all right? All right, thank you. So you can leave. Yeah. Yeah, you'll meet with Miss Kneeling. Yep. And that's pursuant to stipulation by both counsel, okay?
What was the name? I'm sorry.
And what's your name, ma'am?
Christina Walker.
Christina Walker. And then Ms. Kneeling, you can take care of that any way you see fit. Thank you, ma'am. Does anybody know now we're gonna have everybody knowing everybody, but does anybody know the defendant or any lawyers, anybody else? All right, thank you. We think this trial will last about a day. If you believe that the length of trial will be a real hardship for you, please let me know right now. We're getting started pretty timely, and we moved it along. So I don't expect it to go further than a day today, but you never know. Does that affect anybody today, ma'am?
If this goes into tomorrow, I'm due to go out of town for my parents' graveside service.
Okay. All right. So we'll keep that in mind as we go through, sir.
That affects my work schedule for today, and if it does drag on for tomorrow as well.
All right. So this afternoon you have a work schedule.
Yes.
All right.
I work from 6 to 4:30.
From when?
6 a.m. 4:30.
So tomorrow morning, 6 a.m.?
Yes.
Okay.
Judge, I'm
Pretty
sorry,
much
but
all
can we get people's names? when
Sure.
we're speaking
So
to
ma'am,
them?
what's your name?
Thank you.
Linda Kidrick.
Okay, Linda Kidrick. And sir, what's your name?
Corbin Reinke.
Corbin. And sir, you work tomorrow morning at 6 a.m.
Yes.
Judge, can I have
Yes.
for a second?
Sure. So we'll address those issues as we come. Let's see how we end up, all right? Some of you may have health problems that would prevent you from serving on a jury. For example, does anyone have a medical problem that makes you unable to sit for 2 or 3 hours at a time? Does anyone have a sight or hearing problem? Okay, ma'am, that's Miss Kidrick, right?
Yeah, I have to get up about every half hour, stand up and stretch and move.
All right. All right, thank you, ma'am. This is a criminal case. The paper used to charge the defendant with a crime is called a complaint. The paper used to charge the defendant with a crime is called a complaint. The complaint in this case charged the defendant, Trina Austin Morrison, with the crime of assault or assault and battery and reads as follows. On or about February 8, 2023, at the offense location of 4719 Bristol, City of Lansing, Ingham County, State of Michigan, in count 1, did make an assault or an assault and battery upon the following person, Mary Carlisle. The defendant has pled not guilty to the charge. You should clearly understand the complaint I've just read is not evidence. A complaint is read in every criminal trial so that the defendant and jury can hear the charges. You must not think it is evidence of his or her guilt, or that she must be guilty if she's charged. A person accused of crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecution must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove her innocence or do anything. If you find that the prosecution has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of evidence or lack of evidence. It is not merely an imaginary or possible doubt. but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. The clerk, I will now draw the names of 7 prospective jurors. As your name is called, please come forward and take your seat in the jury box. Start in the back row with the seat closest to the back of the courtroom. So as I call juror number 1 will have the longest way to walk, and they'll go all the way to that first seat, okay? And then it will have the longest way to walk every other time, okay? And filling in across the back row, and then the front row in the same manner. All right, so I will call the first randomly selected jurors. We picked 7. 1 is an alternate. We'll explain that later, okay? So the first juror is Carol Monroe. And Ms. Monroe, if you'll take the very first seat there, which means you have the longest walk.
Down here?
Down here, yep.
Oh, okay.
But you have to go all the way around. No.
Oh.
Yep, all the way.
Up on top.
Up,
Okay.
yep. I think they designed this courtroom for exercise. All right, juror number 2 is Linda Kidrick. All right, Miss Kidrick, why don't you take juror number 7, okay? The 7th seat. No, you can take, you stay in 1.
Oh.
Miss Kidrick, you can be juror number 7 at this time.
Knew that was gonna happen.
Yeah, I mean, it's just bound to happen. All right, so Ms. Kidrick, if you take the last seat as juror number 7, thank you. So in the second seat, next to Ms. Monroe would be Corbin Renke. Seat number 3 would be Andrea Mazurva. So in seat 4 would be Stephanie Swart. Thank you. Seat 5 would be Jessica Rabbi. And seat 6 would be Rosanna Rice. All right, jury, I'm going to have the lawyers involved ask you some questions for this voir dire process, okay? Mr. Brodowitz, you may proceed.
Thank you, Your Honor. Okay. Good morning, everyone. I realize it's probably been a bit of a long morning, so thanks for bearing with us. So like the judge said, my name is, I'll introduce myself again. My name is Jeff Brodowitz. I'm the assistant prosecuting attorney here. And like Judge said, we're going to ask you some questions. It's called voir dire. We're just trying to get the truth. We're not trying to pry into your personal lives. You know, we're just trying to get the best jury we can, as many open minds as possible. So just some general questions, I guess, to start for the group. Has anyone ever served on a jury before?
I have.
Okay, we'll start down here. And that's Miss Monroe. What criminal or civil jury? What's
That
up?
was, I don't know, it's been a long time.
Okay.
It's been many years.
Okay, safe to say you don't remember what type. Okay.
No.
That's fine. Do you remember if you were able to come to an agreement in that case or come to a
Yeah,
verdict?
he was guilty.
Okay, so you were able to come to a verdict. Okay. And then Miss Zerba, sorry.
It was civil.
Civil case? Okay, and were you able to come to a verdict in that one? Okay. And then who else? Sorry. Miss Kidrick. What type of case was it?
Both of them were criminal.
Okay.
And we came to an agreement.
Okay.
We came to a decision.
All right. And so, you know, the judge, I guess, has covered that one already. So that's, has anyone here ever had contact with the prosecutor's office? You believe so?
Yeah.
Where it was, what type of contact was that?
I was in trouble once upon a time a while ago. So.
Okay, I'm not gonna ask, but is there anything about that interaction that would, you know, sway you one way or the other in this case, which prosecution or defense? Okay. Does anyone here have any friends or family in law enforcement? Has anyone ever, sitting here, have ever had any experience with a police officer that would give you sort of a negative view or positive view of the police, either way?
Yes.
Would you elaborate a little on that?
Like I said, I've been in trouble multiple times, and half of it would be just talk back to somebody who's talking back with me as well, being a police officer. So, yeah, really heated.
Okay, and would that interaction make you any more or less able to fairly judge a police officer's testimony?
No.
Okay. So we'll go on just a little bit here. So as Judge stated, the crime involved here is the crime of assault or assault and battery. Now, there are a couple of elements to the crime here, but one of the ones I wanted to go over quickly is I guess the idea of what an assault is. And so I guess I would look at just real quick on Ms. Schwartz, what's the definition of an assault?
Intent to do bodily harm.
Okay. Ms. Rice, what's your opinion, what's your definition of an assault?
The intent to do harm to a person.
Okay. Does anyone on the jury, I guess, believe that in order for someone to be guilty of an assault, that there needs to be an actual physical injury?
No.
Okay. Now, if the judge were to instruct you that an assault can be committed without an actual physical injury, it can just be the imminent threat of a physical injury, would you be able to follow that instruction and render a verdict here?
Yeah.
Yes, everybody? Okay. So another element of the crime here is going to be intent. And so in a crime like this, does anyone have a problem with recognizing that intent can be proven not only by actions, but by words as well? And then I guess I'll just ask in general, does everyone understand, you know, the difference between an intentional act and an accident?
Yes.
All right. So then also in this case here, most of the testimony you're going to hear, most of the evidence you're going to hear is going to be testimony from witnesses. And so I guess is anyone, you know, expecting there to be any sort of, you know, groundbreaking eyewitness like on TV or any sort of high tech, you know, evidence as seen on TV here? No. Okay. Just have to ask. And that, you know, do you understand, I guess, does anyone have an issue or does everyone understand that the people who will be testifying are human beings and they're going to have, you know, emotions and varying motives and imperfect memories?
Yes.
All right. And that it's going to be necessary for you to determine who is credible and believable, and that, you know, the credibility and believability of a witness is a judgment that only you.
Yeah.
Now, another thing that Judge Flores already said is that I, as the prosecutor, have to prove my case beyond a reasonable doubt. And so I guess I will start with just quickly here on Ms. Robbie. What does beyond a reasonable doubt mean to you? Okay. Ms. Monroe, what does beyond a reasonable doubt mean?
Proving they're guilty or not guilty.
Okay, I guess I'll ask them based on that. Does anyone expect that the beyond a reasonable doubt standard to be the same as, 100%? My bad.
Just a reminder to everybody to turn off your phone. It's probably as good an example as I can set right there.
My bad. And so, okay, going back to that question, does anyone expect me to be able, that beyond a reasonable doubt is 100%? That it needs to be proved 100%?
Yes,
You said, yes, it does need to be proved 100%.
I believe so.
Okay. And so if the judge were to instruct you that it really doesn't have to be 100%, just has to be any doubt, that there can't be a reasonable doubt, would you have an issue making a judgment based on that?
I would assume not,
Okay.
because there's 100% reasonable doubt, right?
Okay. Ms. Monroe, I think you were shaking your head too, that you expected it to be 100%.
Yeah.
Okay. But if, say, it was if I guess in your mind, if it was 95%, would that still be, beyond a reasonable doubt?
No, that'd be all right. That'd be okay.
Okay. One second. Okay, and then I guess just if I am able to prove my case beyond a reasonable doubt, is there anyone here who would have an issue rendering a guilty verdict in that matter? All right, and now just a couple other things. You understand that, so if I'm able to prove my case beyond a reasonable doubt and it comes back with a guilty verdict, that you here as the jury are only here to judge the facts of the case and not to consider punishment, correct?
Correct.
Okay, and does anyone have an issue with, that? Let me rephrase that. I guess, would anybody here take punishment when you're sent back to deliberate? Would anybody here take punishment into consideration when they're doing their deliberations? Nothing more at this time.
Thank you. From the defense, Ms. Robinson.
Good afternoon, guys. How are we doing? Good, okay. Anybody here remember my name?
Ms. Robinson.
Look at you, Miss Kidrick, right? Awesome, that is my name. But my name's not important today. Does anybody remember my client's name? Yeah, this is Ms. Austin Morrison, and this is one of the most important days of her life. She's sitting here facing a criminal charge, and right now we're picking a jury who's going to be deciding if she's guilty or not guilty. So I really am just going to ask that you guys be open and honest with us, going to be asking some different questions, talking about a lot of different concepts. Don't feel bad if you feel like the answer might not, well, I don't know if I want to say it, or if you feel like uncomfortable saying it in front of us, we can always approach with the judge. But I do just ask that you be open and honest, because that's what Ms. Morrison needs in this case, is somebody who's willing to be open and honest so that we can understand where everyone's coming from. Can we all agree to that? Awesome. Okay, great. All right, so understanding that Ms. Austin Morrison is sitting here right now, right? She's been charged with the criminal offense of assault and battery, right? That means she's been arrested. She's gone through the pretrial stages, and she's sitting here for a jury trial. Does anybody here think that because she's sitting here right now and she's gone through all of those stages, that she must have done something? No. What about you, Ms. Monroe? What do you think about that?
No, I don't think. I need to hear evidence or the argument first before I would decide
Okay. And does anybody here think that, oh, well, you know, she wouldn't be sitting here if she didn't do something? No? Now, we talked a little bit about the presumption of innocence, right? And what that means. So that means that I don't have to do anything in this case. I guess I could fall asleep at the table and technically still be okay with just doing my job. Of course, I'm not going to do that. And I'm not going to do that to Ms. Austin Morrison, but it's completely up to the state of Michigan to prove that Ms. Austin Morrison is guilty of assault and battery, okay? So she doesn't have to do anything. I don't have to do anything. Now, sitting here right now, not having any evidence, having heard anything, what would your guys' verdict be? How about you?
Innocent until proven guilty.
There you go.
She would have to be not guilty.
Okay, great. You know, some people that you trip up on these answers, so I'm glad that we're all on the same page today. You're also going to hear some evidence from somebody that's a police officer in this case. Police officers, we all know, go through special training and have experience. Does anybody here think that a police officer is going to be more credible than, say, someone who's not a police officer because of that training and experience? No? Ms. Monroe, what do you think about that?
No, I don't think so.
Okay. I'm bad with names. Ms. Swart, right? What do you think about that?
I don't think there would be any.
Okay, so you would believe a police officer's testimony and give it the same credibility as someone who was not a police officer, with all things else the same?
Yeah.
Okay. Does anybody not agree with that? Who here has said something that they did not mean to say before? What about you, Miss Miserva? Have you ever said something that you didn't mean?
Yes.
Yeah. What happened with that? How did that make you feel?
Jerk.
Like a jerk, yeah, okay. And what about you, Mr. Ranky? I saw you kind of nod your head.
Definitely.
Yeah. How did it feel after the fact for you?
Probably not for me. I mean, I'm kind of in a few words, just say what I say, kind of get over it, you know.
Okay. And Ms. Rice, what about you? Have you ever said something that you haven't meant?
Yeah.
Yeah, in the heat of the moment? Okay. And after the fact, how did you feel?
Probably like an ass, depending on how.
Okay. Does anybody here think that, I mean, everything, so somebody can say something that they don't mean, right? So it's possible. We all agree that it's possible that we can say stuff that we don't mean, right, in the moment, and then things get heated. Does anybody not agree with that? Cool. All right. So we already talked about how Ms. Austin Morrison is sitting here, and she's sitting here innocent because she has not been proven guilty. What are some reasons why an innocent person might not testify? Anybody give me some reasons?
Not to incriminate themselves.
Not to incriminate themselves. Sure, but an innocent person, right? That's okay. Anybody else? What would be some reasons? Yeah. What would be a reason why an innocent person might not testify in a case?
Well, it could be because they don't have nothing to testify for. They don't have nothing to say.
Yeah, the state hasn't proven their case, right? Okay. Can anybody else think of another reason? Anybody know what the number one fear in all of America is? I like that answer, Ms. Kitcher. No. The number one fear in America is public speaking, okay? I know a lot of people who get really nervous about going in front of large groups of people, or just, I guess, any group of people, getting up there and testifying or talking to them about what happened. Anybody here get nervous about public speaking? Yeah, okay. I see some people nodding their heads, right? So that can also be a reason why somebody who's innocent may choose to not testify, right? Anybody else think of any other reasons? I'm sure that will be in the back of your head. I'm going to tell you guys a secret, okay? Well, it's not going to be a secret anymore, but I just won the lotto today. Okay. Who here believes me? Ms. Monroe, what about you?
No.
Okay, you don't believe me? Ms. Rice, what about you?
I mean, I can't say whether you did good, I have no clue.
Okay. What would you need from me?
To see the lottery ticket.
Winning lottery ticket, okay. What if I told you that I showed Mr. Neves over here this morning that I had the winning lottery ticket? Okay, who believes me now? Anybody? No, Mr. Ranky, you're nodding your head. Okay, you're gonna ask him. And what would you need to see me to believe me?
Cash or the ticket itself.
Okay, yeah, you're like, I want some cash too. Sure, right? Yeah, the proof is in the pudding, isn't it?
Yeah.
All right. Well, thank you guys for talking with me today. I appreciate it. If you are selected for this jury, just ask that you guys be open and honest, listen to everything that comes your way, and render a just decision, okay? Thanks.
Mr. Brodowitz, challenges for cause.
Nothing for cause, Your Honor.
Challenges for cause from the defense.
None for cause, Your Honor.
Preemptory challenges, Mr. Brodowitz.
Yes, Your Honor. At this time, the people would like to thank and dismiss juror number 2.
So that's Mr. Ranky.
Yeah.
All right, so Mr. Ranky, thank you for your appearance today and your participation. And we will replace, that's juror number 2. It's actually juror number 3, but we misseated people. So, but the replacement for Mr. Ranky will be Megan Peters. All right, now, Ms. Peters, unfortunately, you have to climb over everybody.
Oh, sorry, I chose the wrong night.
We don't make it easy. All right, Ms. Peters, you heard the questions that were asked by the lawyers in this case. Is there anything that comes to mind after hearing all the questions asked concerning your participation in this jury?
No.
All right. Mr. Brodowitz, any follow-up questions?
Just briefly, I think, Your Honor. So, Mr. Peters, have you ever sat on a jury before?
No.
Okay. Do you have any friends or family, anybody in law enforcement?
No.
Okay. Have you ever been the victim of a crime before? Okay. I would just ask, what does beyond a reasonable doubt mean to you?
I don't have any suspicions lingering or any doubts.
Nothing more, Your Honor.
Ms. Robinson, any questions of juror number 2?
Yes. And in fact, I will ask it for the whole group.
Okay.
Since, I missed the question when I was up here. My bad. Has anybody here been a victim of an assault or an assault and battery and think that it could affect them in this case?
But we didn't have to report it to the police, right?
Correct.
No, it could be,
Oh,
yeah, just,
okay.
you know, okay, so Ms. Kidrick, do you think that that would affect you in this case? Would affect your ability to be fair and impartial?
It may. I can't say one way or the other.
Okay, so, I mean, I'm gonna give you an example, right? Like, you're about to board a plane, okay? And, you get on the plane, right? And the pilot's like, I think I can land it. Do you get on the plane?
No.
Okay, right. So Ms. Austin Morrison is looking for jurors who can be fair and impartial. So you're saying it might affect you, right?
It might.
So can you really say for certain that even though with the judge going to be instructing you on how you have to be fair and impartial and you can't use that, still might be in the back of your head, right?
Yeah, because it's a long-term thing. It's not like it happened one time and that was it.
Okay. And thank you for being honest with me. I really do appreciate that, Ms. Kidrick, and I know it could be hard to share. Anybody else here have been a victim and think that it could impact their ability to be fair and impartial here? See no other. Ms. Peters, has any of the questions that I asked stuck out with you one way or the other? No. No, okay. Have you ever said something that you didn't mean to say before? Of course, yeah, okay. And how did you feel afterwards? Regret? Regret. Okay. Yeah, I think we've all been there, right? I don't have any more questions, Judge.
All right, thank you. Counsel, can you approach?
Yeah.
Reasons, juror number 7, Ms. Kidrick, you are excused today, okay, ma'am? You need some help, ma'am?
No, I think I'll be okay.
Okay.
Oh, thank you.
So go ahead and speak with Miss Kneeling on your way out, and we'll replace juror number 7. Thank you, ma'am, for your
Thank
appearance
you.
today. So juror number 7 will be replaced by Maya Hone. All right, Mr. Hone, you have the lucky seat. That I don't know if it's lucky for you or the other 6 people in that row. And Ms. Hone, you had the opportunity to hear all the questions that was asked in this matter. All right. Is there anything you wanted to say in response to those questions?
There's not.
Okay. Mr. Brodowitz, you may proceed with some follow-up questions.
Ms. Hone, have you ever served on a jury before? Okay. Any close friends or family that are police officers or law enforcement? I guess that's follow up. Have you ever been victim of an assaulted crime and assault and battery? Nothing else here.
Ms. Robinson, any follow-up questions?
All right, Ms. Hone, good morning. I guess we've got 12 minutes left, so good morning. Any of the questions I asked that stuck out with you one way or the other?
Not so much.
Okay, cool. And knowing that Ms. Austin Morrison sits here and that she's been charged with a crime, do you think she might be guilty of something already just because she's sitting here? No, okay. So you think you can be fair and impartial in this case? All right, thank you.
All right, I think we left off, I think we're at preemptory challenges with the defense.
Yes.
Any
one moment.
okay.
The defense would like to thank and excuse juror number 1.
All right, Ms. Monroe, juror number 1, you are excused. You may climb over everybody.
Sorry.
Everybody rotate.
Right.
I think it's the second one, right? I think it's just kind of a rite of passage.
It's
You need
just,
to number 1 at one point.
We've had other jurors call it musical chairs and other things. Miss Monroe, thank you for your appearance today.
Thank you.
And you can speak with Miss Kneeling on your way out.
Thank you.
Thank you. We'll replace juror number 1 with Jessica Higginbotham. All right, Miss Higginbotham, once again, we're gonna put you in seat number 1.
All right. Ready?
The system now.
Yeah, we got it.
Thank you. And Ms. Higginbotham, you had the opportunity to hear all the questions that were asked.
Yes.
Did anything spark any interest or any response that the lawyers should hear today?
No.
All right. Mr. Brodowitz, any follow-up questions?
Just briefly. Ms. Higginbotham, any close friends or family that are in law enforcement?
No.
You ever sat on a criminal or on a jury before? of any
No.
type? Okay. And then just one, have you ever been the victim of any sort of assault crime?
No.
And just really quickly, just so you listed your profession as agile coach. Can you explain a little bit more about that?
Yeah, I work with tech teams to help improve their processes.
Okay.
Like develop their teams.
Okay. All right, thank you. No further questions, sir.
Ms. Robinson, any follow-up questions?
Yeah. Good morning. Morning. All right, Ms. Higginbotham, am I saying that right?
Yeah.
Cool. Any of the questions that I asked that stuck out to you either way? Okay. Have you ever been pulled over before? Just random question.
Yes.
Yeah. Okay. And have you ever seen somebody been pulled over before?
Yes.
Okay. First thoughts that go through your head when you see someone that's been pulled over. That sucks. Okay, fair. Yeah. Ever think of, what'd they do?
I guess.
Yeah.
Curious. Yeah.
Okay. I mean, it's normal kind of to think that, right? Probably why people slow down on the highway so much when there's police out, and have somebody pulled over. Now, having that pop up like in our head, right? Kind of normal reaction, but we're in the criminal land world. And I'll open this back up to everyone. But so Ms. Austin Morrison is presumed innocent, right? And so we can't sit here and think, oh, what did she do? Because there's nothing here right now that says that she's done anything really. The state has to prove beyond a reasonable doubt, right? So even though that she sits here charged with a crime, all of that kind of stuff, do you think that, oh, she must have done something?
No.
No. Okay. So knowing that you would have to see the evidence and you would hold the state to the burden if they didn't prove their case.
Right.
Nothing further.
Challenges for cause of Mr. Brodowitz.
No challenges for cause here.
Challenges for cause from the defense, Ms. Robinson.
No challenges for cause at this time.
Preemptory challenges, Mr. Brodowitz.
People are satisfied with this jury, Your Honor.
Preemptory challenges from the defense, Ms. Robinson.
Yes, one moment, please. The defense would like to thank and excuse juror number 3.
Juror number 3, Ms. Miserva. You are thanked and excused.
Sorry.
Thank you for your appearance today. And you can meet with Ms. Kneeling on your way out. We would replace juror number 3 with Antonia Lugo. All right, Lugo, we have Miss Lugo, we have everybody going in the same way.
Yeah.
Right, thank you. You're the first jury I've had in the last year to actually have a system. So it says something about you guys. Yeah, it's a very organized group. Ms. Lugo, you heard the questions that the lawyers asked. Do you have any response that maybe they should hear in regards to any of the questions that have been asked? All right. Mr. Brodowitz, any follow-up questions?
Again, just briefly, Your Honor. So Ms. Lugo, do you have any close friends or family in law enforcement? Have you ever been the victim of an assault or crime of any type?
I have,
What type was that?
assault by words and a hand,
Okay. And was that reported to the police at all? Did it
one
go-
time.
Okay, and did that case go anywhere or? Okay. Nothing else.
Thank you. Ms. Robinson, any follow-up questions?
Morning, Ms. Lugo. How are you? Good. Good. All right. I know that you said that you've been a victim of an assault, and I'm sorry that that has happened to you. Do you think that could affect your ability here today? It could. Yeah. Okay.
I don't want to put anybody in jeopardy, so.
Okay. So kind of like what Ms. Kedrick said earlier, you don't think you could really be fair and impartial in this case? Thank you. Nothing further.
All right. I think we're on challenges for, that was the last one was a preemptory challenge. So challenge for cause, Mr. Brodowitz.
So I guess at this time, the people would challenge for cause jury number 3.
Juror number 3, Ms. Robinson, any objection to juror number 3 being
No, Your Honor. Thank you.
recused? All right. Juror number 3, it may not be the case for you today. All right. So so we're gonna have you step down. Thank you for your appearance today.
Yep.
And go ahead and meet with Miss Kneeling on the way out. And we'll replace juror number 3 with a Luke Gensterblum. That would be C3, sir. All right, and am I pronouncing that name correct? It's Luke Gensterblum?
Yes, sir.
Okay, thank you. You heard the questions that the jurors were asked of the lawyers? You heard the questions that the rest of the jury panel was asked by the lawyers? Yeah. Anything, do you think the lawyers, did anything come to mind that you think they should know about your participation today?
Got a lot of relatives and friends in the police department.
All right. And would the fact that that they're in the police department, would that sway you one way or another, or would you be able to take anybody and objectively as they come, knowing that nobody has a corner on the truth?
I think so.
Okay. Okay, Mr. Brodowitz, with that understanding, any follow-up questions?
Okay. Just, I guess, quickly, Mr. Gensterblum, have you ever been the victim of any sort of assault or crime at all?
No.
Okay. And you believe that you could be fair and impartial with judging the testimony of a police officer, even though you have lots of people in your life who are in law enforcement? So. Okay. No further questions, Your Honor.
Ms. Robinson, any follow-up questions?
Yeah, briefly. Good morning, Ms. Gensterbloom. I think I have 1 minute left to say good morning. How are you today?
Very good.
Be good. Okay. Any other questions that I've asked along the way? Have any of them stuck out to you? Feel a certain way about anything? Okay. And I know that you said that you have friends and relatives that have been police officers. Do you think that you would find a police officer's testimony more credible because they're a police officer and they have training and experience versus somebody who is not a police officer?
Yeah.
Yeah, okay, just because that they're a police officer, you would find them more credible? Even if the law says that we judge credibility by, how they talk and what their body language is and common sense and things like that, you would find a police officer's testimony more credible because they're a police
I
officer.
would just because of their experience.
Okay. And so having that, and knowing that and hearing from a police officer and another witness in the case, that would probably affect your ability to be fair and impartial for both witnesses?
There sounds if I'm a police officer, there's something different. I have to go with the police officer, like I say, because of his experience.
Okay, thank you.
It's his job.
Sure. Nothing further.
All right, I think we just finished with a preemptory challenge from the, it was for cause. All right, and that was from the people. So challenges for cause from the defense.
Yes, Your Honor. The defense would challenge juror number 3, Mr. Gensterbloom, as he stated that he would view a police officer's testimony as more credible than another witness just because of them being a police officer.
Response, Mr. Brodowitz.
No objection, Your Honor.
Okay, without objection, juror number 3 is excused for cause. Thank you for your appearance today, Mr. Gensterbloom, and you can meet with Ms. Nealing on your way out, all right, sir?
Thank you, sir.
Okay. We would replace juror number 3 with a Megan Baker. All right, Ms. Baker, juror number 3 seat. And Ms. Baker, you heard the questions that were asked of the jurors by the attorneys?
Yes.
And you understand that, is there anything that came up during the questioning that you think that the attorneys should hear or know about you and your participation?
No.
All right. You understand that that there may be law enforcement witnesses called in this case, and that the credibility factor is based not on what they do for a living, but what you see as a person and how you rate them as a person and their credibility as it conforms with other evidence. Do you understand that? All right. Mr. Brodowitz, any follow-up questions?
Just briefly, Ms. Baker, have you ever been the victim of any sort of assault or crime? Okay. Have you ever had any negative experiences with a police officer that might affect your impartiality here today?
No.
Nothing further, Your Honor.
Ms. Robinson, any follow-up questions?
Just briefly.
Okay.
Good afternoon, Ms. Baker. How are you?
Well,
okay, good. I'm sorry to take up more of your time, but any of the questions that I asked that stuck with you, made you feel a certain way? Okay. And I see that you are a nurse, correct? Okay. You probably see a lot of different and eventful things, right?
I work more with elderly, so I don't see.
Okay. Sure. So no like emergency room type of stuff. Okay. Ever have a time where you said something that you regretted?
Yes, I'm sure everyone has.
Okay. I don't have any more questions.
Thank you. And now, refresh my memory, Mr. Brodowitz, is it challenges, preemptory challenges?
I believe we're at for cause.
Okay, so challenges for cause from the people.
No challenges for cause.
Any challenges for cause from the defense?
No, Your Honor.
Preemptory challenges, Mr. Brodowitz.
People are satisfied with this jury. Your Honor.
Preemptory challenges from the defense.
No, Your Honor, the defense is satisfied, subject to all previous motions and objections.
All right, thank you. We have our jury panel. Okay, so you 7 will sit as jury for the following case. Ms. Nealing, you'll deal with the rest of the juries. Thank you for your appearance today. Thank you for coming today, and you meet with Ms. Nealing, and we'll make sure that you're processed out. Okay, sir? All right, thank you. All right, so the plan here is to at least get through additional instructions and maybe opening statements, and then we'll take a lunch because you deserve a lunch, all right? And maybe while you're at lunch, we can get you paid, so you deserve to be paid. It's not a lot, but it's something, okay? So I'm going to go ahead and play for you or share with you the opening statements in the case. I'm sorry, the procedural instructions. And then we'll get started, all right? So these are procedural instructions involving People versus Trina Austin Morrison. Members of the jury, you've been chosen to decide a criminal charge made by the state of Michigan against one of your fellow citizens. I will now ask you to stand and swear to perform your duty to try the case justly and to try to reach a true verdict. If your religious beliefs do not permit you to take an oath, you may instead affirm to try the case justly and reach a true verdict. So you may stand. Raise your right hand if you choose. Each of you do solemnly swear or affirm that in this action now before the court, you will justly decide the questions submitted to you, that unless you are discharged by the court from further deliberation, you will render a true verdict, and that you will render your verdict only on the evidence introduced and in accordance with the instructions of the court, so help you God. All right, is anybody who does not take that oath? All right, thank you. You may sit down. You'll have a written copy of the instructions I'm going to read to you. You may refer to them during the trial. Since no one can predict the course of a trial, these instructions may change at the end of the trial. At the close of the trial, I will provide you with a copy of my final instructions for your use during deliberations. Now I'll explain some of the legal principles you will need to know and the procedure we will follow in this trial. To prove the charges, the prosecutor must prove each of the following elements beyond a reasonable doubt. The defendant is charged with assault or assault and battery. That Trina Austin Morrison committed a battery on Mary Carlisle. A battery is a forceful, violent, or offensive touching of the person or something closely connected with the person of another. The touching must have been intended by the defendant, that is, not accidental, and it must have been against Mary Carlisle's will. It does not matter whether the touching caused an injury. Number 2, that the defendant intended to either commit a battery upon Mary Carlisle or to make Mary Carlisle reasonably fear an immediate battery. So those are the 2 elements of the charge for assault and or assault and battery. A person accused of crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove her innocence or do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. A trial follows this procedure. First, the prosecutor makes an opening statement where he gives his theories about the case. The defendant's lawyer does not have to make an opening statement, but she may make an opening statement after the prosecutor makes his statement or may wait until later. These statements are not evidence. They're only meant to help you understand how each side views the case. Next, the prosecutor presents his evidence. The prosecutor may call witnesses to testify and may show exhibits like documents or objects. The defendant's lawyer has the right to cross-examine the prosecutor's witnesses. After the prosecutor has presented all of his evidence, the defendant's attorney may also offer evidence, but does not have to. By law, the defendant does not have to prove her innocence or produce any evidence. If the defense does call any witnesses, the prosecutor has the right to cross-examine the witnesses. The prosecutor may also call witnesses to contradict the testimony of the defense witnesses. After all the evidence has been presented, the prosecutor and the defendant's lawyer will make their closing arguments. Like the opening statements, these are not evidence. They are only meant to help you understand the evidence and the way each side sees the case. You must base your verdict only on the evidence. My responsibilities as a judge in this trial are to make sure that the trial is run fairly and efficiently, to make decisions about evidence, and to instruct you about the law that applies to this case. You must take the law as I give it to you. Nothing I say is meant to reflect my own opinions about the facts of the case. As jurors, you are the ones who will decide this case. Your responsibility as jurors is to decide what the facts of the case are. This is your job and no one else's. You must think about all the evidence and all the testimony and then decide what each piece of evidence means and how important you think it is. This includes how much you believe what each of the witnesses said. What you decide about any facts in this case is final. Part of your job in deciding what the facts of this case are is to decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness says. You are free to believe all or none or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you've based on witnesses' race, national origin, or ethnicity, gender identity, or sexual orientation, or religion, age, or socioeconomic status. There's no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Does the witness seem to have a good memory? How does the witness look and act while testifying? Does the witness seem to be making an honest effort to tell the truth? Or does the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias or prejudice or any personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness testifies? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does a witness's testimony seem when you think about all the other evidence in the case? When it's time for you to decide the case, you are allowed to consider the evidence that was admitted in the case. Evidence includes only the sworn testimony of the witnesses, the exhibits admitted into evidence, and anything else I tell you to consider as evidence. The questions the lawyers ask the witness are not evidence. Only the answers are evidence. You should not think that something is true just because one of the lawyers asks questions that assume or suggest that it is. I may ask some of the witnesses questions myself. These questions are not meant to reflect my opinion about the evidence. If I ask questions, my only reason would be to ask about things that may not have been fully explored. During the trial, you may think of an important question that would help you understand the facts in this case. You are allowed to ask such questions. You should wait to ask questions until after a witness has finished testifying and both sides have finished their questions. If you still have an important question after this, do not ask it yourself. Raise your hand, write the question down, and pass it to the court staff. Mr. Neves would be the court officer to pass it to, and he will give it to me. Do not show your question to the other jurors. If your question is not asked, it's because I've determined under the law that the question should not be asked. Do not speculate about why the question was not asked. In other words, you should draw no conclusions or inferences about the facts of the case, nor should you speculate about what the answer might have been. Also, in considering the evidence, you should not give greater weight to testimony merely because it was given in answer to questions submitted by members of the jury. If you cannot hear something that is said or presented, or if you cannot see a witness or evidence, please raise your hand immediately. During the trial, the lawyers may object to certain questions or statements made by the other lawyers or witnesses. I will rule on these objections according to the law. My rulings for or against one side or the other are not meant to reflect my opinions about the facts of the case. Sometimes the lawyer and I will have discussions out of your hearing. Also, while you are in the jury room, I may have to take care of other matters that have nothing to do with this case. Pay no attention to these interruptions. We'll try to keep the interruptions to a minimum. You must not decide the case with anyone, including your friend, family, or friends. You must not even discuss it with the other jurors until the time comes for you to decide the case. When it is time for you to decide the case, I will send you to the jury room for that purpose. Then you should discuss the case amongst yourselves, but only in the jury room and only when all the jurors are there. You must not talk to the defendant, the lawyers, the witnesses, or anyone who may be connected to the case. This means that you may not speak to these individuals, even if it has nothing to do with the case. You should be very cautious about speaking to people because you may inadvertently speak to someone connected to this case. This restriction is necessary to avoid even the appearance of any improper conduct on any person's part. If anyone tries to discuss the case with you or in your presence, tell them to stop. Explain that you are a juror and you're not allowed to discuss the case. If they continue, leave or report the incident to court staff as soon as you return to court. When the trial is over, these restrictions no longer apply. When the trial is over, you may, if you wish, discuss the case with anyone. The restrictions I'm about to describe are meant to ensure that the partials get a fair trial. In our judicial systems, it's crucial that jurors are not influenced by anything or anyone outside the courtroom. Under the laws, the evidence you consider must meet certain standards. For example, witnesses must swear to tell the truth, and the lawyers must be able to cross-examine them. Because information obtained outside the court does not have these safeguards, it could give you incorrect or misleading information that might unfairly favor one side. These restrictions start now and continue until I discharge you from jury service. It is your duty to decide this case based solely on the evidence you see and hear in the courtroom. You must not consider information that comes from anywhere else. This means that you are to deliver your verdict. You must not read, watch, listen to, or receive any information, including opinions or commentary about the case, whether in newspapers, on television, the radio, the internet, or on social media platforms. You also must not research any aspect of the case during the trial. This means research using a cellular phone, computer, or other electronic device to search like dictionary, reference manuals, newspapers, or magazines. You must not investigate the case on your own or conduct any experiments concerning the case, including investigation or experiments using the internet, cellular phones, computers, or other electronic devices. You must not visit the scene or any event at issue in this trial. If it is necessary for you to view or visit the scene, court staff will take you there as a group or under court supervision. You must not consider evidence any personal knowledge you have of the scene. You must not share any information about the case by any means, including cellular phones or social media. This means that if you are not discussing the case with someone else, you may not post any information about the case on social media, websites, or in any other matter. If you discover that a juror has violated my instructions, report it to court staff. You may take notes during the trial if you wish, but of course you don't have to. If you do take notes, you should be careful that it does not distract you from paying attention to all the evidence. When you go to the jury room to decide your verdict, you may use your notes to help you remember what happened in the courtroom. If you take notes, do not let anyone except the jurors see them during deliberations. Your notes will not be examined by anyone, and when your jury service concludes, your notes will be collected and destroyed. You can see we've chosen a jury of 7. After you have heard all of the evidence and my instructions, we will draw lots to decide which one of you will be dismissed to form a jury of 6. So we start with 7, and then after instructions, we pull one juror out by random selection. So we have an extra juror. That's either the best day of your life or the worst day of your life, depending, okay? But one of you will not be deliberating today. I'm telling you that right now, okay? That's we pick one extra juror for purposes, just in case somebody gets sick or they're not able to finish the trial. Possible penalty should not influence your decision. If you find the defendant guilty, it is the duty of the judge to fix the penalty within the limits provided by law. I may give you more instructions during the trial. After all the evidence has been presented, you will hear the lawyer's closing arguments. Following the closing arguments, I'll give you additional instructions about the rules of law that apply to this case. You should consider all my instructions as a connected series. Taken all together, they are the law you must follow. After my final instructions, you will go to the jury room to decide on your case. A verdict must be unanimous, and that means that every juror must agree on it, and it must reflect the individual decision of each juror. It is important for you to keep an open mind and not make a decision about anything in the case until you go to the jury room to decide the case. You must not let bias, prejudice, or public opinion influence your decision. Each of us may have biases or perceptions about other people based on stereotypes. We may be aware of some of our biases, though we do not express them. We may not fully be aware of some of our other biases. Take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. I caution you to avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions after this case individually, but you should do so only after listening to and considering the opinions of the jurors who may have different backgrounds and perspective from yours. So those are the procedural instructions. Mr. Radowitz, are you ready to proceed with your opening statement?
I am here.
All right, you may proceed.
So good afternoon, everyone. It's been kind of long, so hopefully we'll be quick here. We can all get you out to lunch and get you paid. But so again, just to reintroduce myself, my name is Jeff Brodowitz. I'm the assistant prosecuting attorney here on this case. So as Judge stated, today we're here for a trial on a charge of assault and battery. Now, assault and battery, as the judge explained, is essentially just a offensive, forceful, or violent touching of another person or something closely connected to them, or the apprehension of that touching. No injury is necessary in this. Now, there are a couple of different ways, I guess, that we can describe crime. And one of those is called a crime of intimacy. It's an intimate crime, meaning that it's not, like a giant bank robbery that's out there somewhere in the city and everybody sees it. This is something that happens in people's homes. This is something that happens between very few people. You're going to hear very few witnesses, and you're going to have to judge the credibility of those witnesses. Now, the people here today expect that the evidence we will show, or that we will present, will show that Miss Mary Carlisle and the defendant, Miss Trina Austin Morrison, were roommates, and they were living together at 4719 Bristol, which is in the city of Lansing, which is in Ingham County. That on February 8th, 2022, the defendant came back to that residence and began to scream and yell at the victim, Miss Carlisle. Then, as this altercation proceeded, Miss Carlisle attempted to leave the situation, and Miss Trina Austin Morrison proceeded to follow her throughout the house, screaming at her and intimidating her. Miss Carlisle eventually was able to call 911, but that call was disconnected during this altercation. People also expect the evidence will show that during this altercation, Miss Carlisle was thrown up against the wall by Miss Austin Morrison and was then again shoved into that wall. Then finally, the people expect the evidence to show that Officer Lodgson from the Lansing Police Department responded, took a statement from Miss Carlisle, and based on the information that she garnered from that, decided to make the decision to arrest the defendant on charges of assault and battery. So that is, as I said, what the people expect the evidence will show. And that at the conclusion of this trial, after we have shown that evidence, we would ask you to return a verdict of guilty. Thank you.
Opening statement defense.
That's what the state expects to show you and as far as evidence. But what they haven't said is some of the other evidence that you're going to hear, including the fact that the victim's own mother also witnessed this incident and is going to be testifying that none of this happened. That she wasn't in a healthy mental state at the time, her daughter. And that there's been some incidents between Ms. Carlisle and Ms. Austin Morrison where Ms. Carlisle was the aggressor, was the person initiating that. You're also going to see information that if Ms. Carlisle was feeling so threatened at the time that she's following Ms. Austin Morrison out of the house as she's leaving in the car. That's what the evidence is going to show in this case. That Ms. Carlisle is lying about this case. And I want you to just have that open mind and consider everything. And remember when the judge talked about those jury instructions and the credibility instructions and how it's important to watch body language and how people are speaking, not just what they say. Because I think the evidence is actually going to show that Ms. Carlisle is going to get up here and she's not going to be telling the truth. So just keep that in mind. Listen to everything that comes your way. And I think at the end of the day, the evidence is going to show that Ms. Austin Morrison is not guilty.
Thank you, counsel. Counsel, approach. All right, so you've heard opening statements, and we are timely, which is never said in this court. So what we're going to do is we are going to let you break for lunch, all right? And we're going to give you till probably 1:45 to start reassembling back here on the 6th floor. So you'll have lunch on your own till 1:45, and then we'll try to start at 2. But that should give everybody enough time to do what you need to do. And then to get back here. In the meantime, I have a docket at 1:30 that I'll be calling some cases, but it's a smaller docket. So what we'll do is we'll have you consolidate and put you in the jury room. My court officer, Nathaniel Neves, will show you where that is. But at this point in time, I think this would be best to get back here about 1:45, and we're adjourned till lunchtime, all right? All right, so you're all set. We'll rise for you and you can leave on your own. Make sure you grab anything you need.
Yes.
All right, we'll make sure the doors closed and we're back on the record in docket 23-00442. Anything to come to the court's attention will adjourn till 1:45 to 2, depending on the court schedule, for witnesses to continue, and we'll hear testimony. Anything else, Mr. Brodowitz?
Briefly, Your Honor, I would just like to mention, there was mention in the police report, and I believe that Ms. Robinson alluded to it in her opening statement. There is evidence based on the police report that there was a PRT done at some point around this matter, and I would just object to the entrance of that evidence as based on relevance in this matter.
All right, Ms. Robinson, anything regarding that? The opening statements are not evidence,
Right.
so there's a preview of the evidence, and so there's actually no tangible evidence of that. But if it comes up during the trial and you want to make an objection, I think that you've objected that there was a notice of it now, but there's no evidence or tangible evidence of it at this point in time. And you're free to remind the jury if it doesn't come in, in closing arguments, both sides, obviously. Anything else, Ms. Robinson, on docket 23-00442?
No, Your Honor, thank you.
All right, we'll see everybody back here. I got a 1:30 docket, as you know, and Ms. Sutter
Yes.
knows. So, but it'll be 1:45 to 2.
Yep.
Sure.
Yeah, I believe Mr. Pfeiffer is going to be here on the one sentencing for,
Okay,
but
all right,
if not, I'll be.
all right. Ms. Duke's probably the big probation violation.
Yeah.
So we're on the record in docket 23-00353. That's people of the state of Michigan versus Chalery Clark. Will the parties please introduce themselves for the record?
Yes, good afternoon, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Good afternoon, Your Honor. May it please the court, Leah Marine on behalf of Mr. Shore Clark.
All right, and sir, you are Chalery Clark? All right. This is the time set for sentencing on this file. Mr. Pfeiffer, have you had the opportunity to read the pre-sentence report?
I have not, Your Honor. I never received that.
Okay, did you want to read that?
If I might, I only need a minute at most.
And counsel, you've had the opportunity to read the pre-sentence report.
Yes, sir.
And you've gone through it with your client?
We have.
Any additions, deletions, or corrections?
We would ask the court, because it is left to the court's discretion, that to the issue of ankle tether, we ask that the court remove the tether for the duration of probation. Given the totality of circumstances, it's placing a significant burden on Mr. Clark. You know, it's approximately $65 a week for that service. It's also affecting his ability to achieve part-time employment, which he would like to engage with so he can help make his child support payments. Miss Jack, as you know, is a co-parent with Mr. Clark, and it is our position that $65 a week would be better spent on child support payments than court monitoring services. And given the fact that he is a moderate and low risk subject, we feel that the burden outweighs the benefits.
Thank you. The so other than the tether, are there any additions, deletions, corrections to the report in regards to how it was any employment additions, deletions, corrections, or anything that you saw?
Yes, there's a change of address I filed.
You did?
Yes, yesterday with the court. I also have a physical copy with me as well.
I have the change of address, a change of personal information in regards to, it's a 11574 Meadowbrook.
This is, yep. That's
all right.
Correct.
And that's, all right. Mr. Pfeiffer, you had the opportunity to see that, just a change of address with the court. So I'll put that in the court file. I don't think that's an order for me to sign anywhere.
I don't believe so. Just to check, Meadowbrook, would that be in Lansing?
Yeah, that's, no, it's in Warren. 11574 Meadowbrook Drive, Warren, Michigan, 48903. 48093 is what I have. Does that sound right?
Yes, I believe so.
Thank you.
And we can provide a copy of that if you need it. So
That'd be appreciated for the file.
all right. I'm sorry. Yeah, I thought so. Maybe not. Did Mr. Pfeiffer, have you done your appearance for the record?
Yes.
Yeah.
I did.
All right. So, yeah, and I know council has in regards to the pre-sentence and the additions, deletions, corrections that have been indicated, the only one was a change of address that's in the file. We will go to allocution. First, I will go to Mr. Pfeiffer, and if you have a victim, I'll take the statement, and then I'll go to yourself and your client. So, Mr. Pfeiffer.
Yes, Your Honor. The victim, Deja Jack, and her family are here. I spoke with her. She provided me with a written statement she would like me to read to the court on her behalf.
All right, you may proceed.
Thank you. Dear Judge, first I want to thank you for the chance to speak to you about Chalery Clark today. I've already spent a considerable amount of time in various courtrooms involving Chalery lately, which is a strain on me since I'm the sole provider financially for our son. I hope you'll take this letter into consideration as you prepare to sentence Chalery. I'm sure Chalery will attempt to paint himself, me, and the November incident that happened a certain way that is nowhere close to the truth. And that's why it's important to me that you hear from me about the incident and its impact on not only my life, but our son's. Chalery's actions on November 10th have had a big impact on me. For Chalery to come into my home, push me around, proceeding to call me names like lousy ass bitch, threaten to shoot someone I was dating who happened to be outside in the car waiting on me in the driveway, take things I purchased for our son with my own money, and walk around for months without any charges or action was unsettling. It shook my sense of safety and protection. made me so anxious that I had security surveillance cameras installed both inside and outside of my house. I began locking both doors and windows obsessively. It made me wish I never had to spend another moment around Chalery because I don't trust his ability to control his temper. But beyond the sense of being unsafe, to be honest, I'm humiliated and angry because he acted this way in front of our 3-year-old son, which I never thought in a million years he would have the audacity to do. Our son watched his father act a fool, pushing me around, at times telling my son directly that I was a lousy-ass bitch. Our son watched him barge into my house without having been invited inside, throw a diaper bag in my face, and having hit me with it, as well as heard him threaten to shoot the man that my son loves like a stepfather figure, and watched his dad take things that weren't his to take. No mother wants her son to see her being treated that way. This was the type of nonsense I left behind to protect my son and I from. I didn't want our son to end up the same way, treating women like crap. But here we are now, with a son who can't control his anger, tells his daycare provider to shut up, bitch, throws things and hits people. This hasn't just impacted me, it's impacted our son. I want you to know that this was not the first time I've called the police on Chalery. If prosecutors had had the courage to take my prior case in 2020 forward, this would be his second domestic violence sentence. I just want you to know who you're really dealing with. This wasn't a one-time disagreement or some overreaction on my part. As I previously mentioned, Chalery and I have had numerous court dates for child support as well as for my PPO, in which he has lied about the facts that relate to this incident. He has perjured himself numerous times now, and nobody has paid enough attention to it. He initially claimed to Judge Garcia that he and I were actively in a relationship when this incident occurred, and that this was retaliation and proof that my family had some sort of vendetta against him, which is ridiculous. Then he said I invited him into my home, then refused to give him my son because he claims he told me he had a girlfriend and I attacked him, which is also not true. Why would I attack someone over them having a girlfriend when my boyfriend was in the driveway? No story that he has tried to spin has made sense. Chalery is going to say he was, quote, invited, unquote, to my home based off a text sent a day or two before the incident, where I said he could pick our son up from the house at 7 p.m. due to my parents being gone. We were normally doing handoffs at their house. I also told him to let me know if he would be coming, which he didn't. He previously missed getting Carter 2 times prior to the incident, so when I did not receive a text or call, I assumed he would not be coming to get our son. I was outside putting the car seat in my boyfriend's car when Chalery arrived. When I saw the car pull up next to my mailbox, I could see Chalery in the passenger seat. So I stopped what I was doing and went into my home and proceeded to put Carter's coat and shoes on. My front door flew forward as Chalery entered my home. I learned afterward that while I was inside putting my son's shoes on, that my boyfriend saw Chalery getting out of his car, and Chalery began to walk quickly towards my residence. My boyfriend told him there was no need to enter my home. Yet Chalery proceeded to open my front door and barge into my home as I was getting my son ready to leave. It seemed like a power move, especially because we had completed 100 handoffs. 98% of the time, Chalery never got out of the vehicle, whether it was myself bringing our son out or any of my family members. He would sit in his car and let whoever was there put Carter into his car. He called me every awful thing he could think of, and it felt as though he wanted to get a reaction out of me when all I wanted was for him to get out of my house, which I asked him to do numerous times. While Chalery's record might seem clean now, Chalery has a long history of breaking the law. He was no stranger to probation. He was on 2 different probations for a counterfeiting case and a gun case while we were together between 2018 and 2021. I watched him hustle as con his way with probation officers while doing all kinds of things that violate his probation. Doing drugs, moving addresses, leaving the state, failed tests, missed meetings, getting new charges, were all things he should have been violated plenty of times for. So if he's getting probation, just know he thinks it is an absolute joke. As a matter of fact, I know that he's even moved since this case started without saying anything to anyone. He told our child support judge during his show cause hearing on March 28th, he had given his 30-day notice at his previous residence and claimed he did not have anywhere to go but would be staying with his mother, which was a complete lie, as he is now living outside of Lansing. I would bet my life on the fact that he has not let the courts know. I wouldn't doubt that he did not let whoever is in charge of monitoring his tether know either. Now I can't even get service of a PPO extension because no one who is supposed to know actually knows where he is living. Chalery is a swindler, so much so that he could do something horrendous right in front of someone and talk his way out of it with lies, because that is what I have witnessed him do for years. Chalery's family speaks on his behalf. You should take that with a grain of salt. When this incident happened, his own mother told me she hoped, quote, my next boyfriend would beat my ass, unquote, via text message that she sent me following the incident. and that I should always just call her and not the cops when he acted up. They'd rather pretend and shield him than hold him accountable for his actions. Each one of them knows exactly what he has done, the lies he have told, and they have continued to be an accomplice in lying to the courts. My parents will be in attendance today and can attest to my truth. They have each witnessed these proceedings and shenanigans for years. I know this court can impose restrictions and requirements while he is on probation, so I'd like to request a few things to be imposed if you order probation. Random drug and alcohol testing, complete anger management treatment, complete parenting classes, maintain full-time employment, proof of employment and income, and no contact with me. Thank you for hearing my concerns and perspective regarding Chalery and his sentence. If I could say something to Chalery, it would be shame on you for not being a better example for our son. He deserves better than you. As the mother of your child, I deserve better. I deserve respect for the crap you put Carter and I throughout the years. I carried the load and I'm still carrying it. And this is the thanks I've got, being physically and verbally bullied by you. And while you and your family can sit in court and pretend as though you're the victim here and that I should just put up with whatever nonsense you pull, your soul and God know the things you've done. I thought for once in your life you would be a man and tell the truth and own up to your wrongdoing. For once again, you have proven that you are a narcissist. If you said that you blacked it out, I would genuinely believe that given how angry you were. But to lie and act like I attacked you or pretend as though nothing happened is insane. I'm making my stand. I'm done. I don't want to see you. Don't want to talk to you. Don't want you to ever come to my home. Don't send any more people to my home to scare me or shut me up. Don't tell my son to tell me anything or to call me names. Don't tell him that he should hate me or my boyfriend. Just stop all of the shenanigans. I want better for me. I want better for our son, and we deserve better. I hope for your sake and our son's that you wake up and get yourself together, because your son deserves more than a dad who lies, batters, and bullies his way through life and disrespects women. Let him grow up to be better than you. I would love it if you would stop teaching him words and behaviors that can put him exactly where you are and have been. Be decent enough to do right by him, or just leave us both alone and give him a chance at a good life. Sincerely, Deja R. Jack.
All right, Mr. Fifer, any comment from the people?
Your Honor, the agreement in this matter was for the defendant to be sentenced to 7-6. I apologize. My brain is stopping there for a second. To the probationary program under the domestic violence law, if he is eligible. I do not believe that he is ineligible. I would ask that you sentence him to probation under that law. I would ask that you grant Ms. Jack's request. Further, I would ask that he have to complete batters intervention programming, not simply anger management, as batters intervention programming is more specifically designed for domestic abusers as opposed to just anger management. And while I know defense is asking his tether be removed, given Ms. Jack's statement, as well as the original charge of this matter, I would ask that the tether be imposed.
So the Kilbur agreement was 769-4A if eligible. Is that correct?
That's correct, Your Honor.
Okay, and he is eligible.
Yes, Your Honor. I do not have anything stating he is not.
All right. Do you have any? You can still do 769-4A and be put on probation. There was no agreement of no upfront jail. Is that correct?
That's correct, Your Honor. On that front, I would leave it in the court's discretion. However, I will note that the people have concerns about the defendant actually taking this seriously and accepting responsibility. When he pled guilty at this hearing, we were here last, he had the victim served with paperwork to terminate the personal protection order, as he tried telling the court that order was no longer needed, even though he had just pled guilty to assaulting that victim. That is concerning behavior.
Right. All right. Allocution from the defense.
Your Honor, Mr. Clark has had the opportunity to share with me his personal remorse, and I know he's prepared to share that with the court today. Before we allow him to do his plea allocution, I would again like to draw attention reference to Ms. Jack's statement that she is under financial burden and stress. And again, the cost of the ankle monitoring is approximately $65 a month. That is money that would be much better spent on the minor child that the two parties are co-parents to. It's my understanding that they have a third-party arrangement for pickup and drop-off. And given the fact that Mr. Clark has moved some 90 miles away, he poses little to no threat to the victim here. Again, and if I may remind you, that was one of she had several specifications and requests in her statement. None of them included ankle monitoring. So we again ask that the court take that into consideration, and Mr. Clark is prepared for his plea allocution.
My understanding is that the Killebrew agreement was that 769-4A if eligible, which he is eligible, but there was nothing indicating about jail time. Is that correct?
That is our understanding. There is no jail time.
No Killebrew agreement as to no jail or anything like that.
Correct.
Correct, Your Honor. The only Killebrew agreement in this matter is that he's sentenced under 769-4A if found out.
Okay. Mr. Clark, is there anything you'd like to pass on to the court before the court passes sentence?
I just want to honestly just be honest and like I'm sorry for the situation. Understand how serious situations can turn into certain problems, and like I said, I'll try to take every single step I can to prevent any of these problems that they would have to ever again. I said, for example, one is even just leaving the city that we're both residing in from, just kind of make things a little bit easier for me and for her as well. Then so we have a child together, and at the end of the day, we have to both be there for our child. Some point, regardless of what we got going on, court wise, and we still have to be there for our child. We have to be good examples to our child. Like she said, I could be a better example for my son.
Well, the court's had the opportunity to hear all of the argument concerning the Killebrew. I will abide by the Killebrew and indicate that 769-4A is granted pursuant to the Killebrew agreement. This is for a count 2 guilty plea to domestic violence, 750.812. The court is in regards to quite frankly, the tether is an afterthought right now for me. The real question is whether you should spend some time in jail. Okay. I'm gonna abide by the probation for 12 months, but you've been on probation before. Okay. You have a prior CCW charge, I think, which some people consider a non-violent offense. I consider it I don't think being a gun enthusiast myself, I don't think guns stand for nonviolence. Okay. There's a fear in me in that. I want this to mean something, this sentencing to mean something to you, because you have a lot of people who care for you, and the fact that you're on a road to send you someplace where they're going to visit you once a week for the next 5 to 10 years. This was a home invasion first to start with. So, I mean, while you're blaming everybody else under the sun, maybe you should start reflecting on whether this is something you really choose to do, because the prisons are filled with individuals who don't get to see their children. And that's not a place for anybody. It's not a place for anybody. So I'm going to somewhat follow the recommendation, but I'm somewhat not going to follow the recommendation. Okay. I'm gonna sentence you to 17 days in jail, credit for 3 days in jail. So that's 14 days. Okay. 14 days in jail. I'm going to suspend the remaining 30 days that I'm ordering. So that's 54 days in jail. I'm suspending the remaining 30 days if you complete probation successfully. Probation is going to be for 12 months. All right. I'm going to grant your 769-4A status, which really is the gift today. Okay. It's really the gift. That Killebrew that means that if you complete your probation, you get that status. Okay. And that status is huge today. If you violate your probation, I will remove that status. And then this just becomes another abstraction. And that's what you don't want. I want no contact with victim Dejavac to be within 2,000 feet of where she lives, works, goes to school. No assaultive behavior, no use of possession, alcohol, marijuana, controlled substance, no submit to random PBTs and or urinalysis, no bars or nightclubs. I do think that domestic abuse counseling is in order. I'm gonna order you that once you're able to to get out, you obtain and maintain employment. You're not to purchase any firearms, possession firearms, ammunition, weapons, or any kind. I'm going to order tether when you get out. We will revisit that because I'm going to see you for the next 12 months. All right. I'm going to get to see you. Now, if in the next 3 or 4 months, if you come to me and you say this tether, I have not had any contact. This tether is still a problem. I'm going to take you at your word, but that's 3 or 4 months from now. All right. Today, tether's not on the table because I'm truly wondering if this time in jail is going to be enough to spearhead whether you should maybe reflect on some of your activities in regards to things you've done and in things that your father now. And you've indicated to me several times, you've said, I want to be there for my son. Okay, I want to be there for my son. Well, I'm worried about you being there for your son 5 years from now, not 5 days from now. I know where you're going to be. All right. You're going to be locked up for a while here, and you need to reflect on why and what you're doing so that when you get out, you can be the person you hope to be. I want you to be the person you hope to be. All right. That's what's important to me. All right. And that's what's important to your son. So be that person. Okay. Be the person you want to be, not the person you are right now. GPS tether is ordered as requested, but I will revisit it as part of your probation. All right. Anything else for the record? Docket 23-00353, Mr. Pfeiffer.
Not from the people, Your Honor.
Anything else, sir, from your counsel? Oh, I'm going to waive fines and costs. Yeah, I'm going to waive fines and costs.
I can't hear you. Thank you, Your Honor. No further points on our end.
All right. So probate settled. The sentence has been issued. You can go with the court officer, and we'll revisit this. Mr. Clark, good luck to you. Okay.
Thank you, Your Honor.
Yeah, I said, so what I did was, I said 54 days, he does 14 in jail. I know I did 14 days in jail.
54. 40.
So make it 30, just whatever. We'll suspend 30 days. No, I wanted, so it's 17 minus 3 is 14. Okay. I'll leave that aside. All right. Ashley Hernandez.
Yes, Your Honor, she's in the hallway.
All right, let's do that case and then. I'm gonna write CJOS. I did not. But he's on probation. already. There's an, okay. Parenting classes are striking. Matters intervention, GPS.
No, we're talking about elite. Yeah. Who's that guy? They gotta go down.
I would double check.
So make sure they know it's, it's
I was thinking
14
about
days in jail.
I did.
Yeah,
I remember that.
all right.
Okay.
That is Clark. Clark, you tell me if you need anything else. That, because that was a little, well, no, me too. That was a little different.
I'm trying to run away.
All right, so we're on the record in docket 23. Listen. So we're on the record in docket 23-00178. That's People of the State of Michigan versus Ashley Lee Hernandez. Will the parties please introduce themselves for the record?
Jeff Braddock's on behalf of the people, Your Honor. Thank you, Your Honor. Good afternoon. Jared Austin appearing on behalf of Ms. Hernandez. She is present to my right.
And ma'am, you are Ashley Hernandez?
Yes, sir.
All right. This is the time set for a sentencing in the matter. Mr. Brodowitz, there is, I do, just for the record, I do have a pink sheet of restitution. Is that correct?
Yes, Your Honor.
And that restitution pink sheet is for $28,127. Is that correct?
I believe so, Your Honor. I was just looking to see in our file here.
I'm just double checking the figure.
Mhm.
All right.
I believe that is the correct figure.
All right. So restitution as part of the order to Ingham County Animal Control would be that $28,127.
Yeah.
All right. I think we might add that to the order just to have it. Mr. Austin, you've had the opportunity to go through the pre-sentence report with your client.
Yes, I have.
Any additions, deletions, or corrections?
Just a couple minor ones, I believe,
Okay.
Your Honor. It does list on the cover page a matter at the 54A District Court here that was still outstanding. Ms. Hernandez informs me that she has taken care of that.
Okay.
And I don't believe the pre-sentence report reflects the Killebrew agreement to no upfront jail anywhere that I can see.
Yeah, and I noticed that in the sentencing, in the plea sheets, that it was a Killebrew of no jail. Is that correct?
That is correct, Your Honor. And with that, no further corrections or updates to the report, Your Honor. And I just would note, Your Honor, that we would be requesting a restitution hearing for the requested restitution amount.
All right, so in regards to we will set it for restitution hearing. That's a large number. Just to break down that number for $28,127. Any allocution, Mr. Austin?
Yes, Your Honor, thank you. Your Honor, Ms. Hernandez, any prior criminal history she has is rather sparse. It is limited to nonviolent misdemeanors. So other than this, Your Honor, her criminal history is rather limited. Did acknowledge and take responsibility for her part in this. I think this was a situation, Your Honor, where she felt overwhelmed that she was with someone else that had these animals. I think these animals ended up in Ms. Hernandez's care, and she was overwhelmed with what to properly do, although she did take some measures, I believe, Your Honor, to care for them as best she could. But obviously, fell short, or else we wouldn't be here. Given that, Your Honor, I do find a term of probation to be appropriate. Ms. Hernandez has been compliant with the court's orders while this case has been pending. I would ask for a shorter term of probation than what is being recommended, Your Honor, other than the maximum 2 years of supervision. I think the court can
assess a smaller amount of probation, and if need be, the court can always add to that. But I would ask the court to consider a lesser amount of probation and to abide by the Chalery agreement and not impose any upfront incarceration at this point. Thank you.
Okay. Just for I'm assuming the 24-month probation is because restitution would be paid as a part of that probation, and it's so high.
That's possible, Your Honor, although obviously, the court still has other means of enforcing that. It's whatever the restitution amount ends up being, Your Honor, it's doubtful that Mr. Hernandez would get that completely paid for
Right.
during a term of probation, given that she's on disability and has extremely limited income. Obviously, the court can enforce that with some type of civil collections after she's discharged from probation.
All right, Mr. Brodowitz, any comment on the judgment of sentence or the pre-sentence report or on sentencing in this matter before we hear from Ms. Hernandez, give Ms. Hernandez the opportunity to speak?
No, people leave it to the court's discretion.
All right, Ms. Hernandez, this is the time, I think Mr. Austin has spoke eloquently on your behalf. Anything you would like to say to the court before the court passes sentence?
No.
All right. So this is in regards to docket 23-00178, sentencing as a guilty plea to count to the animal abandonment and cruelty 2 to 3 animals. I'm going to follow the recommendation requested with a little bit of a change. Spent 100 days in jail beginning May 9th, 2023. Credit is given for 0 days previously served, and I'm going to suspend 180 days in jail upon successful completion of probation, which would be in line with the Chalery agreement today. Okay. I'm going to waive fines and costs at this time, because whatever you have, you're going to have some restitution in this case. Okay. Crime victims' rights fee of $75, state minimum cost fee of $50, restitution to be determined. So we will set this for a restitution hearing in order to indicate what restitution is going to be in this matter. I'm going to limit probation here to 12 months. So that would be $360 for probation. No assault or threatening behavior, no use of possession of alcohol, marijuana, submit to random PBTs, no bars or nightclub. There is mental health counseling that it appears you've started. You should continue with that. That's important in this case. Do not possess or own an animal of any kind during the term of probation. All right, ma'am? With that, so I will need so I'm going to say follow JOS, but restitution to be determined, and probation is 12 months. And I'm waiving fines and costs. So let's have a date set out for a restitution hearing date. It's probably, I'd say 30 days out, I would think. Something so that we have enough time to see what's coming in and take a look at it. So what's a good restitution hearing date?
Tuesday, June 6th.
Okay, so it's June 6th at 3 o'clock. And then make sure, Mr. Mr. Brodowitz, that you provide Mr. Austin with any information you receive. So we may or may not need a hearing on that date, but that would be a good place to start in regards to hearing testimony concerning the $28,000 restitution amount. Anything else for the record in docket 23-00178, Mr. Brodowitz?
Nothing from the people here.
Mr. Austin?
Nothing further, Your Honor. Thank you.
All right. So ma'am, just to summarize, it's 100 days upon successful completion of probation. I've waived fines and costs. We're gonna have a restitution hearing. The mental health counseling and not to possess any animals are the two largest part of the court sentence today, okay? All right. Good luck to you, ma'am.
Okay, thank you. Thank you, Judge.
If you go right now, they can set you up. So yeah, on the 5th floor.
Okay, thank you.
This goes to Mr. Chris. Mr. Clark. Yeah, that's a change of address. Right, and we have Miss Duke. So we're on the record in docket 21-02940. That is People of the State of Michigan versus Ariana Duke. Will the parties please introduce themselves for the record?
Jeff Brodowitz on behalf of the people, Your Honor.
Good afternoon, Your Honor. Assistant Public Defender Lawrence Sutter on behalf of Ms. Duke, was standing to my right.
And ma'am, you are Ariana Duke?
Yes, sir.
All right. This is the time set for a PV arraignment and a probation violation hearing. I'm going to arraign you on the new allegations that have been presented against you. One of them has been dismissed, all right, pursuant to, I'm sure Ms. Sutter has talked to you about that. And then we're going to talk about where we go from here in regards to this case. I think we've all decided, because we have a jury trial out, that this is probably best left to another date to consider what our options are, okay? So in a request, and so as part of the probation violation arraignment, at a request and summons for probation violation signed by Jody Bayless on April 25th, 2023, co-signed by myself on that date, it is alleged that you failed to refrain from marijuana per Avern Health on March 28th. You tested positive. On April 4th, you tested positive for marijuana. And on April 14th, you tested positive. Do you understand the nature of that probation violation that's been brought against you, ma'am?
Yes, sir.
All right. It is alleged that you failed to attend MRT per cognitive consultants, that you were no-show on April 24th. Do you understand that, the nature of that violation? All right. I do have, as dismissed as a part of this, the new charges that were brought concerning the new police report and the assault or threatening behavior. That's been dismissed. The prosecutor denied the charges and received new reports where you may be the victim in that case. All right. With that understanding, you know you have the right to counsel in a hearing in that matter. You, of course, have Ms. Sutter on the other matter. I'm assuming you're going to get her on this matter too. And then we're going to wrap this all up and put this together. So for a restitution hearing date, and we're probably looking at some testimony on that date, because I don't know if Ms. Sutter told you, but the recommendation right now is that they want to terminate your probation. All right. That's the recommendation, but we're going to sort this out. All right. We're going to sort this out. I don't know if probation's the right thing for you, but we're going to set some time aside to have a hearing on it. All right. I think that's the way to do this. That way, Ms. Sutter also has all the information she needs in order to zealously represent you. Okay. So I'm going to indicate that you were arraigned on the new charges. And we are going to set a PV hearing for both the old charges, which we're set for today, and the new charges, which are essentially dropping dirty charges. And we'll set that for, and Ms. Sutter, how much time do you need in order to?
I would say at least a couple of weeks, Your Honor. I don't know how long it'll take to get some information. And it sounds like from Ms. Duke that Ms. Bayless might have some helpful information for me. So I'd say at least a couple of weeks.
Okay, so 2 weeks or so it'll probably be 3 weeks.
I don't have a problem with that personally. Can I do it on Thursday?
Sure.
Friday?
Yeah. If it fits with everybody's schedule, we'll just give it its own time slot.
Let's do. Let's do 9:30 on Thursday, May 25th.
And May 25th at 9:30, does that work? Okay.
No, the 26th didn't room this morning. Double check 25th. Looks like I'm okay there as well.
All right, so May 25th at 9:30 for formal hearing. Mr. Brodowitz, you have that date?
Yes, sir.
All right. So Ms. Duke, in the meantime, please stay out of trouble, and we'll come back here on that May 25th date and see what our options are, okay? All right. Anything else for the record in docket 21-02940? Mr. Brodowitz.
Nothing from the people, Your Honor.
Ms. Sutter, are you all set today?
I'm all set.
All right, thank you. Let's have her up here. And that's a live hearing?
Yes.
Yeah, okay. How did I do with Ms. Austin's car? I probably did. All right. So, Mr. Brodowitz, when we have the, we'll bring the jury back in when we get Ms. Robinson and.
I'm right here.
There you are. Okay.
But what information I get?
All right, so we're back on the record in docket 23-00442.
Yes, you are.
Okay. Okay, I just want to make sure everybody's here and then we'll bring the jury back. So, Mr. Brodowitz, you're ready to proceed. Once Mr. Neves gets rid of the files, he'll bring the jury back in, okay?
Okay.
All right, Ms. Robinson, are you ready to proceed now?
I am. I just have one correction for the record to make.
Okay,
My witness's middle name is actually Francis, so it's Mary
It's
Francis
F?
Carlisle. I got it wrong. I'm
okay,
sorry.
that's all right.
Right, well, the victim's middle name also starts with an F, but hers is Fontina.
All right, so we'll do a Mary Carlisle and a Mary F. Carlisle.
Sure.
Okay, that's just to show the difference. Mr. Brodowitz, are you ready to call your first witness?
Yes, I am. Your
You
Honor.
may proceed.
Your Honor, the people would call on Miss Mary Carlisle.
All right, Ms. Carlisle, I'm gonna have you come approach the bench. Right, you stand right in front of me and please state your first name and your last name and spell both for the record.
Mary Carlisle, Marycarlisle.
But please raise your right hand. You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury.
Yes, I do.
All right, please have a seat and please project for recording purposes. Mr. Brodowitz, when you're ready.
All right. Good afternoon, Ms. Carlisle.
Good afternoon.
Ms. Carlisle, where do you currently live?
4719 Bristol,
Okay, and is that in the city of Lansing in Ingham County?
48910, Lansing, Michigan.
And did you ever live with anyone at that address?
Yes, I did. Well, when she was there, she wasn't hardly ever there, but when she was home, yeah.
And who was that?
Trina Austin, Morrison. Austin.
And do you see Miss Austin Morrison in the courtroom today?
Yeah, I do.
Okay, and can you identify something, can you identify where she's sitting in an article of clothing she's wearing?
She's wearing a peach-like shirt and she's sitting right next to her attorney.
Please let the record reflect that the witness has identified the defendant.
Any objection to the witness identifying the defendant, Ms. Robinson?
No objection.
Without objection, the witness has identified the defendant.
All right, so Ms. Carla, I want to bring you back to February 8th of 2023. And so you, were you living at 4719 Bristol at that time?
Yes.
Okay, and as I believe you stated previously, you were living with Miss Austin. Were you living with Miss Austin at that time?
Yeah,
Miss
yes, I'm
Austin
still,
Morrison?
yes, yes.
Okay, and on that date, did you happen to call the police?
Yes, I did.
And why did you call the police on that date?
Because that day, her and my mother came over to the house. Well, she followed me around the house telling me I was a horrible mother. I don't honor my mother. She was yelling in my face, she put her hands on me, and I'm going through different rooms of the house, taking pictures because, you know, I'm gonna respect my mama to a certain degree. But, so she came over there to fight with me.
Okay. So you said that her and your mom came over to the house. She was yelling. What was her demeanor like when she entered the house?
Like she was coming to take care of some business, like manly.
Okay.
Aggressive.
Okay. And you stated that she was when she came in, she was doing some yelling.
Yes.
What was, you know, what were some of the things she was saying to you?
She told me that, so whenever I was bent over in the picture, she told me that's why no man want me, maybe because I don't shave my vagina hairs. I need to learn to shave my vagina hairs and a man will want me. And in one of them pictures, she told me that because I walk around with the attire I wear, my daughter should be ashamed of me. I don't know how, she ain't never really met my daughter and talked to her, but she was in front of my mother that I need to honor my mother.
Okay. So you stated she comes in and she's yelling at you in the house.
She didn't start off yelling.
Okay.
She started off still aggressive, but not like yelling until I started making facial expressions. And I think that might have upset her just a little bit.
Okay. And what room in the house did this, well, first of all, I guess I should ask, is 4719 Bristol, is that a single family home, an apartment? Is it?
It's four bedroom, 2 bath house.
Okay, so it's a single family home?
No, 4 bedrooms, it's 3 floors.
Okay.
Basement.
But it's a house.
Yes.
Okay. In what room of the house did this altercation start in?
It started in the kitchen when they walked in the door.
Okay. And so after Miss Austin Morrison comes in and she's yelling at you, what did you do?
Oh, I just laughed. I looked at her and was taking pictures with my phone, and just long as she wasn't in my space at that time. And so I was just listening to her ramble on about me getting help.
Okay. And then so when you said she wasn't in your space at that time, did there come a point in time where she got into your
That reactionary gap, 6 feet. Oh, there's a lot of times she did that.
Okay.
In
And
the
when,
living room, upstairs in the bedroom.
okay. So when was the first time you would say she got into your
In the
space then?
kitchen.
Okay. And then so when she did that, what did you do after that?
I'll get up and walk to another area of the room,
Okay. You walked to another area of the kitchen or another room of the house?
the living room.
Okay.
The living room.
So you walked to another room in the house.
Yeah.
So then when you walked into the living room, what happened after that?
She followed me in there,
Okay. And what was she doing at that time?
yelling at me.
Okay.
Still.
Yelling and screaming?
Yes.
And when she followed you into the living room, how did that make you feel when she did that?
You want my honest opinion?
Yes.
I felt like I should have defended myself, but I didn't.
Okay.
I wanted to.
So then, so she follows you into the living room and she's still yelling at you. What happened after that?
Well, she was constantly yelling and in my face, and I didn't pay attention to some of the stuff she was saying, because it really didn't. It could have been, I might have been a hoe and all this stuff. I don't care. But the things that she said that disturbed me was the 3 that I mentioned that stuck with my head.
Okay. And when she followed you in the living room, did she continue to, invade your personal space?
Yes.
Okay. And so after she follows you in the living room, she's, in your space again. What did you do after that?
I'll just sat there, and it was different periods of the living room that we went around, and so it was like we playing cat and mouse. So I move and she'll follow me, and it was.
Okay.
And I listened to her scream.
Right. And was there a point in this altercation where you went to the second story of the house?
Yes.
Okay. And why did you go?
Because she was trying to throw my baby's antiques pictures, my bags with all my daughter's not personal, but memoirs that she made for me, trying to throw them out the house.
Okay, and so it's when you went upstairs, did the argument or the altercation continue when you went upstairs?
Oh yeah, she was yelling at me, but
okay.
Yes.
And did there ever come a point in time where you went into a bedroom upstairs?
Yeah, we went into that. No, I never really made it to the bedroom. I was in the hallway by the back. She was more so in the bedroom at that time, and I'm just trying to grab my bag. So we were in the hallway, and I'm holding my phone and both my phone and trying to keep my foot on my bag. So we ended up in the bathroom that's where I ended up falling from her pushing into the bathroom.
Okay. So you said you ended up in the bathroom and you said she pushed you while you were in there?
I tussled either with the bag or her tripping over her. I ended up landing on the ground in the bathroom. So I can't necessarily say that I ended up on the ground. So
okay.
I can't definitely say it.
And so then after you ended up on the ground in the bathroom, what happened?
She was yelling at me and I just started dancing on the floor and taking pictures. She was just holding me in the bathroom and she was yelling.
Okay, and was Miss Austin Morrison allowing you to leave the bathroom?
Oh, no.
Okay. And so did the confrontation end in the bathroom there?
No, we got back downstairs.
Okay.
And as I'm like sitting there on that's the picture when I had her bent over, and as she was getting closer, and I roll over to the couch and I end up on the end of the couch. And that's when she was in my face, and I was sitting here, and my mom was behind me, and I made the face like I don't even know why she's here.
Okay. And then did the altercation end up back in the kitchen at any point?
Yeah, we end up in the kitchen. We ended up all throughout the house, the kitchen, the living room. Yeah, she choked me in the kitchen because of a bake. She choked me. That's what she choked me at the kitchen.
Okay, and when you say she choked you, what would you
behind.
describe that?
She just did it. I had my head down and she just pushed my head down into the, it was something there that was holding me over and that's when she pushed my head down. She choked me from behind, hold me down, put it on top of me.
All right, Your Honor, just let the record reflect that the witness has described an action where she was leaning forward and the defendant's hands were on the back of her neck or her shoulders and pushing her head down.
Okay, the record may so reflect.
And so when this altercation was going on, you stated earlier that you did call the police due to this altercation. When in the order of events here did you call the police?
When we was in the living room and we got into the living room and she really was in my space then where I could smell her breath.
Okay.
And that's when I called the police. When she leaned in and was in my,
and was
like she could have kissed me if she.
And was this the first or second time?
That was the end. That was the very
so
end.
The second time you were in the living room.
Yes.
Okay. All right, and so I guess out in the hallway, I played for you a portion of what's been marked as People's Proposed Exhibit 1. Did you recognize the voice on that recording?
That would be me.
Okay,
Yes.
that was your voice. And was it a fair and accurate representation of the call you made that day?
At the time of what I was feeling, yes.
At this time, Your Honor, the people would move for admission of People's Proposed Exhibit 1.
Any objection to motion to admit People's Proposed Exhibit 1?
Yes, Your Honor, I think that what they're trying to do is admit the 911 call, and that is going to contain hearsay other than her statements. So, and they don't have any exception, as I have not seen a business record exception.
Okay, response?
I would say my response would be that we could be admitted under either the excited utterance or the present sense impression exception to the hearsay rule, as this was done in the heat of the action.
I'm not talking about her statements, Judge. I'm talking about the operators. So unless they redact it in some sort of way.
Or I mean, she's already indicated for the record what she's testifying to.
Yes.
So,
and I do not believe there's actually any statements by the operator on the call.
all right. Well, so I'm gonna allow it to be, and I'm gonna grant your motion to admit People's Exhibit 1. However, not for substantive matter, not for offered for the truth in regards to anything that the dispatcher indicated, and she's already testified to what she's indicated, and she's available for cross-examination. So, but as far as what the dispatcher says, I think counsel's correct. I think that is hearsay. I don't think it's done as an excited utterance. However, it is a part of this conversation, so allow it to be played, but it's not used for any type of truth. It's just a part of the record.
I would ask then for a limiting instruction, Your Honor.
Thank you. So we're gonna play the dispatch call. There's a dispatcher on it, and whatever the dispatcher said is not offered for the truth because they're not here. They're not here to be cross-examined. This witness is here. You've heard her testify, and that's the extent of the limiting instruction in regards to whatever they play for you on People's Exhibit 1. Okay. All right, Mr. Brodowitz. With that understanding, People's Exhibit 1 is admitted. And you may play that for the jury. So it's admitted and you may publish by way of playing
For the
it.
jury, Your Honor.
Yes, you may.
All right.
I need some fucking help. Hey, I need some help. I feel threatened. I'm at 4719 Bristol. Hurry up and get here now. My name is Mary Carlisle, 4719 Bristol Street. Hello. Sorry, that mailbox is invalid.
So that was People's Exhibit 1, the audio tape?
Yes, sir.
Okay.
Right, so Ms. Carlisle, were you, when you called 911, were you able to complete that call?
She was telling me in my face, telling me that, and I hung up, that I need to get help for it.
Okay,
So eventually she stayed there for a minute. No, after I hung up is when she decided that you gonna get some help. And I said, I don't want your type of help. And she said, well, I think I got what I need. That's all we need to go wherever she went at the time.
okay. And then also, Ms. Carlisle, during this altercation, you kind of alluded to it, but were you able to document any of this altercation?
I took a lot of photos.
Okay.
A lot of photos. Probably more on my phone than what I got right there.
Okay. So I'm going to show you some pictures. They've been labeled People's Exhibits 2 through 19. Permission to approach, Your Honor?
You may.
All right, can you just please just go through and just take a look at them, to yourself and make sure you recognize them? You've had a chance to look through those photos?
Yes, I did.
And do you recognize those photographs?
Yes, I do.
And how do you recognize them?
Because I'm the one that took them.
Okay. And are those a fair and accurate representation of the photos you took that day?
Yes.
Okay. People would seek to admit people's proposed exhibits 2 through 19.
And those were taken on the date in question, which is
February 8th.
February 8th, 2023?
Yes, yeah.
All right. Any objection to the exhibits 2 through 19, which are photographs, move to admitted?
No objection, Your Honor.
Without objection, People's Exhibits 2 through 19 are admitted into evidence, and you may publish to the jury.
In just a minute, Your Honor, I want to ask Ms. Carlisle a question. So I would like to turn, if you could take the photographs, I would like to turn your attention to just a few of the photographs. If you could, for me, please look at what's been marked as People's Exhibit 4.
Okay.
Can you please describe to the jury what's going on in that picture?
Well, this is when they walked in the house and I was sitting, the first picture, I was sitting there. And I thought it was gonna do something else. So when they stopped to talk to me, I turned my back on it and took pictures.
Okay, and where, I know you said that, but where
That's what the door, they came in,
okay, so that would.
the side door to the kitchen.
Okay, so that's in the kitchen, right? Okay. So now if I can direct your attention to People's Exhibit 5, can you please tell the jury where that picture was taken in the house? in the
This was
location?
5 is up, this is upstairs. This is not
Okay.
in the row, but this is upstairs in the hall.
Okay. And what's happening in that picture?
My suitcase, she got my suitcase and I'm got one phone that in her hand is my suitcase. And she was in my room, so I'm trying to get my suitcase, well, stop her from taking my suitcase. So,
Okay.
yeah, but I had a picture in my hand right there, to take a picture.
All right, and now if I can direct you to People's Exhibit 7.
That's when I fell in the bathroom. And she was in the bathroom. She
So
did come in the bathroom.
So that's, I was gonna ask, where was that?
That's
the picture?
inside the bathroom.
Okay, and what's going on in that picture?
She in my face, I don't know. I just started taking pictures. She was yelling at me, but the bathroom is almost this small, but in the tub, but yeah, this is inside the bathroom upstairs.
All right, and now if I can direct your attention to People's Exhibit 8.
She stayed there, so I just let her go ahead and vent while she stood there.
So well, first of all, where is that picture taken?
Upstairs in the bathroom. She's outside. She's on the outside of the
Okay.
door in the bathroom. That's on the outside.
All right, and what's happening in that picture?
She yelling at me, cussing at me.
Okay. And then People's Exhibits 10 and 11, please.
That's after that. She downstairs yelling at
Okay,
me.
so where were those pictures taken? First of all? Sorry.
In the living room.
Okay, and what's going on in those pictures?
This is the kitchen. This is the kitchen right here. So
Okay.
this is the living room and the upstairs is right here by that dresser. So she yelling in my face. That's when she's saying the things that I do not like, that I did not like.
Okay. And then if I can have you flip to People's Exhibit 15.
I did sit down. And when I was trying to get up to leave again, that's how I end up in this corner. This is the corner. This is the upstairs. This is the kitchen right there. So yeah, I did go in the corner.
And
I
what
had-
room is that taken?
The living room. And I
Okay.
had my phone in my hand, my government phone and my other phone.
Okay, and then finally, if you can flip to People's Exhibit 18.
That's after she got tired of, that's when she got off of me in the kitchen floor. I guess she got hot or was leaving, I don't know. But that was in the kitchen on the floor. I was sitting on the floor at that time.
Okay, and this would be after you said that she would, or I should say, would this be after you said she had pushed you down by?
Yeah, this is, yes, this
Okay.
is, yes. I was playing cat and mouse in that whole house, in that house.
Okay.
Yeah, she took her coat off, because then my mom, she was taking her coat off, and my mom stopped her.
All right, and then finally, permission to approach your honor.
You may.
And permission to publish to the jury.
You may. So jury, you'll get a chance to see those all. If you can see them and multitask and listen to the testimony, that's fine. But during deliberations, you'll get the chance to take all the exhibits back with you also.
Okay. And now, Ms. Morrison, I'm going to play for you a portion of what's been marked as People's Proposed Exhibit 20. Permission to approach, Your Honor?
You may.
Oh, yeah.
Okay. All right. Did you see it? All right.
Yes.
So, can I ask, Ms. Morrison, do you recognize that recording I just showed you? No.
No,
Do you
Ms. Carlisle.
Oh, sorry, Ms. Carlisle, sorry.
Oh, yes.
Do you recognize that recording?
Yes, sir, I do.
Okay, and how do you recognize it?
Because I'm the one that recorded her off the phone, that I took pictures of.
Okay, and is that a fair and accurate representation of the video you took that day?
Yes, yes, sir.
All right, Your Honor, people would move for admission of People's Proposed Exhibit 20.
So People's Proposed Exhibit 20 is a video taken by the witness who laid foundation that she took it on May 8th, 2023, on the day in question. Is that correct?
Yes, Your Honor.
All right. Any objection to People's Proposed Exhibit being admitted into evidence?
No objection, but I do believe it's February 8th, not May.
Yes.
February 8th. Read my own writing.
All right. Now permission to publish to the jury, Your Honor, and play the.
So the People's Exhibit 20 is admitted into evidence, and you may publish to the jury.
You believe you be in the fucking ground. Trust that. And carry that shit to the bank. I will kill your fucking ass.
You gonna what? You gonna kill me?
Kill your ass.
You gonna kill
If
me?
I want to jump on you, I will kill you.
You put your hands on me.
All right. So Ms. Carlisle, can you please explain for the jury what was happening in that video?
That's when she had to be on, look, after she walked out, because she looked at my mom when she was like, why don't you don't want to get no help? And I was like, I don't want your kind of help. She was like, well, there she said it. That's all we need to do. And she walked out the door. And while she was walking out the door, I decided That was the grace of God, recorder. So when she said that, when she said it, I was like, so I put the camera up, like, you really said that, so.
Okay. And why, so then I guess the question would be why, and so finally, I guess, Ms. Carlisle, so given this whole altercation, was there ever a point where you felt physically threatened by Ms. Austin
Oh,
Morrison?
yeah, I did.
No further questions, Your Honor.
Cross-examination, Ms. Robinson.
Your Honor, briefly. All right, Ms. Carlisle, so you were living at 4719 Bristol since November of 2022, correct?
Yes.
Okay, and that is the house of Miss Trina Austin Morrison.
Her mother's house, yeah. Is it where she's living there? Yes.
Okay, but it's her primary residence.
Yes.
Okay. And she decided to allow you to rent a room there after you were evicted from your previous house.
No, she couldn't allow me to rent a room because she's been staying there for government assistance for 31 years. So she couldn't charge me.
Okay, so she was letting you stay there as like, I don't
And I
mean
bought
like
the
renting
groceries.
as like
Yeah,
renting, but
I was supposed to clean and buy the groceries.
now, you stated that previously that she just came over to come fight with you. There was no other reason for her coming over to the house.
Yeah, there wasn't because when she came to me. She didn't go do nothing else. She came directly to me.
Okay, and she was, this was her primary residence, but she was also staying for part of the week at another location while you were there all of the time, correct? Is that a yes, just for the record? Thank you.
Yes.
And so when she came over that day, there was no other reason, like no reason why she would just come to you very angry.
I don't know.
Okay.
I don't know. All I know is when she showed up, she approached me. They didn't come and go do nothing else. She approached me.
And you said they, so who was there with her?
My mother.
Okay. And they came and they asked you about getting some help, correct?
Mm-hmm.
And that was about getting some mental health help, correct?
Objection, Your Honor, relevance.
Wait, Ms. Carlisle, wait till I rule, okay? So response?
Your Honor, I mean, I think she opened the door. She's talking about how that they came over talking about getting help. I think I can delve into it.
I think the subject matter as to why they came over is subject to cross-examination. So I'm gonna allow the answer. You may answer the question if you know the answer to that question.
She didn't say that in the beginning. I don't know what she said that at the end when all this is over with. So I didn't know she was messing with my mother or hanging with my mother. I thought it was funny that her and my sister was outside. So I didn't know what that's why it baffled me. She was like, is that all I need? Like, why would you wanna? I'm gonna leave that for the other discussion, but she couldn't help me other than find me a place. So what up was it her help? Because I wasn't doing no drugs, I wasn't drinking, I wasn't having sex, I wasn't having company. I don't know what kind of help she was trying to get me. Because all that was going on in the house when I was there. So I wasn't entertaining it, all the drugs, or none of them, besides weed, I did. But so I don't know what kind of help she was talking about.
Okay, but you also just stated that you said that you didn't need their help, that you don't want their kind of help, right?
So you don't come and put your hands on me and then tell me to get some help.
That's not my question, though. My question is, they came and talked to you about getting some help, did they not?
No, she didn't.
Okay, so they didn't say that at all.
Not in the beginning, no, she didn't. In the beginning, she said, why don't you get some help? And I said, I don't want your kind of help. That was all that was it. We didn't talk about what kind of help she wanted me to get.
Well, then how do you know what kind of help it is?
Because prior to, she had said that she looked up to me the other day, me not having a place. And so I don't know. But I thought maybe if she was talking about the place, then she should go through the process of going to get me evicted through the courts the right way. So I didn't understand what kind of help she wanted me to get because I was doing my walk with God and she knew that.
Okay. Now, so she's just coming into this house that she also is staying at, and she's becoming aggressive with you. That's what you're saying, correct?
Correct.
Okay, and you just so happen to have your phone on you, right? Is that a yes?
Yes, yes,
Okay.
yes, I'm sorry.
I just had two phones, right? So you had
Yes,
two
I got
phones on
two
you.
phones.
All right, so you're walking around the house and you have your two phones and you're just taking pictures, right?
Yes, I do it all the time.
Oh, okay. So you just always walk around taking pictures of yourself?
Yes, I do.
Oh, okay.
And I just take pictures. That she says that's all you do is ever take pictures of yourself. Yes, I do. I'm proud of the way I look. So yes, I do take pictures a lot. Take a lot of pictures.
Now, I want to go into how you say that this encounter started. So originally, where in the house did you say that it started?
Where they met me is in the kitchen. I was sitting at the kitchen, the table when they pulled up.
Okay, so it started at the kitchen.
Yeah, it started at the kitchen.
Goes to the bathroom.
No, bathroom is upstairs. It goes to the living room. There's the kitchen, the door where they came in right there.
Mhm.
And I was in the kitchen sitting there. And then where they standing is the living room. We went to the living room. Eventually went upstairs to my area, my back where I'm at, the upstairs, my room and the bathroom upstairs. Came back downstairs to the living room, went back in the kitchen, came back to the living room.
Okay, and it's your testimony here today that she pushed you into the bathroom, correct?
Well, I said that I can't necessarily say she pushed me. I don't, because something made me fall in the bathroom, but I'm not going to say how she did it because.
Okay, you didn't willingly go into the bathroom, that's.
Oh, no, I didn't willingly go in the bathroom.
Okay, so then you never told the officer that you went to the bathroom to get away from the accused, correct? And crouched in the bathroom, you never said that?
I stayed in the bathroom to get away. No, I probably did tell her that because she was like, let me walk you through it. I said, you want me to act like a victim, but I had to say my bags was in the bathroom, yes. And she did somehow get me in the bathroom and I don't know how, because in the meantime, I was tussling and trying to take pictures and I had one phone in my hand. So I didn't just leap in there, but when my bag went in there, I went in there, I was there with my bag and sat on my bag.
Okay, but you told the officer that you went in there on your own.
I mean, if I wanted to get out, I could have, but I'm not gonna. I did. I did go in there on my own. I can honestly say that I was in there on my own accord.
Okay.
Because I could have got out.
So now it's your testimony that you went in there on your own and that you could leave.
No, because if I had did that, then we would have been fighting. So I stayed in there on my own free will because I was not free to go.
Okay, because previously you testified that Ms. Austin Morrison wouldn't let you leave.
She wouldn't. I mean, I could have got past. She blocking my doorway. I wasn't free to leave.
But you just said you could have left on your own accord. So which one is it?
If I would have fought her, yes, I could have left. I was not finna fight my way out. I was not finna put my hands because she was. If I would have pushed her out the way, I could have got out. Yes.
Okay.
I'm not finna fight over something so petty.
Okay. So first you stated that she wouldn't let you leave. Now you're stating that you could have left on your own accord.
Yeah, then I would have been put out the house. Yes, I could have left. And then once I walked out the house, then she could have locked the doors and locked me out the house. So I could have left on my own, but I was not getting put out at that time. So yeah, I could have left if I wanted to. I could have got out the house and left, but I took the bullying. Yes.
Now, then during all of this, while all of this is happening, you're still taking pictures. Okay.
Yes, ma'am.
Yes, I'm sorry. Yes,
You're
I was
all right.
taking pictures.
We just have the court reporter here that's recording, so just make sure you answer yes or no. All right, so then you're stating that one of these times you said that she wouldn't let you leave and then somehow ultimately got down to the kitchen, right?
Yeah, yes.
Okay,
yes.
so while you're trapped up in the bathroom, you somehow make it down to the kitchen, right? And then that's where.
My mother called her down.
Oh, okay.
My mother called her down.
Sure, and so in the kitchen, right, that's when you allege that Ms. Austin Morrison choked you. Okay.
Yes.
And at this time, you're still taking pictures of all this?
Yes.
Okay. And eventually they decide that they're going to leave the location, right? They
Yes.
leave, they walk out to their car
Yes.
and you're recording this. Okay. In the video that we just saw, you're recording that. And this is after she allegedly pushed you, correct?
Yes.
And allegedly choked
Yes.
you.
Yes. This is all after that.
Okay. And you stated that you felt threatened during this time,
Yes.
but then you ran out of the house.
No, I didn't run out the house.
Well, you were in the doorway of the house,
But
correct?
she was yelling, making threats. So I said I might as well record it because she was yelling as she was walking out. She was talking as she was walking out. She was talking, and I'm like, let me record her. And when she made that statement of threatening my life, yes, I recorded it.
Okay, so you went, while she was leaving, you went to your doorway and started recording her
Yes.
after she did all this.
Yes.
When
yes,
you
ma'am.
allegedly were scared and threatened.
First of all, I was threatened. Second of all, I feared my life because she had been trying to get me locked up. So yes, I did.
Okay, so
And
you feared your life so much that you just had to record this incident instead of
Yes.
going in the house and hiding, right?
She had a key to get in there. She had a key. The doors was wide open. My mother allowed it. So, and my sister was outside. So yes, I would say, yes, I did. I did. So I had to record it for my own. There's no cameras in the house, so I had to have my own cameras.
Now, you also, did you also tell the police that there was some damage to your wall or to the wall of the location?
Huh? I don't know.
That any sort of damage to a wall, that she pushed you up against a wall? Was there any sort of damage?
I don't know about her. I showed her where I was. No, oh, the floor. I said the only thing is the table floor. I said, but I didn't. No, I ain't never told her she damaged the wall.
Okay.
I never said that.
Now, Ms. Austin Morrison started letting you stay with her since November of 2022. And sometime during that time, things weren't going well between the two of you, correct?
Yeah, you can say that.
And so during this time, she's asked you to leave?
She did once.
Okay, and you didn't leave though?
Because no.
At any point in time, did you ever change the locks to the location of 479 or 4719 Bristol?
No, I didn't. What happened? No, the door, I couldn't get out the door, so I took the locks off the door. I did take the lock off the door when she would come in the middle of, she would come at night. I did. She would come there at night when she was supposed to be where she was at. So I did, and I stayed in the living room, yes.
Okay.
Because I couldn't open, you couldn't get out the front door. So it was ajar. So in case I needed to, I just left it, I left it free will. The house was open.
Okay, so the house was open, you took the locks off the door.
The front door, I took the lock off the front door.
Okay, you took the lock off the front door,
Yeah.
right? So the front door was never able to be locked.
You couldn't get in or out of it. It was hard to open it but it was hard to get it open.
So
Very hard.
you glued it shut or you took the locks off?
I
I'm
took the
confused.
lights off because it was a safety hazard. I couldn't get out the house. If there was a fire, I wouldn't have been able to get out the house.
Okay, so as you're feeling threatened by Miss Austin Morrison, you also have the locks taken off your front door, right?
At the time, this is before she even came. So at the time this happened, the locks came off after she did this after the locks came off.
Okay.
The locks was off this whole time.
And you never put the locks back on?
She wasn't threatening me at all at that time. No, I never put the locks back on. I just sat there with the door. I wasn't afraid of nothing coming in. But I wasn't going to jail either to fighting back. We both go to jail. I don't do that. So yes, I would have had, if it had been nighttime, I would have ran out the house if it was a fire or something. But yes, I took the locks off, but this is after. No, before she grabbed it. It was before that, because I used to put the refrigerator in the door.
Now, did you ever post something on your door directed to Ms. Austin Morrison that says, bitch, if you come in my room again,
Objection, Your
there
Honor.
will be problems?
This has not been entered into evidence at all. It's hearsay.
So you can ask the question. You can ask the question in regards to what if she has or had not.
I had it in my room. I answered that.
Okay.
Not on my door, in my room.
Okay, but you had, bitch, if you come in my room again, there will be problems. You better recognize who the fuck you're dealing with. So you
It
wrote
was,
this.
yes, in my room, and she found it, yes.
Okay.
So that's a yes.
But it
no.
wasn't to her, it was in my room. So she was in my room, apparently, had it been in my room. So yes, I left it there,
Okay, you
But-
wrote it and you left it in your room,
yes.
but it wasn't directed towards Miss Austin Morrison.
It was no, it was, she went in there and found it. It was my room. My room is supposed to be my room. I write notes, a lot of notes, love notes and everything.
Who you talking to?
Who do I talk to? Facebook, my ex, my neighbor.
Who's the alleged B word coming into your room then?
What you mean? It could have been anybody. It could have been the man that she had come, the pervert, the peeping Tom that be in the window, that's living in the shed right now. The guy that's over there too. It could be anybody. She would leave the door unlocked and told me to leave the door unlocked for him. So it could have been anybody.
Your Honor, at this time, I'd like to admit the note into evidence. I don't think that I have it marked. It's a little delicate, so I didn't know if we wanted to put a sticker on it or how to work it, but.
You can lay foundation of it through the witness. The witness.
Well, she already
indicated
testified
wrote
that
it.
she wrote it and
Okay.
she left it on her bed, so.
All right.
No, I didn't say I left it on my bed.
Well, you left it in the bedroom.
I left it in my bedroom.
Has opposing counsel got the opportunity to see it?
Yes, I've shown it to them
Yes.
previously.
All right, response to defense exhibit 1.
Again, the people would just argue that this alleged note is hearsay. We have no idea when it was written, or the witness has said that she's written it. We have no idea when it was written, who, if anyone, it was written to. It's an out-of-court statement being used to prove, I believe, from the defense, the intention of the victim, and therefore would go to the truth of the matter, whether she was actually feeling threatened or not.
I think it's being used to impeach the victim's statement, and so it's not being used for the truth. It's being used to impeach her. With that understanding, I'll allow it. So defense exhibit 1 is admitted. We probably should mark it.
Okay, I didn't know, just because it's so delicate, I didn't
Right.
want to.
I think foundation's been laid that she's indicated she wrote it.
Should I publish it first and then maybe give it to Miss Wendy to mark it afterwards?
Let's mark it first so
Mark
we
it
know.
first.
Yeah, so the record
Maybe
knows what.
approach. Yeah.
All right, so defense exhibit 1 is admitted into evidence and you may publish.
Thank you, Your Honor.
Defense A, okay. So defense exhibit A is admitted into evidence and you may publish to the jury.
I have no further questions, Your Honor.
Redirect.
Just one second.
Just the jury knows that that's admitted as impeachment, not anything substantive. So you can't read anything and say that happened, because we don't know if it happened or not. We just know that that is a document in which is being used to impeach the statement of the witness. Okay. All right. Thank you.
No further questions at this time.
All right, may this witness be excused from the people.
The people would actually ask that this witness be reserved for a possible rebuttal witness.
All right, with that understanding, is there any objection to her being held as a rebuttal witness, Ms. Robinson? All
No
right,
objection.
ma'am, I would have you step outside as you are still under oath, and we'll keep you until whether we need you for rebuttal or not, all right?
Okay.
All right, thank you. Do the people have any further proofs?
Yes, Your Honor. The people would call Officer Rachel Logston.
Okay. So, okay, Officer Loxton, I'm gonna have you come up here. Please state your full name and spell your first name and last name for the record.
Rachel Logston, RACHEL LOGSDON.
Please raise your right hand. You solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury.
I do.
All right, please have a seat. Project for recording purposes. Mr. Brodowitz, when you're ready.
May I ask you quickly what happened to the People's Exhibits 2 through 19? I saw that here.
There.
Still, they were just gonna get put away.
Good afternoon, Officer Logston.
Hi.
Officer Logston, how are you employed?
I work for the city of Lansing as a police officer,
And how long have you been in that position?
20 years.
All right, and were you working in that capacity on February 8th, 2023?
Yes,
And did there come a time on that date when you were dispatched to 4719 Bristol?
yes,
And is that location in the city of Lansing in Ingham County?
yes.
And why were you dispatched to that location?
We were called there for a possible fight or assault that had happened.
Okay, and when you arrived at that location, did you make contact with anyone?
Yes,
Who did you make contact with?
Mary Carlisle.
All right, and what was, when you arrived, how, from your recollection, how long between the dispatch and your arrival at the house, how long of a period of time was that?
It would have been just driving distance from wherever I was to the time I got there, so maybe 5 minutes, 10 minutes.
Okay, and when you arrived, what was Miss Carlisle's demeanor like?
She was pretty excited. She was talking loudly, talking really fast, had a lot of things to tell me, so.
Okay. At that point, what did Miss Carlisle tell you happened at that point?
Well, it evolved over the course of about 10, 15 minutes that I was there, but she ultimately advised me that she had been assaulted.
Okay, and did Miss Carlisle describe that assault?
Yes, she did.
And how did she describe that?
I'm gonna object hearsay.
I would say it's an excited utterance, Your Honor. The witness has, or excited utterance as the witness has testified that Miss Carlisle was excitable. She was speaking loudly, and it was only about 5 minutes after the altercation had ended.
Response?
Your Honor, I don't think it's excited utterance at this time. I think she's doing an investigation. She's already asked, what's been going on. The emergency has ended.
I think the demeanor of the declarant is what's at issue. If the declarant, who is the complaining victim, is still in an excited state, then it may be an excited utterance, but you're running out of time on the excited utterance. So
Yeah.
I'm going to sustain the I'm going to overrule the objection, allow the initial remarks to be let into the record. But as we get further away from an exciting event, we tend to be less and less of an excited utterance.
Okay. So then just how did Miss Carlisle describe the assault?
It wasn't immediately upon me getting there. She took me through the house over the course of the time of the call, up to the assault point.
Okay. So you said she took you through the house. What did you observe as you were walking through the house?
There were some things that had been knocked over. Looked like there had been a struggle in the living room. Things were misshaveled in the bedroom. So.
Okay. And as you made contact with Ms. Carlisle, did she ever show you any proof that this happened?
She had some video footage on her phone that she had recorded.
Okay. So at this time, Your Honor, I would ask permission to play People's Exhibit 20 for the witness.
So this has been previously admitted as People's Exhibit 20. If the officer has seen this before,
I can lay a foundation. with that.
because the jury's already seen it, so.
Yes. I believe I can lay a foundation with that, Your Honor. Let's do it. I can just do it that way. I don't think I need to publish it again, as you stated. This would look here. So officer, I just played for you People's Exhibit 20. Is that the video that you were shown by Ms. Carlisle?
Yes.
All right. And did Ms. Carlisle provide you any other proof that this happened on that day?
I watched a couple little videos of what had happened throughout the house, but there wasn't really much for me to see because the videos were kind of jumpy and moving around a lot. So I wasn't able to really get any documentation of that except for the final one that she sent me.
All right. Did Ms. Carlisle ever show you any photographs on that day?
I don't recall.
Okay. No further questions at this time, Your Honor.
Cross-examination, Ms. Robinson.
Okay, Officer Logston, you stated that you've been a police officer for how long, 20 years, correct?
Yes, ma'am.
Okay, it's been a long time. And then when you approached or went to the location, you came into contact with Mary Carlisle, correct?
Yes.
And you stated that her demeanor was excited, she was talking fast, said a lot of things. Did this appear normal to you?
No.
Okay, and in your 20 years of experience, how did that appear?
If somebody's claiming there was a fight or an assault, when I show up on scene, people are excited still.
Okay.
So it didn't prove out of the norm for me for what type of call I was responding to.
Okay. So she was acting excited, she moving around. In fact, she showed you around the whole house, correct?
Yes.
Okay. And at some point in time, she told you about how she was pushed into, or excuse me, she told you at some point that she was that she got out of her bedroom and then went into the bathroom and crouched down on the floor next to the toilet, correct?
Yes.
Okay. And that the accused came into the bathroom still screaming at her and in her face. Did she tell you that?
Yes.
Now, when you spoke to Ms. Carlisle, she said that she also, you asked her if she needed any medical assistance, correct?
Yes.
And she responded that she did not need any medical assistance.
Correct.
So she was not taken to the hospital.
Not when I was there.
Okay. And she didn't ask you to take her to the doctor, correct?
No.
Was there anybody else on the scene at the time, or was it just you and Ms. Carlisle?
I believe I was the only one there for that call.
Okay. Did you attempt to make any contact with Ms. Austin Morrison or Ms. Carlisle's mother?
No, I did not.
And are you aware of any previous incidents of where Ms. Carlisle has had the police called on her?
Yes.
Okay, and has that been from in surrounding that time period? Or close in time to?
It would been within a couple months of that call, yes.
Okay, and those have been calls where she's had the police called on her, correct? Not her calling the police.
Yes, where Miss Austin had called on Mary.
And have you responded out to the scene other times, or was that other officers?
I have.
Okay, so this incident in general, what number of time was that for you to be at that location?
I believe it was the second time I had been there.
Oh. Nothing further.
Thank you. Any redirect, Mr. Brodowitz?
Just briefly, Your Honor. Officer Loxton, you stated that this wasn't the first time you were called out to this residence.
Correct.
Do you recall what the nature of the other call was that you were called out there for?
I do.
And what was that?
Miss Austin Morrison had called us wanting assistance in getting Mary out of the home.
Okay, and do you recall why that was, or?
At the time of the call, it was because they were arguing, not getting along. That was the reason.
Was there, in that call, was there any indication of anything physical?
No.
No further questions, Your Honor.
Okay, may this witness be excused from the people?
Yes, Your Honor.
From the defense?
Yes, Your Honor.
All right, witness, thank you for your appearance. You're excused. Do the people have any further proofs today?
Nothing for the case in chief, but possibly on rebuttal, Your Honor.
All right. So do the people rest in their case in chief?
Yes, Your Honor.
All right, before we start defense proofs today, we're going to take a little break. We'll take a brief adjournment, go to the bathroom, get a drink of water, and then we'll come back and we'll follow up on the rest of the case. All right. So everybody rise for the jury. Just, yeah, you can take those with you or leave them there. It's up to you. Judge, leave them. Okay. All right, we'll make sure that door is shut. The people have moved to rest their case in chief. Does, out of the presence of the jury, does the defense have any motions?
Not at this time, Judge.
All right. Without any motions, does the defense, we'll take a 5-10 minute break. Does the defense plan to call any witnesses?
We do.
Okay. So let's take about 5-10 minutes and then we'll go back. We'll bring the jury in, the people have rested, and we'll proceed with the defense case. After the defense case, we'll take a small break, go through jury instructions, which I kind of have a feeling I know where we're going with this, but I'll have both counsel, and then we will also select the one juror to be released after jury instructions and after closing arguments. So that understanding, let's take 5 and then we'll come back.
Okay, I know it's hot in here, and I'm Miss Robinson. I mean, it's not the love in the world. I know you can talk over a fan.
Yes.
Do we think that your witness could talk over a fan?
Oh, I don't know.
Okay. May just have to wait until.
She's an older lady, so she's got that older lady voice.
Okay, I was just wanting to check with you before I turned it on, and I don't want the jury not to hear, obviously, or
Sure.
there to be any issues.
Understood.
Okay, thank you, Ms. Robinson.
She's like, "You want these pictures?" Carlisle to this meeting. And we'll go out and look at it.
All right, ma'am, if you come up here, right in front of me, ma'am. Right, this way, right in front of me, okay? Okay. All right, now it's right here. Please face me. Please state your name and spell your first name and your last name for the record.
Okay, it's Mary Carlisle, Mary F. Francis Carlisle.
Okay,
So it's Mary, Francis, Frances, Carlisle, Carlisle.
okay, please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right, ma'am. Go ahead and have a seat here in the witness chair and project for recording purposes. Ms. Robinson, when you're ready.
Good afternoon, Ms. Carlisle. How are you?
Thank you. I'm tired.
Sure. All right. Now, Ms. Carlisle, can you tell me how you know the alleged victim in this case, Miss Mary Carlisle? Share her name.
Oh, that's my daughter. She was born. July 1st, 1971.
And do you know Ms. Austin Morrison?
Yes, I know her.
Okay, and how do you know her?
I met her to my daughter Tina, which it's been about 21 years, and then on the 8th of February this year, I seen her again. We never communicate, never talk anything. It's just that when she called asking me for help, which was the 8th, that's the first time I talked to her at 21 years.
Okay. All right. So I do want to go back to the time of the incident, which was February 8th of 2023. Did you and Ms. Austin Morrison, were you guys together that day?
Yes, she called me probably about 8:30 and asked me, could I go and help her to get my daughter some help? And so I wanted to know what was going on. She related to me what she was dealing with her, and explained that she was sick, said she's sick and I need your help to go with me because I'm trying to get her help downtown and I need your help. And so I said, well, what's going on, Trina? And then she was telling me about she had called the cops and she was dancing naked in the window and a lot of bizarre things and stuff. But my daughter had this Carol, the one in the back, she had called me earlier and told me that Trina were gonna call me because she had told her to call mama. Mama's on someone that can help her, that she can maybe reason and talk to. So she asked me, would I go with Trina? And I said, yes, I will go with Trina. So which Trina picked me up about 9:30. She probably had called me about 8:30, somewhere like that. But when she got there, it was about 9:30. She picked me up.
Okay.
Then we wind up over to her house.
All right, I'm going to stop you right there. So she calls you at about 9:30 and then she picks you up and you end up going to, is it 4719 Bristol?
Yes, but before we got there, she took me downtown on Kalamazoo to the courthouse. And I said, why are we stopping here? You said you was taking me over to see my daughter. And so she said, well, I'm supposed to stop here. I need to go into the court and, stop here with the 15.
Yeah. Well, let's not get into that. I want to kind of go into more of what's going on, like when you get to the 4719 Bristol.
Okay.
Okay. So after that, you go to the location of 4719 Bristol. Tell me what happens there.
Okay. When we get there, we both get out the car. My daughter was part. She called me when she was there because they don't let me go in too many places by myself, especially when I'm going around my quarantine. And so I says, we got out the car and just as we got out, Trina introduced me to Joe. Joe, this guy that, I don't know if he stayed there or her friend, he be there all the time. And so while she was introducing me to Joe, Tina came out and threw the ladder, almost hit me in the head out on the porch. And so, I just looked at her, but Trina kept talking to Joe, and I was concerned about my daughter, because I had told her, I'm not going anywhere with you till I see how my daughter's doing and what's going on. I want to know if she was all right. And so I turned around and walked in the house. Tina walked in the door, and I walked in the house behind her. So when
And you walked in behind Tina, not Trina, correct?
Trina was still talking to Joe. I walked in the house
Okay.
behind Tina.
Okay.
And so.
And who is Tina? Tina is your daughter, Mary.
Yeah.
Okay,
I'm
just,
sorry, I
that's
called
okay. Yeah, and you call her Tina, why?
All right, let's stop.
Sorry.
The rebuttal witness is in the
Oh,
courtroom, and so you have to be out of the courtroom.
So, that was the question.
Not yet. All right, you may proceed.
So your daughter, Mary Carlisle, right? You call her Tina.
Right.
Okay, can you tell the court why you call her Tina?
Well, her name is Mary Fontina, and we always call her Tina, because so still a Mary F, but that's Mary Fontina, mine's Mary Francis, so we always start calling her Tina.
Okay, so when you're talking about Tina, you're talking about your daughter.
Right, Tina's my daughter.
Okay. So you said that you followed her into the house.
Right.
Okay, then what happened?
So I asked her, what's going on? How are you? What's going on with you? She said, Mama, don't come getting up in my business. And so I said, I just want to know how you doing, what's going on. She said, this is not none of your business. And so she proceeded to turn, and first she turned the music up real loud. Then, I was not looking, and then she turned it back off, and she started walking in. By then, Trina was coming in the other door, like we were standing by the window. And so I was following her in the living room to try to figure out, baby, what did you do and what's going on? Because when I first walked up, Trina said, that's my chandelier that she threw down in the yard. In the ladder, she said, all my stuff is here. So when I said, baby, why are you doing this? And I said, I didn't never teach you to be like this. I never taught you to do nothing to hurt anyone. Why are you doing this? Mama, I said, stay up out of my business. And so I says, I kind of I just was looking at her because she was patting her butt and throwing up her finger and licking out her tongue, because I think Trina had came in. I don't know if she was doing that to me or Trina, but Trina had came in the door by then. And so, and I said, why are you acting like that? And so she said, all I ask you to do is step out of my business. And so I'm like, Tina, come on now, don't be acting like that. So then Trina said, what she do, she need to be getting up out of my house. And then Tina said, what you need to do, B, she said, if you go back up in my room, I'm show you what I'm gonna do to you. And that's something you need to be cleaning up this nasty house. And so, I still didn't say nothing. And Trina, because I had really told Trina when we got there.
Okay, so I just want to stop to clarify you. So your daughter said that to Trina, correct?
Yeah.
Okay.
Yes.
Okay, so she says that, and is this on the top floor or the bottom floor when this is going on?
I never went on the top floor.
Okay, so you were on the bottom floor.
Bottom floor at all times. Maybe started upstairs, hiked away. I'll tell you about that in a little bit, but I never did leave the bottom floor.
Okay, and at this point, did you see anybody put their hands on anyone?
Nobody touched nobody at this point. She didn't. Tina was egging her on, but I had asked Trina not to say nothing to my daughter, because I said, when I'm going over here, you not say nothing. You're not gonna hit her. She said, I ain't never hit her. I ain't gonna hit her this time. And so I was okay with it, because I don't I didn't know whether I trust or not, but my other daughter was outside in the car, and she said, I'm not coming in. That because I don't want Tina to know I'm here. They don't get along. And so she stood out in the car. She had a brand new car. Nobody knows. Dark in the window. And she said, I'm driving this car because the only thing I'm ever gonna say anything to you is if she hit you, I'm gonna get in it. But other than that, I'm not gonna get involved, Mom. I don't want to be involved with nothing that goes on with, they have no problem with that.
Sure. Okay, so let's get back down to what was, going on the first floor. So after she said, that statement to Trina, what happened after that?
Okay, Trina said, when Trina said, you need to be up out of my house. And then when she told Trina that, if you go up in my, she called it the B word, if you go up in my room again, what she was gonna do to her. And so Trina passed me and went upstairs. Tina and I still was there, but Trina went upstairs. And all of a few minutes, my daughter took off upstairs right after her. And so I kind of went to the door to try to beg for Phyllis to come in. And then when I went out to go upstairs, when I started upstairs, I got about the fourth stair. There was a big suitcase at the top of the stairs, Trina on one side and Tina on the other. Looked like it was took a walk thing, but it looked like it was gonna fall on me. So I turned around and kind of like, headed back downstairs because I feel like if everybody gonna follow me, I know I'm gonna be out for a month. So I never did make it upstairs, but that's what they was at, about 2 minutes. And then Trina headed back downstairs. Tina came back down behind her. Throw something out, those and broke it. I don't know what it was, the base or something. And so then they went in the kitchen. They went to follow her in the kitchen. But meanwhile, Trina was whistling in my ear. She kept stopping and whistling in my ear. And so I kind of went and laughed. She just said, oh, if you just let me, if you just let me. I said, I'm tired of this. I said, you know what we came over here for. I came over here with you to see how she was doing, and you said you came for a reason. So that's what we're gonna do. And so I turned my back 2 minutes. I don't even feel no 2 minutes. When I turned around, 'cause I kept trying to get my daughter to come in because I wanted to show her that lockout was glued up. It was glued up with red tape and stuff.
Right, the lock off the door.
Right. And so when I looked around, that Tina was on the floor like a little baby ball looking on something other. And so the only time can I see Trina touch her back, had a hand on her back, and I'm like, what is going on? And so she said, I dropped my e-cigarette, and Tina grabbed it. I think they both addicted to the cigarette, but she dived down over it to keep Trina from getting it. She wanted, and they both wanted it. So then I looked at Trina, and all this time you've been good. And I said, and so Trina moved her hand off. She did have a hand on her back. And so she moved the hand off her back, because she know that she just said, oh, I don't want to disrespect you, but if I did, she just said, I'm just so angry, I'm just tired. I said, but you already know, I don't pay that. We don't fight. We don't fuss. I told Trina, I said, Trina, I don't fuss. Stop arguing with Tina. Every time I turn around, Tina arguing with her, I said, did I not tell you to shut up? Do not say nothing back to Tina. And so then she hushed for a few minutes, but like I said, they back in there arguing about the house, who paid for the house and whose house it is.
Yeah, but you never seen anybody throw any punches,
Nobody.
pushing anyone?
Nobody. She did not hit Tina. Tina did not hit her, not one lick. Damn one throw a lick.
Okay. And so after this was in the kitchen where she dropped her e-cigarette and was picking it up, and they were both on the ground, right? Trying to get the e-cigarette.
Trina was not on
Or Trina wasn't on the ground, I'm sorry.
Tina was on the floor, but she was covering something with, balled up over it. And I don't know if Trina was trying to move her to get the cigarette or not, but she had a hand on the back, but then she said, just let it go. And then that made my daughter really angry. She turned around and busted, she took her hand, hit the coffee table, knocked everything on the floor, and kicked the coffee table and stomped the legs off of it. And so I'm like, Tina, why are you doing this? We can't afford to pay for this house like this, pay for all the stuff. But my son had said that mama, with, you know, whatever she had for Tina, Trina will have to help her get it back, you know how she is. So I'm like, she say, I called the cops about 4 times. I said, just call the cops. Just call the cops. She said, I done called the cops about 4 times. They won't come over here. They don't want to come if Tina say something other. And so she said, I ain't called. So Tina said, well, I'll show you how that's done. I'll get them out here. So she, after she had knocked that stuff down, then she went on the couch, right in front of the window. There was no curtain, nothing to the window, the big bay window. By the door was open, one of those things. So the couch was only there. I sat in front of this couch, Trina stand down there, Tina sit back on the couch. Everywhere she go, she has 2 cameras, you know, 2 phone in her hand. And she said, y'all got these phones for a reason. And she's flying around, she's visiting around and sort of thing. So she got a video of everything, because she didn't drop it not one time. No more when she went to the floor, she's covered up, but sometimes she didn't have a camera. So, but anyway, she said, I'm tell you how this doing. She laid back on the couch and she said, let me show y'all something. She went screaming at the top of her voice. She did it for about two minutes. She had 2 cameras and stuff. So I told Trina, and then Trina said, oh, you make me so mad. I could kill you. I said, Trina, you don't say stuff like that around me with my daughter. She said, I didn't say I was want to kill her. I said I could kill her. She make me that mad and stuff. I said, but that is something that we don't say. And so then Trina started questioning her, asking her about, are you gonna get help? Are you going to go get some help? Then she said, first she didn't say nothing, then finally after she done did all the hollering and she's gonna show us how she get cops out there, what's going on, you know, then she said, I'll go get the help. So like I said, all this happened in about 30 minutes. Then we turn around and we walked outside and they, you know, because they're going on and they said a few words going outside, you know, I guess saying something to one another, and I just kept, you know, kept going. But like I said, all the incidents was in about 30 minutes. Nobody hit nobody.
Okay, so you never saw Ms. Austin Morrison lay a hand on your daughter that day?
No, like I said, the only thing she had her hand on her back when Tina fell to the floor to get the e-cigarette. She did have a hand on her then. That's the only time that I've seen her with that touch her.
Nothing further.
Cross-examination, Mr. Brodowitz.
Yes, Your Honor. Just briefly. Good afternoon, Ms. Carlisle.
Hi.
Right, so Ms. Carlisle, you stated in the direct examination there that you never made it upstairs.
No, I did not.
Okay, so you have no idea if somebody could have laid a hand on somebody or pushed somebody or done something upstairs. Okay. You also stated that after the incident went back downstairs and I believe into the kitchen, that you were trying to get your other daughter who was in the car to come into the house.
Yeah, Baker went to the door and I begged for her to.
So at this point, just for to orient things, you're facing out the door, your back is to the interior of the house.
Exactly.
And then you turn around and your daughter is on the ground curled up and Miss Austin Morrison has a hand on your daughter. But you have, and just to clarify, Miss Austin Morrison told you it was over an e-cigarette.
Right.
Did you ever see an e-cigarette?
She had one in her hand when she came.
Okay, but at that time, did you ever see one on the ground?
I didn't see the e-cigarette. Like I said, I only seen it when she had it in her hand.
And so you don't know, you truly don't know how your daughter ended up on the ground.
I don't know how she got there when I could see when I turned around, she was fetus were like balled up over something of covenant. And so I when I asked her what it was, she said it was the e-cigarette.
Okay, but that was Miss Austin Morrison who said it was an e-cigarette.
Right.
Okay. So you also stated that at some point during this, Miss Austin Morrison said that your daughter made her so mad that she could kill her.
She did say that.
Okay. And I guess just from, in your opinion, if somebody said that you made them so mad they could kill you, would that make you feel uneasy, make you feel threatened?
Improper opinion testimony.
Response?
Well.
No,
Wait, wait.
don't answer.
Response, Mr.
I can
Brodowitz?
move on, Your Honor.
All right. The objection sustained.
So again, so you also stated that your daughter always has 2 cameras.
She always had 2 cameras. Most of the time she had 1, but that day she had 2. And she explained she said, you see, I got 2 cameras. These cameras is for a reason. And she was turning on me and she was turning on, she just was turning around. She's good with the camera and stuff. And she just was taking pictures and turning around and stuff.
And did she ever say what that reason was?
She didn't say what the reason were. She just said it's for a reason.
And then, so you stated, I guess, at the end of your testimony that you never saw anybody hit anyone.
No, not one.
Okay. But then just to, I guess, circle back, fully, you never made it upstairs during this altercation.
No, I didn't.
And you don't truly know how your daughter ended up on the ground.
I don't know how she ended up there, but as I can say, like it's about about a minute when I turned my back, when I looked back, she was covered over something when nobody hit nobody. Then I just seen her covered over there. Trina's hand was on the back. Looked like she was kind of push her off of what it were. And
Okay.
when I asked her, she told me what it was.
Okay. No further questions, Your Honor.
Redirect, Ms. Robinson.
Just briefly. Ms. Carlisle, you said that you never went upstairs, but you could see up the stairs, correct? Okay. And you couldn't, when you looked up the stairs, you never saw Ms. Austin Morrison hit your daughter?
No, they wasn't hidden. There was a big old suitcase. And Trina was on one side, Tina was on the other side, and looked like they were doing the playing tug of war
Sure.
with it, but it looked like it was gonna fall on me. So I turned around, headed back down because I know if it fell on me, they both two go come tumbling down the stairs.
Sure. Okay. Nothing further.
Need this witness be excused, Ms. Robinson?
They may.
From the people?
Yes, Your Honor.
All right, witness, thank you for your appearance. You're excused. Any further proofs, Ms. Robinson?
Yes, Your Honor.
You may call your next witness.
The defense would call Ms. Austin Morrison to the stand.
All right, Ms. Austin Morrison, you come up and please state your name, your full name, and spell your full name for the record.
Trina Louise Austin Morrison, TRINA LOUISE AUSTIN MORRISON.
Okay, please raise your right hand. Do you solemnly swear or affirm to tell the truth, whole truth, and nothing but the truth under penalty of perjury?
I do.
Okay, please have a seat and please project for recording purposes. And Ms. Robinson, when you're ready.
Take a break. I just need 2 minutes. Okay, I'll just go on question. Check it with you in 2 minutes. Sure.
All right, so let's take just a 2-minute break.
Okay.
Okay. Just to mark these exhibits. your exhibits, Ms. Robinson,
Thank you.
and you may proceed.
All right, Ms. Austin Morrison, how are you doing today?
Could be doing better, but I'm alive, so I'm okay. I'm good.
Absolutely, absolutely. All right. So how do you know Ms. Mary Carlisle, the youngest one?
Honestly, I can't, we were trying to figure out when things were good, how we ever met, but she used to live with me about 20-something years ago. She was going through some stuff and she called me and I invited her to come live with me in East Lansing at that time. And it was shortly after my daughter had died, so I had a spare room, come stay here, get your stuff together. And she went on and went back to school and got her CO license and started doing very well for herself, got her own place.
Okay, and as far as around February 8th of 2023 with how were you and the younger Mary Carlisle, I guess, related? I wouldn't say like related, but like how was your relationship?
February 8th, I was more than ready for her to leave my house. Around the 18th or so, it was a Sunday in January, I heard my drapes open up and I turned around and she was half naked dancing in front of my bay window. And I asked her, what was she doing? And she said, dancing. And I said, you can't be doing that. And she asked me, why not? I said, because this is my house. You can't be doing that.
Okay, so I want to, I guess, go back a little bit before we get into any specific instances. But so when did she start living at the 4719 Bristol address?
November 28th. I don't stay at the time, I wasn't staying at my house Monday through Thursday. I do not have a car. I work out in West Lansing. My mom lives real close to my job. So Monday through Friday, I stayed at my mom's house because I could walk to work. And on Friday, when I got out of work, I'd go home on the weekends. On the 28th of November, she called me out the blue. Hadn't heard from her since my son graduated high school at the time because she used to work in school security. And my son is now 30 years, so that tells you how long ago he graduated high school. She called me crying, no questions asked. I said, Tina, the only thing I can do for you is give you a place to lay your head and to tell you about God. That's the only thing I can do for you. And she came by my mom's house. She picked up a key. She went to my house. Every weekend thereafter, I would go home. And then on the weekdays, I'd go up to my mom's house, but periodically, because I drive for a living for a company, periodically throughout the week in between clients, I would stop off at my house for whatever reason and see her, see how she's doing, you know, give me something to eat, whatever, relax, because I got time in between clients.
Sure. Okay. So she was basically, I mean, she wasn't like paying you to rent a room, but she was using one of the rooms in your mother's house, which was also sort of where you resided on the weekends.
Correct.
Okay.
Where I've been residing for the last 27 years.
All right. And so, did you ever start experiencing problems with Mary?
Yes, this was about the second, like I said, about the second or third week of January. It was a Sunday, and I remember specifically because I was up getting ready for church. And I was standing over my kitchen sink and I heard the curtains open. And when I turned around, I seen her dancing, and all I could see was her drawers and a little short, like not like a robe, but kind of like a little robe, but all I could see was butt. And at that time, I was like, what are you doing? And she said, I'm dancing. And I'm like, you can't be doing that in front of my window. And she said, why not? I said, because I said so. This is a residential area. If you don't like it, you can call the cops and get me out. I stated, well, okay, I'll do that. And I dialed 911. Well, they can't put me out either because I got a phone delivered here. Unbeknownst to me, she had ordered a phone to my address without my permission.
Sure. So I want to sort of go back to some specific instances. I'm going to show you some pictures. want you to take a look at those. Do you recognize those?
Yes, I do.
And can you tell me what those are?
One day in between one of my trips at work, I went to my home.
Well, just tell me what the pictures
Oh,
are first, and
the
then we'll
picture
go into the
is
details.
My toaster oven, my food processor, some other items, coats, some other items, an empty cat litter box, pictures in the cat litter box, and they're sitting outside in the snow.
Okay. And you took these pictures, correct?
Yes, I
And
did.
they're a fair and accurate representation of what you saw?
Nowhere near, but.
Sure,
it
well,
was
they'll
much worse
partly.
than- They're partially,
Okay,
very small part.
all right. At this time, the defense would move defense exhibits B and C into evidence.
Motion to admit defense exhibit B and C. Any objection?
Yes, Your Honor, the people would object as these images were not shared with the people prior to trial.
As
They
counsel,
were
have you
shared-
seen these images?
Only about 30 minutes ago was the first time I saw them. They were not shared with the people prior to trial. So the people had not had a proper opportunity to inspect the images and to review the evidence.
They were just given to me 30 minutes ago.
All right. Well, let's take a recess, and out of the presence of the jury, we'll discuss some of these exhibits. So all rise, and we'll excuse the jury. All right, you may be seated. So pursuant to People's Exhibits A and B, defense exhibits A and B.
Let's
we
B and
have
C.
B and C. We have photos of another time of another date concerning that are not, so these are not photos taken on the date in question, correct?
No, correct. They're events leading up prior to.
Okay, and so there are two photos of events leading to that date. And
There's other photos that also show damage from some other dates leading up to this
okay,
incident.
so that sounds like we're getting into character evidence of the victim.
That would be my other objection, Your Honor, is that these are character evidence not going to the victims.
These sounds like specific acts character
tendency to
evidence.
be-
It doesn't sound like reputation or opinion.
That doesn't apply to the victim. It only applies.
No, it applies to the victim self-defense.
This isn't a self-defense case.
Well,
We're saying she's lying.
It's starting to sound like a self-defense case. I mean, so we can look at the rule, and the rule is a pertinent trait under 404. And the indication is that the defendant acted the way she did in regards to things that the victim had previously done. And now we're getting into specific things the victim had previously done.
So I'm using these to show the extent of their relationship at the time and how this is going to show how she was acting. I mean, the victim has already gotten up here on the stand and said, like, she has no reason to know why my client would come in and be upset and all of these things, and wants to paint this picture that she's just doing this unprovoked, when no, it's not unprovoked. These incidents have been happening, and I have a right to rebut that.
You have a right to cross-examine her while she's on the stand. I would agree with that, but now you're bringing in extrinsic new evidence that is 30 minutes old, that has just been brought to the prosecutor's attention about events that happened previously. It seems like we're getting a little off track here in regards to.
And I'm not using them to show, like, I guess, like, to make a case against her. I'm using it to show the relationship, because she came in here and she's arguing that, and I didn't know that she was going to say this because it wasn't in the police report. None of this was disclosed to me prior to the trial. And so I'm getting this evidence that the victims come in here and saying, oh, she's doing this unprovoked. And now, no, there's a reason
But
why.
you ask the questions of the witness without putting in the photograph evidence.
But then it's not, it's still,
Because this sounds like specific acts. This sounds like you're getting into specific character acts of the victim when you were saying, I did this for these reasons. Not, but, and the rule's pretty
but
clear
she's
that
not,
comes in.
she's not saying that she did anything. She's going to testify that she never put a hand on her.
So you're just using this to impeach the victim's testimony.
Correct.
And the victim was on the stand and you cross-examined her.
I did
And so-
cross-examine her, but
so
I was
don't
not
know if
aware
this
of
is-
this evidence beforehand.
Well-
So if we want to call, I can call the victim back up and bring her up that way, but I wasn't made aware of this evidence before that.
Well, I know that's not your fault, but this seems like cross-examination evidence. It doesn't sound like direct evidence. And it just sounds like you're throwing dirt on the victim and now saying, this is the reason I did this. And then we have a notice problem. I mean, 30 minutes is not proper notice for photograph or exhibit evidence. So, Mr. Brodowitz, your response, that's my concern with this test, with these exhibits. A is a notice problem, which was your initial objection. And then B is it sounds like we're getting into throwing dirt on the victim in regards to character evidence under 404. That's usually can only be done by reputation opinion. It cannot be done by specific acts. And this sounds like we're getting into specific acts as to the relationship.
But I'm not using it to show a specific act. I'm using it to show her state of mind and what's been going on. Because she's saying that my client came in here unprovoked.
I don't know. You had the opportunity to cross-examine on
But
that.
I didn't have these,
But that's not my fault, and that's not the victim's
right, but now we're
fault.
denying her a fair opportunity when evidence has come to
I'm
light.
denying your untimeliness of the exhibit.
So then I'm gonna ask to call the victim back up to the stand then.
But to cross-examine the victims, you want to reopen the prosecutor's proofs?
Yes, so I can bring these in and question them.
All right. I understand your argument. Mr. Brodowitz, objection for the right. I'll hear your argument for the record.
No, yes, Your Honor, as I believe Your Honor has stated that, number one, there is a notice issue here. The prosecution was only made aware of this only about a half hour now, about 45 minutes ago. And on top of that, as Your Honor stated, it appears that we're getting into specific acts of character here, contrary to the rules of evidence and what can be admitted. I mean, I understand if the defense only got these just recently, but as you stated, that's not an issue. It could have been brought up on, even without the photographs, these incidences could have been brought up on cross-examination and were not.
Right. So the ruling of the court is that the photograph evidence is not allowed. So that's exhibits 1
Can I
through.
go into the incidents?
Go ahead and make your record.
Okay,
Okay.
and I would also state too that under 6.201A, since the prosecution has not made demands for me to share any evidence with them, I'm not even required to disclose them.
I understand that. Anything else you want to make on your record?
No, Your Honor.
All right. So I'm going to deny the motions to admit any of the photographs as to character evidence and improper timeliness. The people have, so you may proceed. Okay, you may proceed with the witness questioning her. I think you can question her on whether there's a reputation or opinion concerning why she did what she did in regards to impeaching the witness, although it seems like that should have been done when the witness is on the stand, but I'll allow some. All right, all rise to the jury, which we are. All right, we're back on the record. You may be seated. And counsel, you may continue with your direct examination.
Okay, so I want to go back to January 22nd. You went back to the location of 4719 Bristol, is that correct?
That's correct.
Okay, what did you notice?
When I got there, I seen boxes and bags and I didn't know what it was at the time because my son, the room she sleeps in, the whole upstairs used to be where I raised my son. And he still had some boxes and stuff because he just in the last 2 years brought a house, but they weren't open. They were still folded boxes. And I see boxes outside. It's snow and it's wet outside. And I see boxes on boxes that are thrown out, not neatly, outside, along with all of my kitchen appliances. But at the time, I don't see my kitchen appliances. So I go into my house and I say, what the H, but I use the word, what the H is going on? Why is my son's stuff? That's not your son's stuff. That's your stuff. You're being evicted, B. And I said to her, what the H is wrong with you? And then she says to me, what the H did you do to my brother Aaron? And I said, what are you talking about? And she hands me a Bible with the words Moses and Aaron highlighted. It's all right here. You better read the. And I just walked out the house and I started bawling. And Joe was out there. He's a friend that scraps metal. He rents my shed from me in order to break stuff down. And I'm so shaken. I call the cops. And I'm trying to call my son. He's like my centerpiece, my center point, my north arrow, I was so distraught, and now I'm realizing everything that's outside is every possession I have in my kitchen of 27 years, everything except the kitchen table, the stove, the refrigerator. The chairs are out there. The bottom drawer in the stove is out there. Every dish. This is a 4-bedroom house. My food processors, one used, one new. All my pots and pans, everything in the refrigerator, everything in every cabinet is outside, either broken, sitting in the snow, had been out there for some time because it wasn't snowing at that point, but everything was covered in snow. And litter had been poured on. I have a cat. The litter box had been emptied and poured on everything. So this stuff was irreplaceable, or it wasn't a matter of I couldn't clean it up and use it again.
And this was back in January,
This
correct?
was in January. I had already started the eviction process.
Okay.
When me and her mother pulled up to the house on February the 8th, she finally had the notice. It's been in the mailbox. All of this.
Okay, well, hold on. So
okay.
I just want to make it a little bit more clear. So we're going to go kind of in segments, right?
Okay.
So all of that stuff happened back in January.
Yes.
And then is that when you decided you wanted to start the eviction process?
No, I started it before that.
Okay, so there were some incidents before that as well.
Yes, I had called the cops on her at least but on that occasion, when the cops showed up.
Well, I don't want to get too much into those details, right?
Okay.
But so there's been other incidences,
yeah.
This being the main one before that happened, right?
Yes.
Okay. And so that stuff was damaged. Okay.
Mm-hmm.
And so let's go now to February 8th of 2023. Tell me about that day.
Somewhere on the 7th, I believe, 7th or the 6th, I suffer from mental illness. And so I recognize it personally, in my opinion, when I see it. So I hadn't talked to her family since well over 20 years. And so I remembered how she contacted me on the 28th. And so from the number that she called me through Messenger, I called that number back. And I didn't get no one, so I texted them and asked them, do they know how to get a hold of Tina's family? I got a response back. This was somewhere in between the 6th and the 8th. I got a response back, and I got a hold to her sister Carol, and her brother Ricky, and
did they eventually put you in touch with her mother?
they eventually put me in touch with her mother.
Okay, so then did you reach out to her mother?
Yes, I did. And I asked her if I could have Tina's date of birth, and she asked me why. I said, because I wanted to petition the court for her to have a psych eval.
Going to object at this point, Your Honor, to any evidence of any sort of psychological evaluation as to relevance and also as to character evidence, improper character evidence.
Response?
That's fine. We don't have to go into that.
All right, good. So the objection sustained. We've had some testimony in that regard already, so you may proceed.
So you then got in contact with her mother, correct? Okay. And then at some point, did you guys decide to go to the house?
Yes, her mother said she wanted to see for herself what was going on. So I went and picked her mother up, and we went back to my house.
Okay. And when you guys got to the house, what happened?
When we got to the house, I introduced her to Joe. I was talking to her sister, Phyllis, that was in the car that she didn't know was there, and I was talking to Joe. Her mother went in. I was still outside. When I entered the home, immediately Tina started patting her butt, using her phone, talking vulgar. She even made a statement, "You allowed that man to come in and touch my pee." What the heck? Where did this come from? She made the statement about if you go up. Now, I seen that note on the table. That note was on the table. I seen it. I grabbed it, brought it up, put it in my pocket. She then made the same statement out of her mouth verbally. So honestly,
I'm going to stop you just a little bit right there, Ms. Austin Morrison. Are you talking about this note that's been
Yes,
previously
ma'am.
marked as Defense
Yes,
Exhibit
ma'am.
A? Okay, so you saw this.
I saw that.
Okay. And then you balled it up and put it in your pocket?
Yes, ma'am.
Okay. Then what happened after that?
Honestly, I just wanted Tina out of my house. I'm waiting on the eviction process. It's taking a while, of course. It's going to take months. But I remember when I asked her mother for their date of birth and would she come help. I remember her mother making a statement to me that if you take me over there, Trina, she's going to try to jump on me and we can get her out your house quick. Okay. I then go up after Tina makes that statement to me that basically verbatim to what the note says. I go upstairs because if she hit me, I can get her out my house, at least on assault. They could arrest her for assault. So I go upstairs hoping, honestly, to provoke her to hit me or do what she says she's going to do in the letter. I go upstairs, I go into the room, I grab the suitcases. She flies up after me.
And when you say she, you're talking about Mary, also
Yes.
known as Tina, correct?
Yes, ma'am.
Okay.
She comes up after me. I am on my way out the bedroom with the 2 suitcases that she came into the home with. And she started, "That's my stuff, that's my stuff." And she's pulling and she's pulling. And as she's pulling on the other end, she falls back into the bathroom. And the suitcases, one of them somehow ends up under her and she sits on it. Her mom's at the middle part of the stairs. I tell her, "Go back downstairs before you fall and something comes flying downstairs." She goes back downstairs. I leave the bathroom. I come downstairs. Tina runs after us downstairs. She goes in the living room. She kicks my table. She swipes her hand over everything on the table, my little knickknacks, kicks the table, and I go into the kitchen. I'm not sure what Miss Carlisle was doing at the moment, other than I'm hearing her say, "Tina, stop all this foolishness, stop all this foolishness." I sleep with my e-cigarette in my hand. I walk around with it in my hand right now, and if I wasn't afraid that I'd accidentally hit it in court right now, it would be in my hand right now. It's like a pacifier. I drop it. She shoves me and hovers over the e-cigarette. I'm reaching around her to try to get, and I'm yelling, Tina, give me my e-cigarette, give my e-cigarette, give my e-cigarette, and she's steadily hovering over it, and she won't give it to me. I finally let up, like, forget about it.
Okay, so you stated that she pushed you. How exactly did she push you?
She just kind of, shoved me. out the
Okay,
way.
and just so the record's clear, it looks like you're doing that with your right arm?
Yes.
Okay, so
yes.
she used her right arm to
It
bump
definitely
into you.
was her right arm because I got shoved to the right towards the seat.
Okay, so she shoved you with your right arm, and did that cause you to drop your e-cigarette?
No, I had already dropped it.
Okay.
I'm in the kitchen and she comes downstairs, she does all the stuff and knocks everything over in the living room. And I go in the kitchen and I dropped it. She didn't cause me to drop it. I dropped it. She immediately seen it and went after it immediately.
Now, so then you're just trying to get your e-cigarette?
I'm reaching around her. Tina, give me my, and that's when Miss Carlisle turned around. What's going on? And I'm reaching around her, trying to get my e-cigarette. And I'm saying, give me my e-cigarette, Tina, give me my e-cigarette, give me my e-cigarette. And she was not gonna give it to me. And she's just steadily doing all this.
Okay. Okay, and so after that, did you eventually get your e-cigarette?
No, I never got it.
Okay, so you
I
never
just-
got it, you gave up.
Yeah, I gave up.
Okay, and at this point in time, what did you do after you gave up trying to get your e-cigarette back?
Somehow or another, we end back up in the living room. And the whole purpose was to ask her to go seek some help. I was told the papers I wanted to file, I could not file without asking her to seek some help. And I have to have done it within a 72-hour period prior to filing those papers.
Sure. Okay, so you went over there to seek some help and then, or asked her if she wanted to seek some help, and then you
Correct.
did that.
Well,
Then you left?
We asked about 6-7 times, and between the two of us, and when she made the statement, I don't need your kind of D help. And I said, that's all we needed. And me and her walked out. As we were walking out, I'm hollering and screaming. I'm pissed. I'm upset. I'm hollering and screaming. She's hollering and screaming. But me and her mom just walked out because as soon as she said, I don't need your kind of D help, I said, I verbally, that's all we needed. And we walked right out the house.
And so as you're walking out of the house,
My back is turned. I'm not even knowing she's taking this. I didn't know that until you told me that the prosecutor had new evidence, and that was last week. And I didn't even find out what that evidence was until yesterday.
Sure. Okay. And so you saw that video, right? Okay. And so tell me what was going on then.
Well, in the video, I don't remember saying I'll kill you, but obviously I did. But what I actually heard was, if I would have hit you, I would have killed you. That's what I heard in the video. That's what I heard when you played it for me out there. But it kind of got, to me, that part didn't get played, or it got volumed out.
Did you ever intend to kill her that day?
No.
Okay.
I wouldn't be in court today.
And so during the whole incident that's going on between the time that you arrived at the house and when you left the house, did you ever lay your hands on Ms. Mary, otherwise known as Tina Carlisle?
What Ms. Carlisle said that my hand was on her back. I don't remember my hand being on her back, but I do remember the inside of my arm because I'm reaching around her while she's like this, like she's like this. And she's holding my e-cigarette and I'm reaching around her trying to get it. But
was that intentional or unintentional?
The touching of her?
Yes.
Unintentional.
Okay. Any other intentional touching, contact, anything like that?
No.
Okay.
None.
Nothing further, Your Honor.
Cross-examination, Mr. Brodowitz.
Your Honor. Good afternoon.
Good afternoon.
All right, so you started your testimony saying that you
came back one day and that allegedly stuff of yours was outside of the house.
When I finally did go in the house, every item in my kitchen except the stove, refrigerator, and the table was gone and was sitting outside.
But did you ever see Miss Carlisle move any of this stuff?
No, but she made the statement and said you're being evicted, B.
Okay, but you never saw her move any of it?
No, I didn't.
Okay, and you stated that you were not home for about 4 days a week during that.
No, I stated that I didn't sleep there 4 days a week. I went there periodically, probably once every day.
Okay. You also stated that in your testimony there that you tried to intentionally provoke Miss Carlisle to.
Yes, I went upstairs to intentionally provoke her.
But she never struck you at all.
No,
Okay,
but the question is not whether or not she struck me.
I understand. You also stated that in your testimony that when you and Miss Carlisle were I guess fighting over the suitcase, that Miss Carlisle fell backwards then into the bathroom, and then you told her mother to head back downstairs.
May not been in that order. By the time we were in the hall before, may not been in that order, but yes, that's what I stated.
But you're
yes.
not sure what order that happened, if at all.
No, but I did tell her mother to go back downstairs before something fell and hit her.
All right, you also said. One second. All right. And so we heard prior testimony from Miss Carlisle's mother that you did at one point say that I guess she made you so mad that you could kill her.
Yes, I said that.
Okay. But I believe you said on your direct examination that you never said that you were going to kill her.
When her mother said that to me, we were in the kitchen. This was when we first got there. Now, that is different from the tape that you played, which was when we were leaving. And her mother told me immediately, because we were still at the kitchen door, Trina, watch what you're saying, because she's taping everything. And I said, I didn't say I was gonna kill her. I said I could kill her.
No further questions, Your Honor.
Any redirect?
No, Your Honor.
May this witness be excused from the defense?
Yes.
From the people?
Yes, Your Honor.
All right, witness, you are excused. Thank you for your appearance today. Does the defense have any further proofs?
No, Your Honor, the defense rests.
All right. Any rebuttal from the prosecution?
No rebuttal from the prosecution, Your Honor.
All right, do the people rest?
Yes, the people rest, Your Honor.
All right, we're going to take about 5-10 minutes to look at jury instructions to make sure that we have the jury instructions all set. And then we'll come back on the record. We will allow jury instructions and closing arguments. And then one of you gets to be dismissed for the day after all of that. So that's good or bad. I don't know what to tell you. I don't know what to tell you. But we're all rise for the jury, and takes about 10 minutes, I think. Yep, follow Mr. Neves. All right, so anything to come to the court's attention before we meet in chambers and look at instructions, and we can put anything else on the record. Mr. Broadwoods.
Nothing from the people.
Ms. Robinson?
No, Your Honor.
All right, so let's take 10. Let's go and look at instructions, and then we'll allow for. Do you need any minutes for closing arguments? Do you need just a prep for closing arguments?
Just a few, Your Honor.
Okay. Once we get done with instructions, we'll do about 5 minutes and then.
Yeah, that should be fine.
docket 23-00442. Had the opportunity to go over jury instructions with both the prosecutor and the defense. And now we're ready for closing argument. Mr. Brodowitz, when you're ready, you may proceed.
Thank you, Your Honor. And thank you, ladies, for sitting and bearing with us all day and sitting through this. So if you remember back to when I gave my opening statement, I said that there are different types of crimes, and that the crime you're going to hear about today was an intimate crime. It was a personal crime. It was a crime that happened to someone's home. And that's what we heard evidence of here today. And so when you go back and you deliberate, ultimately, your decision is going to have to rest on not only the exhibits presented, but also the credibility of the witnesses that you heard today. And so let's talk about a little bit about those witnesses. You heard from the prosecution, you heard from the victim, in this case, Ms. Carlisle. You heard about how Ms. Austin Morrison came home. She was angry, she was yelling, she was cursing at the victim, Ms. Carlisle. And then Ms. Carlisle told you how she attempted to leave the situation, how she moved around the house trying to get away from this situation, trying to get away from the language and the verbal assault that was being done by the defendant, Miss Austin Morrison. We saw the photographs that the defendant took during this, which shows and corroborates her story that she moved around the house. We heard the 911 call where she states that she feels threatened by the defendant. We saw the video where the defendant clearly states that she was going to kill, or that she says in some form that she was going to kill the victim. And then let's compare that to also the testimony that you heard from Officer Logsdon. Officer Logsdon said that when she came over, when she arrived after the call, that Miss Carlisle was upset, she was talking fast, she was emotional, and that Miss Carlisle, again, much as she did here today for you folks, took her throughout the house, described the incident, told her what had happened. And now compare that to the story we heard from the defense witnesses. Yes, both of their stories, I will admit, were similar, but there were also some issues with their stories. For instance, we heard from the victim's mother in this case, who said that the defendant at one point, when the victim was sitting on the couch, told the defendant in some way, shape, or form that she would kill. She said she would kill her, but the defendant said she never said that. She never recalled that in her testimony.
Objection, Judge. That's misstatement of what happened.
I think the jury will be the decider of what they remember and what they don't remember concerning arguments are not evidence. So only the testimony that you heard is evidence. Okay. So with that understanding, the objection's overruled.
We also heard testimony from Miss Carlisle's mother that she was on the stairs and she could see up the stairs, and that during that point in time, she could see Miss Carlisle and Miss Morrison tussling over a suitcase, but that she went back downstairs. Well, then we hear from testimony from the defendant that they were tussling over the suitcase, and Miss Morrison, at least according to her story, fell into the bathroom. And then she told the defendant's mother to head back downstairs. We also heard from the defendant's mother that we also heard from the victim that when the altercation proceeded back into the kitchen, that she was shoved down by the back of the neck and the shoulders by the defendant onto the floor. We heard from the victim's mother that during this point in time, her back was turned. She had no idea what happened. But we also heard from the defendant that this was supposedly over an e-cigarette. I find that hard to believe. And again, when we look at the defendant's testimony, the defendant was saying that essentially the defendant's testimony was that she kept trying to avoid this situation. But we can see from the photographs that were admitted that the victim took during this, that that's not the case. That on multiple occasions, the defendant was in Miss Carlisle's face, was screaming at her, was standing over her, causing Ms. Carlisle to feel threatened. We also heard during the testimony of the officer that there were multiple calls out to this house. But we also heard that even though some of those calls were due to, were made, I guess, on Ms. Carlisle, you could say, that at least the one that the officer responded to was not assaultive in any way. Ms. Carlisle is the victim here. Ms. Carlisle is the victim of an assault. She was followed around this house by the defendant, who was screaming, yelling at her at various points, threatening her, and on a couple of occasions, shoved her. That's the definition of assault and battery. So the people would ask you to find the defendant guilty as charged.
Thank you, counsel. Closing argument, Ms. Robinson.
Unfortunately, saying something doesn't make it so, right? So saying that Ms. Carlisle is the victim in this case doesn't just make it so, right? We've heard the evidence in this case, and I think it's pretty clear that nobody can really determine what Ms. Carlisle's story is because it's changed so much. At first, she said she could get out of the bathroom, then she said she couldn't get out of the bathroom, and that she was shoved, and then she told the officer something completely different, that she went into the bathroom herself and crouched down, right? You also heard some testimony from Ms. Carlisle, her mother, so Mary Tina's mother, who came to the house, and she saw nothing happen. There was no assault that occurred. Just because she's saying that she's the victim in this case doesn't mean that she's the victim, right? You got to have some proof in the pudding. Where is that proof? It hasn't been presented today, right? They want you to believe everything that Ms. Mary or Tina got up here and told you. But are we really going to believe someone that's changed their story multiple times, that is trashing Ms. Austin Morrison's stuff prior to this incident, who's had the police called on her before for an incident, who's ran around the house butt naked before? Are we really going to believe her over two people who came here and testified and said that nothing happened? Why would the victim's own mother come and testify in this case and lie? She's not going to lie about something. She told the same story that Ms. Austin Morrison told you guys. And that story is the truth. That's what happened. Nothing happened this day. You've heard some stuff about how Ms. Austin Morrison said, oh, I want to kill you, that sort of thing. And we talked in jury selection a little bit of, we've all said stuff that we didn't mean, right? We've all said stuff that we didn't mean. Did she intend to go in there and kill her that day? Absolutely not. Because as you see, she's leaving the house, and that's clear from the video, she's leaving the house with the victim's mother. And they're going to the car and they're leaving. They're done. They don't want anything more to do. She's mad. She's upset. Yes, Miss Austin Morrison is mad and she's upset. And frankly, she probably has right to be, since all of her stuff is trashed and she's dealing with someone who's saying all these things about her that just aren't true. She gets to her own home and she finds a note. Bitch, if you come in my room again, there will be problems. You better recognize who the fuck you dealing with. I think if anybody found that note in their own house, they might get a little upset. They might get mad. But that doesn't mean she assaulted anyone that day. And you've heard evidence that she didn't assault anyone that day. The people want you to look at these photos that were taken by Ms. Mary or Tina Carlisle that show, oh, clearly an assault must have happened. She must have been all up in her face. Well, you also heard that she's walking around kind of like she's an Instagram star around the apartment or around the house, just taking pictures of what's going on 24/7. During all of this, after Ms. Austin Morrison is upset, she finds this note there. So what does she do? She takes the opportunity to be a selfie star and take pictures as she's going around the apartment, right? Yet during this time, while she has the opportunity to cheese for the camera, and you'll see in some of those pictures, she's even kind of like smiling, that she felt threatened. She felt threatened by Ms. Austin Morrison, even though she had the opportunity to do all this, right? She was so threatened that she followed them out of the house as she was leaving and stopped in the door. She was so threatened. She was so threatened that she left the door unlocked. Didn't put locks back on the house, right? You've also heard testimony from Ms. Carlisle, the alleged victim's mother in this case, about how she was acting and how she was acting prior to. And that was kind of concerning. Her behavior was a little concerning. And how she wanted to go over there with Ms. Austin Morrison and try to figure out what was going on with her daughter. And that's why she was there. They wanted to go over there and see if they could try and get her some help. But instead, they walk into this. Now, you also heard that they went upstairs and there was pulling over a suitcase. There's no intention there to ever hit anyone, to ever cause offensive contact. Because remember, look at the other evidence of what happened. You heard Miss Austin Morrison and she told you guys about how prior to this incident, there was times where Tina or Mary Carlisle trashed her stuff, took out some possessions that she had that were pictures from her son, put all of that outside in the snow, just threw all of her stuff out and told her, bitch, you're the one being evicted, not me, right? So all of her stuff is already gone. She doesn't want Mary or Tina to do that to any more of her stuff. So if she sees Ms. Carlisle with the suitcase, of course, what's she gonna do? She's gonna grab it because that's her stuff. But there was no assaultive contact. You've never seen any sort of, I guess, there's no injuries that have been reported. She said that she was choked. You have never seen her go to the hospital. In fact, she refused medical attention. She didn't go to the hospital. None of that happened. And over the span of 30 minutes, only for a brief period, did Ms. Carlisle not see what was going on. The victim's mother did not see what was going on, only for that brief period. And she said absolutely nothing happened, right? The only thing that happened upstairs is that they were tussling over a suitcase, okay? Not at any time did Ms. Austin Morrison put her hands around the alleged victim's neck. Did she knock her against a wall? Did she shove her into a bathroom? None of that ever happened, right? The alleged victim is going through some sort of crisis. She's upset that perhaps Miss Austin Morrison doesn't want her to stay with there anymore. She doesn't want her to stay there anymore because her property was being damaged. She's upset that she's going to have to leave. She's upset that she's being confronted by both her and her mother. She doesn't like it. And so what does she do? She makes all of this up. And you heard from her mother herself that, oh, I know a way of how to get the police here quick. I'll call them. And that's when she called the police. So the state is right about how you should look at credibility in this case and look at different things of how they acted, how they said, what what their demeanor was, that sort of thing. And Miss Carlisle got up here and she's a bit of a mess. And her testimony was all over the place. Ms. Austin Morrison got up here and she told you exactly what happened. That story didn't differ from the own alleged victim's mother who came up here and testified. Was she a little passionate? Maybe did she get a little heated? Sure. But she's been also going through this incident where she has somebody that she's graciously offered and given a room to who's kind of destroying her stuff all of the time, is still in the house, all of that kind of stuff. And so she's upset about that. She has a right to be upset about that. That doesn't mean she assaulted her. So look at all the evidence and look exactly what has happened in this case. Because I think it's going to show you that Ms. Austin Morrison didn't do anything. She didn't lay a hand on Ms. Carlisle. She dropped her e-cigarette, maybe unintentionally hit her on the back while trying to pick it up. Never choked her, never shoved her against a wall. And I think it's clear because the alleged victim's own statements are so inconsistent that we don't even know what her story is. And at the end of the day, you have, as a jury, have to go back and you have to decide whether there is enough evidence to convict Ms. Austin Morrison of assault and battery. But you would have to find her guilty beyond a reasonable doubt. And everybody's reasonable doubt might be a little different. So your reasonable doubt might be that the alleged victim had very inconsistent statements. Your reasonable doubt might be the fact that, oh, look, Ms. Carlisle and Ms. Austin Morrison testified to the same thing. Your reasonable doubt might be the victim or alleged victim's demeanor in this case. There's a lot of different things here that just don't add up and don't equal assault and battery. And despite what the state says and what they say happened, it's not actually true because the proof's in the pudding and it's just not here, right? So I want you to look exactly at everything that's been brought forward. Look at those inconsistencies. Look at the credibility. And I think you'll come to an ultimate decision in this case of not guilty. Now, the state's going to have an opportunity to get back up here and make another argument for you. And I expect that they're probably going to argue a lot of the same things of what they said in their first argument. But remember the note that Ms. Austin Morrison found when she entered. Remember the stuff that was trashed from hers. Remember that the victim's own mother testified that nothing happened, that Ms. Austin Morrison testified that nothing happened. Remember those things, because those are the things that the state doesn't want you to focus on. And I think when you look at all of the evidence in this case, I think you'll ultimately come to the conclusion that Ms. Austin Morrison is not guilty. Thank you.
Rebuttal, people.
Yes, Your Honor. So, yes, the defense is correct in one thing, and I will reiterate one thing, and that's to, as they said, look at the evidence. Now, the defense liked to hammer on the point that, you know, Ms. Carlisle was trashing Ms. Morrison's stuff, but there's no evidence of that. We have testimony. There's no other
objection, Judge? Absolutely not. Can we?
What's your objection?
I can't say it in front of the jury.
Right, so you can approach. All right, so we've had a brief conversation at the bench. Mr. Brodowitz, you may proceed.
Okay. Like I was saying, folks, just look at the evidence that has been presented here. We've heard three different, albeit a couple of them slightly, three versions of the events. We've heard from the victim, we've heard from the defendant, and we've heard from the victim's mother. All those stories have inconsistencies. All of them are different from the other. But with the victim's story, the victim took photographs. The victim took video. The victim called 911. The victim can corroborate her story with those photographs. So I would ask you to look at the evidence. I would ask you to look at the testimony of all three witnesses. And then look, and even, sorry, all four witnesses, including the officer. And then I would ask you to look at the physical evidence. And I would ask you to judge their credibility based on the evidence that's been presented here today. And when you do that, I think you'll find that the evidence that was presented by the people backs up the victim's story, that she was followed around the house, she was assaulted by the defendant, and that she was battered by the defendant. But even if you don't find that she was battered, the defense liked to hammer on that there was no injury. She didn't go to the hospital. There was no medical attention. Injury is not required in order for assault and battery to occur. There need not be an injury. There need be no physical injury. All you need to find is that there was a harmful or offensive touching. It was against the victim's will, which we have here. Ms. Carlisle testified that she was shoved down by the defendant. So with that, I would ask you to find the defendant guilty as charged.
Thank you. So the arguments are closed, and I will read the following instructions, and then I'll read the following instructions. I will strike one of the jurors after my instructions, and then I'll swear in my court officer, and we'll start the deliberation process. But these are your final jury instructions. You should get a copy of this. We'll bring a copy of this to you. Okay. All right, members of the jury, the evidence and arguments in this case are finished. I will now instruct you on the law as it applies to this case. Remember that you've taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the jurors who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of this case are. That is your job and no one else's. I'll remind this jury that the closing arguments are not evidence, okay? They're only theories to help you understand the evidence. And if anything was said during closing arguments that doesn't comport with the instructions that I give you, you're to disregard it, okay? You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I've already given you some instructions about the law. You must take all my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum it up, it is your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way, decide the case. A person accused of crime is presumed to be innocent. This means that you must start with the presumption the defendant is innocent. The presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to his or her innocence or to do anything. If you find that the prosecutor has not proved every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable, after a careful and considered examination of the facts and circumstances of this case. When you discuss the evidence and decide on your verdict, you may only consider the evidence that has been properly admitted in the case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I've told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. The fact that the defendant is charged with a crime and is on trial is not evidence. The lawyer's statements and arguments are not evidence. They're only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witness's answers. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies in this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you decide the case, you must pay no attention to that opinion. You are the only judges of the fact. You are the only judges of the facts, and you should decide this case from the evidence. At times during trial, I've excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during the trial. As I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important their testimony is. You do not have to accept or reject everything a witness said. You're free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have based on race, gender, or national origin of a witness. There's no fixed set rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might distract the witness? Does the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyers? Does the witness' age or maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or influence that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you must accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about something but told the truth about others, you may simply accept the part you think is true and ignore the rest. When you go to the jury room, you may take along a written copy of the jury instructions with you along with your notes. You should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a business-like way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communication equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you'll discuss the case among yourselves, but ultimately each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It is your duty as jurors to talk to each other, make every reasonable effort to reach agreement, express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own and you must vote honestly and in good conscience. If you have a question about jury instructions before you begin deliberations or questions about the instructions that arise during deliberations, you may submit them in writing in a sealed envelope to the bailiff. The prosecution has introduced evidence of a statement that it claims the defendant made. Before you may consider such an out-of-court statement against the defendant, you must first find that the defendant actually made the statement as given to you. If you find the defendant did make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about the how and when the statement was made and about all other evidence in the case. You may consider the statement in deciding the facts of the case. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So take that same example. If you see a person come in from outside wearing a raincoat, covered with small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence by itself, or a combination of circumstantial evidence and direct evidence can be used to prove the elements of the crime. In other words, you should consider all evidence that you believe. You have heard evidence that before the trial, a witness may have made a statement that may be inconsistent with their testimony here in court. You may consider an inconsistent statement made before the trial to help you decide how believable the witness's testimony was when testifying here in court. If the earlier statement was made under oath, then you may also consider the earlier statement as evidence of the truth of whatever the witness said in the earlier statement when determining the facts of this case. You should not decide the case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You've heard testimony from a witness who's a police officer. That testimony is to be judged by the same standards you use to evaluate the testimony of any other witness. To prove the charges the prosecutor must prove each of the following elements beyond a reasonable doubt. The defendant is charged with assault or assault and battery. That Trina Austin Morrison committed a battery on Mary Carlisle, in parentheses Tina, because at times she was called Tina through the proceeding. A battery is a forceful, violent, or offensive touching, or the person or something closely connected with the person of another. The touching must have been intended by the defendant, that is, not accidental, and it must have been against Mary Carlisle's or Tina's will. It does not matter whether the touching caused an injury. That's one way to commit assault and battery, is the actual battery aspect. Then there's an assault, and you can you can convict just on the assault. There's an or there, okay? So it's assault or assault and battery. That the defendant intended to either commit a battery upon Mary Carlisle, Tina, or to make Mary Carlisle, Tina, reasonably fear an immediate battery. That would go to the assaultive nature. The prosecutor must also prove beyond a reasonable doubt that the crime occurred on or about February 8, 2023, at the location of 4719 Bristol in the city of Lansing, Ingham County. There's been evidence that Mary Carlisle may have committed violent acts in the past and that defendant knew about these acts. You may consider this evidence when you decide whether the defendant honestly and reasonably feared for her safety. When you go to the jury room, you'll be provided with a written copy of the final jury instructions. You should first choose a foreperson, then the foreperson should see to it that your discussions are carried on in a business-like way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communications equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately, each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. Possible penalty should not influence your decision. If you find the defendant guilty, it is the duty of the judge to fix the penalty within the limits provided by the law. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to the bailiff or court officer. It is not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury to deliberate, you may take your notes and full instructions. If you want to look at any or all of the reference documents or exhibits that have been admitted, just ask for them. We'll probably send you back there with the exhibits that have already been admitted, and then we'll give you a copy of the instructions. When you go to the jury room, you'll be given a written copy of the instructions you should have just heard. As you discuss the case, you should think about all my instructions as the law you are to follow. You may return a verdict of the alleged crime of assault and/or assault and battery, or not guilty. I prepared a verdict form listing the possible verdicts, and that'll be given to you by the court officer. All right, so those are the final instructions. The following is either the best day or the worst day. One of you gets to get picked off. And we've randomly selected one juror. That's juror number 5. Juror number 5, you are done with today's proceeding. I will tell you the joke. You either buy a lottery ticket or you don't, depending on you, but you are excused from your participation in deliberation today. Thank you for your appearance. I will swear in the court officer in order to, he will be responsible for your taking care. It is I'll say it is the longest oath I've ever seen, okay? So just so you know, we don't fool around here. So raise your right hand, Mr. Neves. Do you solemnly swear that you will, to the utmost of your ability, keep the person sworn as jurors on this trial from separating from each other, that you will not suffer any communication to be made to them or any of them orally or otherwise, that you will not communicate with them or any of them orally or otherwise, except by the order of this court or to ask them if they have agreed on their verdict until they shall be discharged, and that you will not, before the render of verdict, communicate to any person the state of the deliberations of the verdict they have agreed upon, so help you God. Thank you. All right, so the jury is now dismissed to deliberate. When you get there, pick a four-person, and you can go right into deliberations, all right? So start deliberating. There was a time that I didn't have to say that, but I do believe it start deliberating, and then we will give you the instructions and any exhibits you request, all right? All right, thank you. All right, so we're back on the record in docket 23-00442. The jury is out at 5:28. And based on some conversations we had at discussions during closing argument, Ms. Robinson, did you want to make a record?
Your Honor, I think there was going to be some argument from the prosecutor that there was not any evidence that showed some of the incidents that we're talking about when that wasn't the case. I think he did correct himself on the record, so I'm not going to make a motion at this time. But I was just concerned with that.
All right, thank you. And that's my understanding. There did seem to be I would say a creeping up to the line and then a retracting from the line. And I think that it was settled. So without a motion, are there anything to come to the court's attention, Mr. Brodowitz?
Nothing from the people, Your Honor.
Ms. Robinson?
No, Your Honor, thank you.
All right, we're in recess, deliberations until a jury verdict. So stand by.
Okay, thank you.
Thank you. may rise and foreperson, you may announce everybody else can sit down except for the foreperson. Yeah, you're the one, okay? And now you can announce the verdict.
We do find the defendant not guilty.
All right, thank you. I'll get Mr. Neves, I'll have you take the verdict. Mr. Brodowitz, would you like the jury polled?
No, Your Honor.
All right, thank you. Jury, thank you for your service today. I know it's been a long day for you, I know that. And I apologize for that, but thank you for your service. This system doesn't work without you, all right? So I won't spend any more time saying things. I know you want to get home, you want to eat and things of that nature. So thank you again.
Thank you.
Jury's dismissed. I'll rise for the jury. All right, we can be seated. We'll shut the door. So we're on the record in docket 23-00442. And the jury verdict is read as not guilty. So Ms. Austin, the case is dismissed against you, and there's been a not guilty verdict. You're free to leave the Zoom. You're free to leave the courtroom. Thank you for your appearance today, okay? Anything else for the record on docket 23-00442, Mr. Brodowitz?
Nothing from the people, Your
Ms.
Honor.
Robinson?
No, Your Honor, thank you.
All right, ma'am, you're all set. Good luck to you.
Right, yes.
Here's the file, and then there's the jury verdict. You have the witness sheet.
Was this your first time like observing court and stuff? Yeah. It's not like the TV shows, is it?
No.
No, rarely do we. This is pretty good. We got it done in a day.